Recording in progress.
Judge, I was just informed by corrections that Mr. Antoine Jones refused to come to court. However, we do have Mr. Christopher Romero Martinez here.
Okay, Mr. Jones, is this his first day being brought in? Yes, he was. Yes.
Mr. Jones was brought in on August 2nd, Judge. So this would be his first day.
Okay, I'm gonna reset for tomorrow. Okay. This is Mr. Romero Martinez Christopher.
Yes, Judge.
Okay, Mr. Romero Martinez, do you need the services of an interpreter?
No.
Okay, you've been charged with battery, first degree misdemeanor under section 784.03. Any probable cause argument?
Judge, we don't have probable cause arguments at this time. We do have arguments for the bond in this case, however. We would be asking for either a release on his own recognizance or pretrial services with an alternative bond. Mr. Romero Martinez has no priors that I see. He's not a flight risk and he's not a risk to the community if he were to be released.
Okay, so I'm gonna find probable cause, state release conditions, argument.
Your Honor, the state would be asking for standard bond here without pretrial services. The victim in this case was found with blood on his nose. This is also a co-defendant case, and this is a battery corroborated by an independent witness. So standard bond with no pretrial services.
Judge, if I may make arguments in response, that the purpose of the bond is to prevent Mr. Romero Martinez from absconding from court or from posing a risk to the community. Although the allegations in the arrest form may include injuries and co-defendants, it does not increase his risk to the community. It does not increase his risk of flight.
And you asked for pretrial services?
Yes, Judge.
The alternate standard bond?
Yes, Judge.
Okay, that's what I'll order.
Thank you, Judge.
So pretrial services, the alternative $1,000 bond. And I'm gonna read stay away order. Mr. Romero Martinez, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry any a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Leslie Martinez, who is the victim, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Does the victim and the defendant live together?
Judge, they do not live together.
I thought. Any particular reason that they would need to, defendant needs to go and get anything from the victim's residence?
No, Judge.
Okay, thank you. That concludes the order.
Judge, I have Mr. Fred Wilbarger here with me, and he does not need the assistance of an interpreter.
Okay. Mr. Wilbarger, You've been charged with first degree misdemeanor, battery, domestic violence under section 784.03 1A1. Any probable cause argument?
Judge, we don't have probable cause arguments at this time. However, we would have an argument for the bond in this case. Mr. Wilbarger has no priors that the defense is aware of. He has no priors. He is not from here. However, he does have family here. And we would be asking for either release on his own recognizance in this case or a standard bond, Judge.
Is Mr. Wilbarger from Florida?
Judge, he's from California.
Okay, so he doesn't live here.
He does not live here permanently. However, he does have family here, and he told me that he might be able to stay with them.
State.
Your Honor, the defense said that there were no priors. There's no way to confirm or deny that at this point because we do not have national priors on a California resident. I'm sorry, Your Honor. Thank you. So in which case, Your Honor, we would be asking for reluctantly the standard bond amount here. I have no grounds to ask for an elevated bond amount since I don't have any context on the defendant's priors, but so in which case, Your Honor, we'd be asking for the standard bond amount.
How long has he been in Florida? Or Miami?
Judge, he doesn't know the specific time. He said a few days.
He's been in Miami for a few days. Okay.
Yes, Judge.
All right.
Just if I may, in just a few days of being in this city, he has committed a crime.
Understood. So you're asking for standard bond, correct?
No, Your Honor. In light of these facts, we'd be asking for an elevated bond of 2,000.
Okay.
Judge,
Yes.
if I may, we would still be asking for the standard bond in this case, just because he's been here for a few days and may have been arrested for something does not indicate any further risk to the community or a flight risk. Although the fact he's from California might pose a flight risk, there's nothing else in this case that indicates that. There's nothing else to ask for more than a standard bond.
Well, I mean, the flight risk is certainly something to go above the standard bond. He's not a member of this community and he committed a crime the first few days being in Miami. And I don't have information about his priors.
And Judge, the defense would just like to repeat that this is an allegation of a crime.
I understand. Yes, but I understand that argument. When I speak, I'm not saying he committed the crime. I'm not finding him guilty. I'm just speaking colloquially, that he's been alleged to have committed a crime, but on the A form, there's probable cause for it. So I have to assess that in determining what to do. Again, I understand it's a fight with family. Where else would he stay in Miami when he's a resident of California if I were to consider a different bond?
Judge, he does have a cousin that lives down here. He informed me that he'd be able to stay with.
Okay. All right. I'll go with the standard bond. No pretrial services or release. Obviously, no pretrial services because he's from California. But I'll standard bond of $1,000. Stay away order. Mr. Wilbarger, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons: Trimex King, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Is there anything at his stepfather's
Yes,
home
Judge.
he needs to retrieve?
Yes, Judge. He would need to retrieve some items.
Okay, the defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve his or her personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. That concludes the order. Thank you.
What was the bond amount, Judge?
Standard $1,000 on straight bond.
Thank you.
Cruz Sardina, Yoander.
Judge, apologize. We had the wrong individual in the room. Mr. Sardina's coming now. Judge, Mr. Sardina will need the assistance of the Spanish interpreter.
Interpreter present. Thank you, counsel.
Okay, Miss Cruz Sardina. Or Mr., excuse me. You've been charged with a first-degree misdemeanor battery domestic violence.
Se le acusa de agresión corporal de índole violencia intrafamiliar.
Any probable cause argument?
Señores, ¿algún argumento respecto al fundamento legal?
Judge, we have no probable cause arguments at this time, but we would have an argument for the bond in this case.
No tenemos ningún argumento respecto a la base legal, pero sí quisiéramos argumentar respecto a la fianza.
Probable cause found. Any argument from the state on release conditions?
¿Algún argumento por parte de la Fiscalía en cuanto a su liberación?
Your Honor, the state would just be asking for the standard bond amount here. There is defendant after battering a victim, a woman, then followed the victim to the police station as she was attempting to report this crime. And for those reasons, Your Honor, we would ask simply for the standard bond amount without without.
Judge,
Your Honor, the interpreter couldn't fully hear, but may I relay what I have?
I can repeat. Madam Interpreter, would you like me to repeat?
Thank you, State. Yes, thank you.
So in this case, the defendant, after battering the victim, followed the victim to the police station as she went to report, and then subsequently turned himself in at another police station. So there's no reason for him to follow the victim to the police station other than to what seemingly seems to be stalking. Now, the state would be asking because of that, a standard bond amount with no pretrial services, despite any indication of priors here.
Su señoría, lo que queremos argumentar es que el informe de arresto refleja que el acusado, después de haber atacado a la víctima, la siguió hasta la estación de policía a la vez que ella se acercaba a la comisaría para hacer la denuncia. Y nosotros viendo esa actitud de seguirla, eso ya constituye otro delito que es acecho, acoso. Y solicitamos, por tanto, que no le otorguen la fianza gratuita PTS, sino monto de fianza.
Judge, if I may.
Yeah.
Judge, it's the defense's position that while the allegations in this case do take place between a married couple, there's no stalking charge currently. This is a first-degree misdemeanor DV battery. Mr. Sardina poses no risk to the public based off of the state's arguments. And furthermore, there's no priors in Miami-Dade that the defense is aware of at this time. And it would be our position that he does not pose a flight risk. He's lived here for over 10 years at this point, and this is his community. We'd be asking for pretrial services with the alternative bond of $1,000, Judge.
Is he employed?
¿Tiene trabajo, señor?
Yes, Judge.
Where is he employed?
¿Dónde trabaja el joven?
Trabajo aquí en Miami, los edificios, instalando las ventanas, de ventilación de cristales, todo eso. Eso es lo que hago.
Something about windows. Joven, tiene que hablar más claro y más fuerte porque no le escucho, por favor.
Trabajo aquí en Miami, en los edificios, lo que es instalación de todas las ventanas de esos edificios de la playa.
I work in all these buildings around Miami Beach installing windows. Your Honor, the interpreter has to supplement the record in my prior rendition. I forgot to say, el caballero, después de haber visto que la señora fue a denunciar, él fue y se entregó a otro departamento de policía. Your Honor, may the interpreter relay what the defense just said?
Yes.
Thank you. Por más que estamos hablando de una pareja de casados, esto sigue siendo un delito menor, acto de violencia intrafamiliar, agresión corporal. El señor no presenta riesgo para nuestra comunidad, no tiene antecedentes penales, ni tampoco presenta peligro de fuga porque tiene aquí a la familia, lleva más de 10 años viviendo acá y solicitamos el monto estándar de fianza.
Okay. I'm gonna pretrial services with the alternate of $1,000 bond.
Se le otorga la fianza gratuita pre-trial, monto alterno de fianza $1,000.
I'm gonna read a stay away order.
Le voy a leer, joven, la orden de alejamiento.
Mr. Cruz Sardina, you are ordered not to engage in any criminal activity.
Señor Sardina, se le prohíbe tener actividades ilícitas.
Do not use or possess any any illegal drugs.
No puede estar en tenencia ni consumir sustancias ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede utilizar, comprar ni estar en tenencia de arma blanca, arma de fuego ni municiones. Your Honor, Counsel Quirantes is trying to get your attention. Mr. Quirantes.
He's next.
Okay. Sorry for meddling, Your Honor.
No worries.
Thank you very much.
Purchase, possess, ammo and firearm. That's where we
Okay,
left
do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede utilizar, portar, encontrarse en tenencia de arma blanca, arma de fuego ni municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court.
Cualquier arma de fuego, municiones o permiso para portar arma debe ser entregado al departamento de policía más cercano, trayendo el recibo ante nuestro tribunal.
The defendant is prohibited from having any direct or indirect contact with the following person here and after the victim, Evelyn Gomez.
El acusado tiene prohibido contacto directo o indirecto con la persona de la víctima, Evelyn Gómez,
Including contact in person, writing, by telephone, through social media, or any other electronic means.
incluyendo contacto por teléfono, escrito, en persona, a través de las redes sociales y también a través de terceros
Or through third persons.
o a través de terceros.
Defendant must stay at least 500 feet away from the victim's home, place of employment, and their school at all times.
Tiene que conservar el acusado la distancia mínima de 500 pies a favor de la víctima, su hogar, su lugar de estudio y o empleo en todo momento.
I understand the protected party lives with the defendant.
Tengo entendido que la persona protegida por esta orden judicial convive con usted, el acusado.
Yes, Judge, and he would need an opportunity to get his belongings.
Así es, su señoría, y él necesitaría oportunidad de obtener sus pertenencias.
The defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer.
El acusado podrá regresar en una sola ocasión dentro del plazo de 48 horas de la emisión de esta orden judicial con escolta policíaca.
To retrieve his personal clothing, personal health items, medication,
Será con propósitos de recoger su ropa personal, artículos de cuidado de la salud, medicamentos,
personal and business related paperwork, and work tools.
documentación personal y laboral, incluyendo herramientas laborales.
Going to the home or remaining at the home without the police will subject the defendant to arrest.
Acudir a esta casa o permanecer ahí le deja sujeto al acusado a nuevo arresto.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
la policía tendrá que solicitarle al acusado toda llave de acceso o control para abrir garaje, para luego podérselos entregar a la víctima.
That concludes the order.
Concluimos con la orden judicial.
Okay, Mr. Gatto, Alexander Gatto is coming next.
¿El señor Gato necesita intérprete?
No, ma'am.
Gracias, señor.
Good morning, Your Honor. Albert Quirantes here on behalf of Mr. Gatos. Thank you for calling.
Of course, and I apologize, hadn't seen it earlier. The defendant obviously is not represented by the public defender's office, so Mr. Quirantes is his counsel.
Your Honor, I would advise the court that we have reviewed the probable cause affidavit and we would stipulate to the probable cause, and we'd be requesting a standard bond in this case. Mr. Gatto is a lifelong resident of Miami-Dade County, 30 years. He voluntarily surrendered with his wife, the victim actually, who's here, to request that the court issue a modified stay-away order to allow nonviolent contact. He's been, like I said, the victim wasn't requesting that the officer arrest him, but there's this policy of arresting in these cases. So we'd be asking that he be issued the standard bond and hear from the victim, who is Maritza Gatto, who is here, and her screen name is Yaibet.
Okay, can we let her speak?
¿Puede activar su micrófono, señora Yaibet, en la parte inferior izquierda de la pantalla, por favor?
Hello. Hello. Hi, good morning.
Good morning, how are you?
I'm doing good, thank you.
Okay, go ahead and let me know what you want me to consider.
May I inquire, Your Honor?
Yes,
Ms. Yaibet, are you afraid of your husband, Mr. Gatto?
No, I'm not.
let's put her under oath. She's going to testify. Madam Clerk?
Ma'am, yes,
Are
sir.
you under oath?
Ma'am, could you raise your right hand for me, please?
I am.
Do you swear or affirm the testimony you're about to give today will be the truth, the whole truth, and nothing but the truth?
That's correct.
Thank you. You may put your hand down.
Ms. Gatto, are you in fear of your husband, Mr. Gatto, in any way?
No, I'm not.
Okay, did you appear with him at the police station and he voluntarily surrendered?
Yes, I did.
Do you realize that if the court issues a modified stay-away order, then he will be able to come back home when he's released from court, and he will be in the home with you? You realize?
Yes.
You have
Yes.
you have no objection to that?
No, no, I have not.
Are you requesting that the court issue a modified stay-away order to
Yes, I do.
allow non-violent contact only?
Yes,
And you realize that if there's any problem, then you will call the police and that there will be a violation of that order,
agreed.
if there was a violent act. Okay, thank you, Your Honor. No further questions.
State, do you have any questions? Would you like to ask?
Yes, Your Honor. Ms. Gatto, good morning.
Good morning.
I just heard your testimony. I just want to make sure that no one is pressuring you here. I just want to make
No.
sure that you know have you ever spoken to Mr. Quirantes before?
No.
Okay, Mr. Quirantes, you were a lawyer?
Yes. Hello?
I'm sorry. State, may I ask a question to clarify?
Sure.
Okay.
I gave you permission, that's the state.
I'm interrupting the state because I'm not sure she understands, okay? Ms. Gatto,
Yes, sir.
Ms. Gatto, did I call you yesterday to advise you that the detective in this case was asking for my client to surrender in this case?
Yes, I'm sorry. I understood that if we have like if we hire you
Right.
before this case, that's what I understood. I'm sorry. I
Yeah, I
apologize.
just wanted to clarify because I'm not sure that
Yes.
you. And did you and him comply and go right to the detective after we spoke?
Yes, we did.
Did I advise you that you had the right to appear at this hearing today and request whether you wanted or not that a stay-away order be issued in this case?
That is correct.
And is it your complete voluntary decision to testify as you're testifying here today?
Yes,
And nobody's threatened you or coerced you or intimidated you or asked you to say anything here today?
no,
Okay, just wanted to clarify for the state and for the court. Thank you, Your Honor.
thank you.
Okay, does your son still live at home?
Yes, he does.
Okay, is he going to be at home, the next few months?
Yes,
Okay, he's 19 years old?
yes, he is.
Okay. State, any other argument on, release conditions?
No, Your Honor, there'd be no objection to defense's request of standard bond on both.
Okay, standard bond on both counts. Did you ask for pretrial services or
No, just standard bond, Your Honor.
standard bond? Okay, standard bond,
2 misdemeanors.
$1,000 each, is that correct?
No, Your Honor, it would be 1,000 on the.
And 150, okay.
Battery and the 150, right?
Sorry, misspoke.
Thank you, Your Honor. I hope you appreciate my streamlining of the procedure. I know you have a lot of cases.
No worries, I just didn't see the messages. Yes, Mr. Carantes, if you could say it again, your name?
Albert Quirantes, Quirantes, on behalf of Alexandra Gatto.
Okay, any issue with the modified stay away order?
No, Your Honor.
Okay, I'm gonna read the modified stay away order, but I want to be clear. I'm doing so because the victim is requesting it, but Mr. Gatto, obviously, no more. I know there are allegations at this point, but please refrain from any incendiary topics, as such as the one that's alleged in the A form.
Agreed.
Okay?
Yes, sir.
Do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file receipt with the court.
I do have a firearm, sir.
Yes, yeah, okay,
I-
so go ahead.
I'm saying I do have one. Do I have to surrender that?
Yes.
Okay.
The defendant is prohibited from having any direct or indirect contact with the following persons. Hold on a second. Actually, I have to read the modified version, correct? Okay, so the defendant is allowed to have contact with MYG, the initials, his spouse, with the victim, but is prohibited from being physically threatening or violent towards the victim in any manner whatsoever. Okay? I don't read, right? All right, thank you very much.
Thank you, sir.
As far as surrendering the firearm, he may appear at the police station in Doral and leave the firearm in the vehicle, get off, advise the officers there as to what you're going to be doing, and then they'll allow you to bring him in. They'll give you a receipt and we will file it with the court. Okay, Mr. Gatto? Sorry
sir.
about that, Judge. Just wanted to make sure so he's not confused.
No worries, I appreciate it, Mr. Carantes.
Thank
Have
you.
a great day, Your Honor. Have a nice weekend.
Thank you, you too. Ms. Marino, here for Karen Richardson.
Yes, good morning, Your Honor.
Let me, can we go out of turn quickly? Do we have Karen Richardson here?
Judge, I can ask corrections to bring him.
I don't have Karen Richards.
Karen Richardson.
Oh, you're for felony.
Yes, sir. Yes,
Oh, I'm
sir.
sorry. You're gonna have to wait. We're on a DV calendar and then misdemeanor calendar.
Understood.
All right. We have next, Donald Caston.
Yes, Your Honor. Good morning.
Morning. Okay, you've been charged with battery, domestic violence, a misdemeanor, first degree. Any probable cause argument?
Judge, we have no probable cause argument at this time. However, we would have an argument for the bond in this case.
Okay. State. Any argument on release conditions? Probable cause found.
I'm sorry, Your Honor, I'm just still reviewing the.
Okay, defendant, what's your probable cause argument? Excuse me, not probable cause, your release conditions argument.
Yes, Judge. We would be asking for release on his own recognizance in this case, or the alternative of pretrial services and alternative bond of $1,000. Mr. Kasdan has no local priors that the defense is aware of. While the allegations in this case do include a battery of a girlfriend. It's the defense's position that he is not a flight risk and he's not a danger to the community based off of his lack of priors, lack of bench warrants, therefore.
Okay, and so Mr. Kasdan, how long has he been a member of this community?
Judge, he's been a member of the community for 9 years.
Okay, is he employed?
Yes, Judge, and he does have family down here.
How many family? Where are they located? Can he stay there?
My mother lives in the same building with me. I don't live with this girl.
Judge, he does not live with the alleged victim in the case. However, his mother does live in the same building with him. And he would be able to live there
If he needed to.
if he needed to, yes.
Okay, and I heard the defendant call her this girl. Are they in a relationship?
Judge, based off the arrest form, there's an allegation that they are in a 2-year dating relationship. I believe it would be his girlfriend.
Okay, state. You need more time? I'll give you a couple
Yeah.
extra.
Thank you, Your Honor. So, Your Honor, in this case, we have a defendant who chased the victim down in his car after she tried to escape him. Battered the victim.
Can you hear? Can you, public defender? Can you hear
Yes,
the argument?
Judge.
Okay,
Yes, sir.
sorry.
Battered the victim and then fled the scene of the crime. So there certainly is a risk of flight here with the defendant who has fled from the crime itself. In which case, Your Honor, we would be asking for an elevated bond of $2,000.
Yeah, okay, and I also noticed that there is he's obviously able to pay for the bond, correct?
Judge, I believe so, yes. However, we would still be asking for the standard bond in this case. Despite the allegations in the arrest form, it would still be the defense's position. He's not a flight risk and he's not a risk to the community. He has no priors, no prior bench warrants based off of the facts that defense sees no prior cases in Miami. And he has been a member of the community for 9 years and he does have family here.
Okay, look, pretrial services and standard bond, the alternative standard bond, again, given I'm fleeing the scene of the crime, is not necessarily the same thing as a flight risk from the community. He's been here for 9 years. He's employed. He's got his mother here. The stay away order will address the concerns that I do have about escalating violence, given the nature of the allegations. Again, they are allegations, but the nature of the contested allegations, because I do see that there are separate statements. One witness testified that she physically observed the defendant hitting the victim and saw him slam the victim to the floor. And all the other allegations about the driving situation suggest a pretty emotional circumstance or situation. So either way, the pretrial services are a bond, but again, I will sternly advise the defendant to stay away from this victim.
Yes, Judge.
All right, the stay away order. Do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following persons hereinafter: the victim, Ali Jimenez, including contact in person, in writing, by telephone, through social media, or any electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Is there any particular reason why the defendant would need to go to her residence?
No, Judge, not at this time.
Okay. Again, this is a no contact case. All right. Thank you. Sorry, the bond is pretrial services, alternate $1,000 bond.
Judge, I'm here with Mr. Christian Galvez, and he does not need the assistance of the interpreter.
Okay. Mr. Galvez, you are being charged with domestic battery, domestic violence battery with harm, first degree murder, first degree misdemeanor, section 784.031A2. Public defender, any probable cause argument?
Judge, we do not have probable cause arguments at this time. However, we would have an argument towards the bond in this case.
Okay, what is your, I'm gonna find probable cause. What is your bond argument or your release condition argument?
Yes, Judge. We would be asking for pretrial services with an alternative bond of $500 in this case. Mr.
$500?
Yes, Judge. Below the standard bond in this case, Judge.
Okay.
It's the defense's position that in this case, Mr. Galvez is alleged to have battered the mother of his children. However, he does have priors. However, they are all nonviolent priors and drug offenses. He's lived in Miami for 30 years. He works here, and he also has his entire family here. He's not a flight risk. He's not a danger to the community. It's a defense's position that pretrial services with the $500 alternate bond would be suitable in this case.
State?
The state would just ask for the standard bond amount. I understand that the convictions on the defendant's record are nonviolent. However, there have been four prior battery charges that the defendant has been alleged to have committed. So the state would be asking for the standard bond amount here.
Okay,
Judge.
I'm sorry, Your Honor, would have no objection to pretrial services with the alternate bond being standard.
Judge, apologies if I may. The battery cases that the state brings up were all no action or no prost. And the only actual convictions he has on his record are for drug related offenses. So there are no violent convictions, no withholds to violent crimes, purely allegations and cases that were closed.
Okay, and Mr. Galvez, did this altercation occur in front of children?
Judge,
Or are the allegations that this was witnessed by children?
Judge, from my understanding, from my client advising me, he says that the children were not in the room. However, based off the arrest form, it says that the children were present in the listed location. However, that does not mean they were necessarily in the room or aware of the situation.
It says they have $2 in common and reside together at the listed location, right?
Yes, Judge.
Okay. All right, and the allegation is a telephone was thrown.
Yes, Judge.
Okay. All right, a second. And these drug charges in the past, for what substances?
Yes, Judge. So I do see that one of them is for cannabis, and then two of them are for cannabis related. And then the other two, I'm unaware based off of the names of the charges, Judge.
Okay, and is Mr. Galvez, you said he's a longtime resident, is he employed?
Yes, Judge. He was actually telling me he has work tomorrow that he would like to get to if possible.
And he has family?
Yes, Judge. He gave me the address for his mother's house where he can stay.
Okay. All right, so you asked for a $500 bond and the state asked for standard 1,000?
Judge, it was pretrial services with the alternative of the $500 bond.
He's not eligible for pretrial services, so I won't order pretrial services.
Yes, Judge. That would be asking for the $500 bond.
And the state wants the standard 1,000?
Yes.
All right, I'll give a standard $1,000 bond, straight bond. And I'll read a stay away order. Mr. Galvez, do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the victim, Jeanette Corbello, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. I understand this is the share a common child, correct? Are they married?
Judge, no, it's just children in common.
Okay. Do you need to return to the residence?
Yes, Judge. He would need to return to the residence to get some property.
The defendant may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer, to retrieve his personal clothing, personal health items, medication, personal and business-related paperwork, and work tools. Going to the home or remaining at the home without the police would subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. Okay? And just to be clear, I understand that you have children in common. That is not a justification to violate the restraining order or this stay away order. So you'll have to make other arrangements to see your children in the meantime. Okay?
Yes, Judge.
I think this is the final DV case for this morning, correct?
Judge, I am here with Mr. Molina Sosa. He will need the assistance of the Spanish interpreter.
Okay, thank you. Appreciate you telling me that.
Interpreter present, thank you.
Okay, Mr. Molina Sosa, you've been charged with first degree misdemeanor for battery, domestic violence.
Señor Molina tiene un cargo de delito menor en el primer grado, agresión corporal, índole, violencia intrafamiliar.
Any probable cause argument?
Judge, no, however, I apologize.
A ver si existen argumentos respecto a la base legal del caso. Sorry.
No probable cause argument at this time. We do have bond arguments, though.
No tenemos argumento respecto al fundamento legal, sin embargo, sí en cuanto a la fianza.
Okay, I'm going to find probable cause. What is the bond argument or the release condition argument?
Bien, ningún argumento en cuanto a la base legal. Ahora, ¿cuál es lo que me está usted solicitando en cuanto a la liberación o el monto de la fianza?
Yes, Judge. In this case, Mr. Molina Sosa has lived in Miami for 3 years. He also does have work here. He works for Uber. He has no prior cases that the defense is aware of based off of his record in front of me, which also means he has no prior bench warrants. It's our position he's not a flight risk. And also, despite the allegations in this case, which do include a battery, as was spoken by the court earlier, he's not a risk to others if released on this case. We would be asking for either an ROR or pretrial services with a $500 bond, Judge.
May the interpreter relay, Your Honor?
Yes.
Thank you, Your Honor. En la defensa indicamos que el señor Molina Sosa lleva 3 años viviendo en Miami, tiene trabajo, trabaja para Uber, no tiene antecedentes penales. Queremos afirmar que él no presenta riesgo de fuga, por más que se alega el delito de agresión corporal. Y también queremos indicar que él no presenta riesgo para nuestra comunidad. Por tanto, solicitamos libertad bajo palabra con la fianza gratuita pre-trial y, en todo caso, una fianza alterna de $500. Thank you.
Before I turn it over to the state, where are the ties to the community?
Judge, that was he's lived in this community for 3 years.
En cuanto a sus lazos con la comunidad, bueno, su señoría lleva 3 años viviendo en nuestra comunidad.
And he does not have family here. He has family in Atlanta. However, he does drive for Uber. And from my understanding, he does have a support system here.
Y en cuanto a tener familia, tengo entendido que su familia no vive acá, sino en Atlanta. Sin embargo, acá trabaja y tiene un grupo de apoyo.
Is there an immigration hold in this case?
¿Orden de detención por parte de la entidad migratoria?
No, Judge, not on the jail card.
No aparece la orden de detención en la tarjeta carcelaria. No hay.
Okay, and you said he has support or something vague about that. What is that support in the community?
¿A qué se refiere cuando nos indica que el señor tiene apoyo en la comunidad?
Judge, he has many friends in Miami, including friends that would allow him to live with him. That is what the defense meant with the support system.
Bueno, cuando la defensa estaba indicando que tenía grupo de apoyo, nos referimos a que tiene muchas amistades en Miami, a más de amistades que pueden otorgarle alojamiento. A eso nos referíamos en la defensa.
State.
Your Honor, the state would be asking for the standard bond amount here with no pretrial services. The only argument submitted is that the defendant has ties to the community because he's lived here for 3 years. However, the state would like to lay the record that the defense has previously stated that ties to the record are sufficient, ties to the community are sufficient, even if a defendant is just visiting from California, for example. So there is no tie to the community here, despite 3 years, 1 day. There has been nothing submitted here. He does not have, he is self-employed through Uber, and due to the violent nature of this crime, the state would be asking at a minimum for standard bond with no pretrial services.
La Fiscalía solicita que se le otorgue el monto de fianza estándar, que no se le otorgue ni libertad bajo palabra, ni tampoco la fianza gratuita. Por más que la defensa quiere manifestar que él tiene lazos con nuestra comunidad y un grupo de apoyo, 3 años y trabajar de manera independiente no reflejan ningún sistema de apoyo. El hecho de estar aquí 3 años no quiere... Was that echo of myself, Your Honor? Or did
That was me. I moved and I hit something, I think. So you may have heard something with my chair hitting.
Oh, okay, Your Honor. Sorry. Por más que he estado aquí 3 años y 1 día, eso no le da derecho a declarar que tiene lazos con nuestra comunidad. Por más que esté solamente visitando y viva en California, como han argumentado en otras ocasiones la defensa, solicitamos el monto estándar de fianza.
Judge, if I may?
Sure.
I believe the state may have mischaracterized my representation that somebody from California has substantial ties to the community. I did correct myself once I became aware of that. However, in this case, what is relevant is that he has been here for 3 years. He's been here long enough where he could apply for Florida residency. He could have a Florida license plate, a Florida driver's license, which is much more than in that prior scenario where somebody was a tourist here.
Okay, so
Su señoría, quiero corregir algo. Creo que la Fiscalía ha reflejado de manera errónea lo que yo había manifestado anteriormente. Además que esa vez que manifesté los lazos y la persona estaba aquí como turista y habitaba California, en esa misma instancia me corregí. Lo que sí se hace relevante en este caso es que el señor, de hecho, lleva 3 años viviendo acá y ese es tiempo suficiente como para poder haber obtenido su placa del automóvil, la matrícula, la licencia de conducir, solicitar su residencia, y por eso es que queremos manifestar que sí tiene lazos.
Okay, so I'm gonna enter pretrial services alternate $1,000 bond. My largest concern is about the flight risk, given that he's not he's an Uber employee. So he's relying on his car for employment. But other than that, haven't heard anything else establishing any sort of an enhanced risk to the community. There's a risk to the alleged victim here. So that's why, obviously I'll enter a stay away order, but the stay away order should, if he follows it, of course, should take care of the risk to the community, because I otherwise haven't heard anything establishing that he's an additional risk.
Thank you, Your Honor. Le voy a otorgar la fianza gratuita, pretrial services, y monto de fianza alterna, $1,000. Lo único que me preocupa en cuanto al riesgo de fuga, no estoy muy seguro, pero sé que depende de su automóvil para poder trabajar, y obviamente el peligro para la víctima en este caso, a favor de la cual voy a emitir orden de alejamiento. Si el señor se apega a pie juntillas a la orden judicial, entonces ya se habría eliminado esa posibilidad de que nos presente usted un riesgo. Thank you, Your Honor.
Okay, I'm going to read the stay away order now.
Le voy a leer la orden de alejamiento, señor.
Do not engage in any criminal activity.
No puede participar de actividades ilícitas.
Do not use or possess any illegal drugs.
No puede consumir ni estar en tenencia de drogas ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede utilizar, comprar o estar en tenencia de arma blanca, arma de fuego ni municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department.
Cualquier arma de fuego, municiones o permiso para portar arma debe quedar entregado de manera inmediata al departamento de policía,
And file a receipt with the court.
presentando recibo ante este tribunal.
The defendant is prohibited from having any direct or indirect contact with the following person:
El acusado tiene prohibido contacto directo e indirecto con la siguiente persona.
the victim, Jacqueline Ortiz, including contact in person, in writing, by telephone.
Jacqueline Ortiz, es a favor de ella la orden judicial. No puede tener contacto con ella en persona, por escrito ni por teléfono.
Through social media or any other electronic means, or through third persons.
Tampoco puede publicar nada en las redes sociales, tampoco por medio del uso de ningún dispositivo electrónico ni a través de terceras personas.
Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times.
El acusado tiene que conservar la distancia mínima de 500 pies de la persona de la víctima, su hogar, su lugar de estudio y o empleo en todo momento.
I understand from the A form that the victim and the defendant reside together.
Tengo entendido a partir de la orden del informe de arresto que la víctima y el acusado conviven.
Judge, they do live together. He would need to go back to get belongings. However, he does have another residence he can stay at.
Su señoría, es un hecho que sí conviven y tiene que ir a recoger unas cuantas cosas y además cuenta con otra vivienda para poderse alojar.
The defendant may return to the victim's residence one time only within 48 hours of the entry of this order.
El acusado podrá regresar a la vivienda en una sola ocasión, según esta orden judicial, y 48 horas dentro del plazo de su emisión.
He may do so only accompanied by a police officer.
Solo podrá acudir en compañía de agente policial,
To retrieve his personal clothing,
con afán de recuperar su ropa personal,
personal health items, medication,
artículos de salud personal, medicamentos,
personal and business related paperwork, and work tools.
documentación laboral, personal y herramientas laborales también.
Going to the home or remaining at the home without the police will subject the defendant to arrest.
Si acude a esta vivienda o permanece en la vivienda, le deja sujeto a nuevo arresto.
Without the police.
Thank you for aiding the interpreter, Your Honor. Si acude o permanece en la casa de la persona sin escolta policial, queda sujeto al arresto.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
El agente policial deberá solicitar por parte del acusado toda llave o dispositivo de ingreso para entregárselo a la víctima.
Thank you. That concludes that order.
Gracias, concluimos con la orden.
That concludes the DV calendar.
Y hemos concluido con, sorry, Honor, that was for
Nice.
nobody.
It's fine. Somebody enjoyed it. All right, now we wait for
Good
the
morning.
misdemeanor.
This is Joanne Hennessy. I'm here for the misdemeanor calendar.
Good morning. How you doing? Now we wait for the staff switch here.
Sure.
Recording stopped.
Good morning. How you doing? Were you here yesterday? No. And somebody. Thank you. Thank you. Nice to meet you as well. Thank you, folks. Thanks for helping me.
Oh, yeah. Thank you.
Yes, Mr. Officer Pereira.
Are you taking a break, Your Honor?
No, we're switching staff here.
Oh, understood. Thank you.
New team coming in. Yeah, does the interpreter require a break?
Just 2-minute comfort break, taking advantage of this one.
Okay, yeah, all right, 2-minute comfort break.
Thank you, Your Honor.
Thank you. Morning, everyone. This is Judge Perez Santiago. We are
Recording in
back on the
progress.
record, or we were on the record probably, but either way, we're here for the misdemeanor and criminal traffic calendar. Public Defender's Office ready?
Yes, Judge. Assistant Public Defender Jacob Kovas for the defense again.
Okay, gonna get appearances from everybody again who's going to be part of this proceeding.
Thank you, Your Honor. ASA Nicholas Whitaker on behalf of the state of Florida.
ASA Alexa Borges, also on behalf of the state of Florida.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Okay, anybody else that I'm missing? Okay.
Judge, apologies. We do have two cases that corrections is asking to call out of turn.
Which
It would
cases?
be number 12 and number 47 on the docket.
Page 4, Mr. Jarvis.
Mr. Jarvis.
Okay, I'm gonna get him now. Give me a second. Survey.
Judge, he's a fugitive from F Corps. Held no bond. He's from the parole board.
Okay, Mr. Gervais there, all right?
Yes, Judge.
All right, Mr. Gervais, you've been charged with a second-degree misdemeanor, alcoholic beverage, curbside drinking prohibited. Do I have any probable cause arguments? By the way, I'm provisionally appointing the public defender's office, unless I state otherwise.
Judge, no probable cause arguments at this time. We would have bond arguments that could be heard.
Okay, state, or actually, go ahead, please proceed.
Well, Judge, being that Mr. Gervais is currently being held on another case, we would ask for a $1 bond in this case. This is an alcoholic beverage curb drinking case. He doesn't pose a threat to the community. He does not have apologies. I'm not. He has priors. However, in this instant case, there's no violent allegations. There's nothing indicating that at this time he's a threat to the community. We'd be asking for a $1 bond since he is being held on other cases.
State?
No objection from the state.
Okay, so $1 bond.
I want to get this over with.
On the bond.
No.
Probable cause found, $1 bond.
Can I take a plea now so I can get this over with? I have a parole violation that I'm trying to get over,
Judge.
take care of too.
I'm not gonna take a plea, on the misdemeanor calendar. Apologize.
I have
Thank you.
advised him against it, Judge. Thank you.
Anything else? All right, you go. Thank you. Mr. Gervais, thank you very much. And the other case,
Judge, the next case would be Mr. Muhammadin Kabibi. It's number 47.
what page, corrections?
15.
Be on the bottom, Judge, of files.
Gonna be the bottom of the file.
Yeah, down there.
And Judge, he does speak Arabic. He would need an Arabic interpreter.
Do we have an Arabic interpreter?
Your Honor, the interpreter will try to procure the Arabic interpreter as soon as possible. Therefore, please do not put any Spanish cases until I have achieved that, please.
Okay, we can't proceed until we have an interpreter. Unless
I mean, please pass the case. It's going to take a while for me to get into language line. You have to put codes and ask and hold and.
Judge, apologies. He is saying that we would be willing to waive interpretation for this.
okay, if he's waiving interpretation, I'll accept the waiver of interpretation.
Yes, Judge.
Understood, Your Honor. Thank you.
Okay, this case, you're here for a bench warrant for a citation, failure to appear on 11/13/2023 for arraignment with Judge Capote. And I guess it originated from a driving without a license.
Yes, Judge. He was in ICE custody when the bench warrant was issued.
He's also a fugitive from Hillsborough County.
Okay, so there's an ice hold in this case?
Judge, from my conversation with him, he's already resolved the ICE case. However, I'm not aware of any ICE hold at this time.
So he was in an ice hold before.
Yes, Judge.
One day before.
They released him and brought him back here, Judge.
Okay. State,
Just a moment to confer, Your Honor.
and corrections, I'm sorry, you said he was wanted in Hillsborough County? What was it?
He has a no bond hold for fugitive, Hillsborough.
Okay, fugitive from Hillsborough, okay.
Judge, given his failure to appear in or being wanted in Hillsborough County and his failure to appear here in Miami-Dade County, we would be asking for an elevated bond of 2,000, given that the standard bond is 1,000.
Judge, if I may respond. As the defense represented, he was in ICE custody, which would explain the bench warrant here. And although the defense does not have knowledge of the fugitive warrant in Hillsborough County, that may also be attributable to his time in ICE custody. The defense would ask for either a reduced bond in this case on the bench warrant, since he does have other holds and a fugitive warrant. Or we would be asking in the alternative, the judge says that you set the standard bond, Judge.
What's the standard bond?
Right now, it's at $1,000 for the bench warrant.
Okay. Again, I don't know the circumstances of the no bond hold in Hillsborough County. So I will convert the bench warrant to a bond of $1,000.
Yes, Judge.
Thank you. Straight bond. Okay, that's it for the out of turns from the corrections.
Yes, what's the bond for Mr. Habibi?
$1,000.
Thank you.
All right, we are now back in order, correct?
Yes, Judge. Judge, Miss Valeria Lafucci did bond out, so we have here Miss Kiana Hammonds at this moment.
You just got BO at the bottom.
All right, Miss Hammonds. Okay, Officer Pereira's hands raised. What's happening here?
Hi, good morning. Are you able to hear me?
Yes, I am.
Hi, good morning, Judge. I'm here for a PC hearing on a felony case of a battery on a female over the 65 years of age.
Yes, that we're on the misdemeanor calendar still. We just
Okay.
started the misdemeanor calendar, so you have a bit to go.
No problem. I'll wait here. Thank you so much.
Thank you, officer. Okay, Ms. Hammonds, you're being charged with second-degree misdemeanor for disorderly intoxication. Any probable cause argument?
Judge, we have no probable cause arguments at this time. We would have an argument for bond in this case.
Okay, probable cause found. What's the bond argument?
Yes,
Or
Judge, we'd be Apologies. We'd be asking for an ROR in this case, or in the alternative, $1 bond. Ms. Hammonds has no priors that the defense is aware of. She has lived in Miami for 7 years and she does have work. While she does not have family here, she does have friends and she is able to have a support system around her. It is our position that due to the lack of her priors, due to the lack of bench warrants, she is not a flight risk and she's also not a threat to the community, as well as her living here for 7 years and her ties to the community.
Take.
No objection.
Okay, ROR. Thank you. Release on recognizance.
Thank you, Judge.
Oh, there's a stay away order in that case. I'm sorry. Ms. Hammonds.
Ms. Hammonds is back, Judge.
Okay. Ms. Hammonds, part of the release conditions, I'm also ordering you to stay away from the following areas. It's where you were arrested. 300 block Lincoln Road, Miami Beach, Florida. This order shall remain in effect until the case is closed, modified by the court, or for a period of 6 months. Okay? Thank you very much. America Gonzalez is next.
She's on probation, F21 5897, F23 9617.
This is a probation violation.
Judge, Ms. Gonzalez does need the assistance of the Spanish interpreter.
Señora González, yo le voy a servir de intérprete. Han mencionado en la cárcel que tiene 2 casos en los que se encuentra usted bajo libertad vigilada. Escuchemos.
Okay, Ms. Gonzalez, you're charged with a first-degree misdemeanor for trespassing property after warning.
Señora González tiene un delito menor en el primer grado, entrada ilícita tras advertencia.
And you're charged with a second-degree misdemeanor for alcoholic beverage, curbside drinking prohibited.
Y también tiene un delito menor en el segundo grado, que es beber en público, en la vía pública, perdón.
Any probable cause argument, Public Defender's Office?
¿Argumentos por parte de la defensa?
No probable cause arguments at this time. We would have an argument for the bond in this case.
No queremos argumentar respecto a la base legal, pero sí tenemos un argumento respecto al monto de la fianza.
Okay, I'm gonna order, probable cause found. What is the, for both counts, what is the release condition argument?
Bien,
Yes,
voy
sir.
a declarar que existe suficiente base legal para los 2 cargos existentes. ¿Qué es lo que me quiere argumentar en cuanto al caso, la defensa?
Judge, we'd be asking for a ROR in both counts in this case, or in the alternative, the admission into the TAP program. Miss Gonzalez is currently unhoused. However, she all of her priors are nonviolent. She has lived in Miami for many years. I believe over 10 based off of my short discussion with her. She does not work and she does not have a family. However, she does have ties to this community. She has been in Miami since coming here, and she is not a flight risk, and none of her priors are violent. Or I apologize. There is one first-degree misdemeanor battery that I did see. However, other than that, there's no other violent priors that the defense is aware of.
Su señoría, quisiéramos argumentar en el caso de la señora que, ya que está desamparada, queremos solicitar que le otorguen libertad bajo palabra o el acceso a la fianza, the alternative program, ya que la señora está desamparada, no tiene trabajo ni familia, pero sí tiene lazos con la comunidad, lleva más de 10 años. En mi breve conversación entiendo que es como más de 10 años que vive acá, no presenta ningún riesgo de fugarse, y donde sí tiene un solo cargo de índole violenta en el pasado, de agresión corporal. En todos los otros antecedentes que tiene no tienen nada que ver con actos violentos. Gracias.
State.
Thank you, Your Honor. As a threshold issue, the defendant, as far as violent crimes, was convicted in May of 2023 of felony aggravated battery.
Give it interpreter chance.
En mayo del año 2023, a la acusada se le condenó de agresión corporal con agravantes como delito mayor, en cuanto a sus antecedentes que sean o no de índole violenta.
And Your Honor, one of the charges here is trespass. The defendant was convicted in September 2024 of the same charge and convicted in June of 2024 of the same charge.
Además, su señoría, la acusación que tenemos en este caso, que es entrada ilícita o intrusión, se le condenó de lo mismo tanto en junio como en septiembre del 2024.
For these reasons, Your Honor, we'd be asking for an elevated bond on the trespass charge of $1,000 with the standard bond on the alcohol of $150 and no pretrial services.
Solicitamos, su señoría, que no le otorgue ninguna fianza gratuita y que le eleve el monto de la fianza en lo de entrada ilícita a $1,000 y el monto estándar de fianza en cuanto al cargo de bebida alcohólica a $150.
Does she qualify for TAP? Do we know?
No sé si calificará para la fianza TAP.
Judge, I believe she would qualify for TAP.
Que me pague la fianza, yo no tengo.
The judge, apologies. Based off my discussion with her, I believe that she would qualify for TAP. She does not currently have an address. And I can see if we can get references from her.
Okay, well, so I'll order TAP with the alternate being the standards on both counts. I think the standards on both counts.
It's 500 on trespass, 150 alcohol for.
Are you placing a hold?
Putting a TAP program.
She's out of probation, Judge. Are you placing a hold on those cases?
Yes.
La señora se le va a otorgar el programa TAP con los montos alternos de fianza en el monto estándar, 500 más 150. Además, orden de detención a emitirse por los 2 casos abiertos que tiene, bajo los cuales la tienen en libertad vigilada.
The judge, apologies. Defense did not see that Ms. Gonzalez was out on probation. Given that, we would be asking for a $1 bond in these cases, since she does have felony holds, or she does have probation holds.
Disculpe, su señoría, la defensa. Señora, escuche por favor, que le estoy interpretando. Señora, la defensa no se había dado cuenta que estaba bajo probatoria. Siendo esas las circunstancias, ahora solicitamos más bien monto de $1 de fianza, ya que tiene los 2 casos abiertos. Thank you, Your Honor.
Judge, also a VFOS defendant.
Además, es acusada de delitos violentos y reincidente.
She's a violent felony.
Offender of special concern.
Where is the violent felony?
¿Cuál es el delito violento?
Your Honor, the violent felony, I believe was mentioned earlier. It's the
first degree bit.
Inaudible for the interpreter.
Okay, no, I'm not gonna do the dollar holds.
No le voy a otorgar los montos de $1 en las órdenes de detención.
I do a felony hold.
What's the felony case number?
VFOS.
F21 5897, F23 9617.
Tenemos F21 5897 y F23 9617.
Thank you. Put me.
Yeah, it's right there.
I put it F21.
Okay, perfect.
Ms. Gonzalez is also ordered to stay away from the following address.
Judge, I apologize. I did not.
What about my probation?
Yo fui a mi provecho.
I went to my probation.
Judge, I apologize. I did not hear the bond amount that was given in this case.
It's it's tap alternate bond for count one, $500.
I thought because of the probation holds, we don't need to modify the tap hold, or are we keeping her on tap with the probation holds?
Keep,
Oh.
yes,
Yes, Judge, thank you.
I'm not modifying any of the of my prior decisions based, I'm just having holds also.
Thank you, Judge.
En cuanto a la solicitud de la defensa para que le otorguen montos de $1 en cada cargo, queda denegado. El señor juez mantiene los montos de fianza ante dichos de 500 más 150 y las órdenes de detención para comparecer ante los jueces sus casos abiertos.
Okay, and the defendant shall stay away from the following address: 1160 West Flagler Street, Miami, Florida.
No puede acercarse a la siguiente dirección, señora, según orden judicial: 1160 West Flagler en Miami, Florida.
We can pause too. Yeah.
Thank you.
Your Honor, I can
Gracias.
confirm it's tap alternate 500.
Yes.
On count one and alternate 150 and.
Okay. Thank you.
Judge, I'm here with Miss Inaris Hernandez.
Mm-hmm. Mr. Naris Fernandez, do you need interpretive services?
Do you need an interpreter? ¿Habla español? No. Judge, no, she would not need the interpreter at this time.
She's out on felony bond. F 15283.
Repeat that again, sorry.
She's out on felony bond. F 15283.
Thank you, ma'am. All right, ma'am, you're being charged with second-degree misdemeanor for petty theft and first-degree misdemeanor for resisting officer without violence to his person. Any arguments for probable cause?
Judge, no probable cause arguments at this time. We would have bond arguments.
All right, probable cause found on both counts or three counts. Where your arguments on release conditions?
Yes, Judge. We would be asking for either a $1 bond in this case, seeing that Miss Hernandez was out on felony bond, or we would be asking for the TAP program and the alternative, since Miss Hernandez is currently unhoused.
Okay, so she was out on felony bond and I assume violated the conditions for release?
Yes, Judge. She wouldn't be eligible for TAP. Yes. So we would be asking for a $1 bond in this case.
State?
Your Honor, we would be asking for a felony hold and a $1 bond on the.
Okay. Felony hold and dollar bonds for all three counts. Felony hold is for,
She might need a stay away order.
she will, yes, she also get a stay away order.
Apologies, Judge.
All right, stay away order. Ms. Hernandez, you are being ordered to stay away from the smoke shop. Someone's hand raised. Watching, okay. From the smoke shop on 1677 Southwest 107th Avenue, Miami, Florida. The order shall remain in effect until the case is closed, modified by the court for a period of 6 months. Thank you. As well. Is Miss Ware?
Judge, she'll be back on your bond hearing calendar next.
Yes, Judge. I'm present with Miss Ware here.
Okay. So she'll be on my felony calendar next.
Yes.
All right, so this is for misdemeanors. This is a bench warrant violation.
Yes, Judge.
Okay, what's the underlying charge? Possession of drug paraphernalia, okay. So, Ms. Ware, you're being charged with, you were arrested for failure to appear at a prior proceeding, on a charge for drug possession, possession of drug paraphernalia. What is the bond amount? I'm sorry, the bench warrant amount, $1?
Yes.
Okay. Any probable cause argument?
Judge, no probable cause arguments at this time. I asked Miss Ware why she may have missed court, and she said that she was not given notice through the mail. She'd never received a letter, and she was never told the court date. However, we would just be asking for the $1 bond that is already imposed.
Date? She'll be back in felony later today. No argument, or?
Yeah, I think I'm.
Okay, $1 bond for this case, and we'll see her back later today. Is this Maria Del Rio?
Yes, Judge.
Oh, Judge.
All right, Ms. Del Rio, you're being charged with second degree fraudulent refunds and several other issues of bench warrant for driving with license suspended knowingly and failing to appear for trial with Judge Nelson. Bench warrant $2,000. Failure to appear on a 2/12/2019 arraignment with Judge Krieger Martin, who's since retired.
Judge, apologies. I do not have the arrest forms for those warrants, so I'm unprepared to make arguments as to those cases. I have the arrest form for the fraudulent refunds allegation. However, I don't have anything regarding any warrants.
Okay. Want to pass on or?
You can read them, Judge, the statute if you want.
Okay.
Then you can read what was there.
Okay, so here's what. The driving with license suspended knowingly, citation AEXUAJE was for a failure to appear. The bench warrant was issued. The let's see what you off. Failure to appear on August 17, 2022, again for trial. The second bench warrant for $2,000. AAJ20QE, violation of a non-resident requirement of driver's license. Failed to appear on 2/12/2019 for arraignment. Let's see.
The rest are traveling together.
Yeah, the others are traveling together. You're not held on those, but there are other violations as well. So multiple driving violations and bench warrants.
Yes, Judge, and I was just informed by Ms. Del Rio that for the 2019 bench warrant that was placed, she told me she was in custody when that was set in place.
Where was she in custody?
Judge, Metro West.
So corrections
Have to confirm.
Can you confirm that?
Say that again, confirm what?
The defendant is stating that on the failure to appear for an arraignment on February 12, 2019, the defendant was in Metro West's custody. Or was in custody at Metro West.
Yes, Judge, in 2019, the defendant was in custody from January 2nd, 2019 to April 24th, 2019.
Judge, in that case, we would ask any bench warrants that were placed at that time to be vacated.
That bench warrant is for the 2/12/2019 AAJ20QE is vacated. She was in custody and obviously has a non-willful failure to attend, so that one will be vacated. You need to write that down.
No. As when they're taken in custody, it's set aside, but your condition of release would be different.
Great. Okay. Anything on the $5,500?
He was not in custody.
Nothing from the defense, Judge. I don't have any information regarding that case. Besides the allegations and the bond amount and the case number. However, we would be asking for admittance into the TAP program with an alternate bond in this case. Ms. Del Rio is unhoused, and although she does have failure to appears in the past, and she does have bench warrants from the past, we believe that she may be a good program or a good fit for the TAP program, as they might be able to help her come to court and not fail to appear in the future.
State.
No objection, Your Honor.
Okay, so she's a TAP on an alternate bond for the second degree misdemeanor will be $150. I'm going to convert the bench warrant for AEXUAJE. That bench warrant from $5,500 to a $5,500 bond as the alternate for the TAP program. Did you do anything with the third one?
The third one is a misdemeanor, Judge. Functional funds.
I did that one already.
You did?
Yeah,
Okay.
150 or TAP.
Okay, and then,
We set aside one for $2,000.
okay.
What is the bond amount for the 0QE?
Give me a second.
I believe that was the case that was vacated, where the bench warrant was vacated, Judge.
Yes, that's vacated.
What's the bond amount? How is she getting released?
It's the standard. You can tap or standard.
Judge, we would ask for it to be the TAP program in concurrence with all the other cases.
Yep.
Okay, that's a 2019. If I want to do that. Okay, it will be, where is it here? Well, you can just write TAF alternate.
What's the standard bond for that?
It is
150?
150.
So tap and alternate bonds for each standard.
Marcus,
Yes.
case ending in 0QE is tab alternate 2000?
No, I'm
No.
$150.
150. This is traveling with, this is this sign here next to the reset shell report. Thing in this one. That shell report. And this one. And where's the other one?
Misdemeanors 150. Tap 150.
And this one, you wanted to leave output prevention, right?
Yes.
It'll be tap 5,500.
Thank you. Do we have everything?
Judge, is there a stay away order in this case?
I believe so. Thank you for asking. Maria Del Rio. Ordering you to stay away from the following address, the Walmart in South Dixie Highway, Florida City, Florida. It is, the order will remain in effect until case is closed, modified by the court for a period of 6 months. Thank you. Corrections, did you get everything?
Yes, Judge.
All right, thank you. Thank you for asking all the of clarification. All right, Ileana Hernandez, is that who we have next?
Those are the people.
Okay, Miss Hernandez, you're being charged with 2 violations. No valid driver's license and misuse of a temporary tag. And you have friends in the courtroom?
Yes, Judge.
Any probable cause argument on either of these?
Judge, this time we have no probable cause arguments. We just have arguments as to the bond in these cases.
Okay, what is the argument for the bond?
Just to check corrections, does she have any holds?
According to the jail card, she does not.
Okay, perfect. In that case, we'd be asking for an ROR in this case. According to the records that I have in front of me, Ms. Hernandez has no local priors. This means she has never had cases in front of this court, nor she had an opportunity to bench warrant or fail to appear before. It's the defense's position that she's not a flight risk and she is not a threat to the community. Although she does not have substantial ties to the community, she's been living here since January. This is a place that she does plan on making her own home, and she has no plans on leaving Miami anytime soon based off of my conversations with her. And it would be the defense's position that even though she's only been here since January, this is a place that she does plan to make home for a long time. She's not just a tourist.
State?
One moment, Your Honor. I just want to review.
And apologies, Judge. She will need the assistance of the Spanish interpreter.
Oh, okay. Let's restart everything.
Yes.
There be no objection from the state here, Your Honor. I just want the defendant to fully understand that she does not have a driver's license, which means she cannot be driving in the state until she obtains one. And thus, Your Honor, we would be asking for a no drive order.
Madam Interpreter?
Yes, Your Honor.
Oh, I'm sorry. She asked me earlier. Well, no. We handled it already. Sorry, it's, this, defendant, Ileana Hernandez needs your interpretation services.
Yes, Your Honor. Señora Iliana Hernández, yo le voy a servir de intérprete.
Okay, so, Ms. Hernandez, you are being charged, with, or traffic citations for no valid driver's license, and, misuse of a temporary tag.
La acusación en su contra, señora, es por estar sin la licencia válida y también una placa o matrícula de carácter provisional o chapa.
Your attorney, public defender's office has argued or has not raised a probable cause argument, and I find probable cause for both violations.
El abogado de defensa no ha argumentado respecto al fundamento legal de los cargos y el señor juez declara que tienen base legal ambos.
But has argued for you to be released on your own recognizance.
Sin embargo, ha argumentado para que le otorguen libertad bajo palabra.
And I'm going to give the opportunity for the state to repeat its argument now that you have interpretation services.
Voy a dar la oportunidad ahora a la fiscalía que repita su argumento ahora que cuenta con los servicios del intérprete.
Thank you, Your Honor. The state would ask that the defendant, it be explained to the defendant that she may not drive in the state of Florida without a valid driver's license.
Quisiéramos en la fiscalía que se le explique a la acusada que no puede manejar en el estado de la Florida sin contar con licencia de la Florida.
And lastly, we ask the court impose a no drive order on the defendant.
Además, solicitamos en la fiscalía que se emita orden judicial prohibiéndole el manejo a la señora.
Okay, I'm going to release her on her own recognizance
Le otorgo libertad bajo palabra, señora, o caución juratoria.
on both counts.
Es en ambos cargos.
I want to remind you that you are not allowed to drive in the state of Florida without a valid driver's license.
Quiero recordarle, señora, que está prohibido manejar en la Florida sin portar licencia de la Florida.
And I will issue a no drive order.
Además, emito orden judicial prohibiéndole el manejo.
The court orders you that you shall not drive until you have a valid driver's license.
La orden judicial dictamina que no podrá usted manejar sino hasta obtener licencia de conducir válida.
Failure to comply with this order may result in a finding of contempt of court.
Si es que no cumple con mi orden judicial, puede resultar en que le declaremos en desacato a la corte.
And again, you have your friends in the courtroom who I would advise to help you honor your obligation to return to court.
Además, quiero recordarle que tengo aquí en la corte sus amistades y quiero decirles que le ayuden a cumplir con esta orden judicial.
Because failures to appear will only aggravate the situation, not help her in any way.
Porque, por ejemplo, falta de comparecencia, si tiene que presentarse a la corte, eso no le va a brindar ninguna ayuda si incumple.
All right. Thank you. Your friends are nodding in the back, so I hope you appear in the future for future dates.
Sus amigos están ahí atrás asintiendo, así que es mi expectativa que a futuro usted se presente.
Thank you, Judge.
No driving.
Thank you. Is this Mr. Scruggs or no, Miss Scruggs?
The bond out.
Bond out?
Yes, and Judge, Mr. Obregon is at Jackson Memorial Hospital, I believe.
I don't have Mr. Obregon next. Do I? Oh, I do.
Yeah, then Ward D, reset for tomorrow.
Okay. Are we set for tomorrow? And you said he's in medical?
He's in Ward D, Judge. Reset for tomorrow.
Okay, thank you. Is this Mr. Rivera?
Yes, Judge.
Señor Rivera, ¿necesita intérprete?
No, ma'am.
No.
Gracias.
Okay, Mr. Rivera, you are being charged with first-degree misdemeanor of threatening a law enforcement officer with death or harm. Any probable cause argument?
Judge, we don't have probable cause arguments at this point, but we do have arguments towards the bond in this case.
Okay, probable cause found. What is your release condition argument?
Yes, Judge, we would be asking for an ROR in this case, or in the alternative, pretrial services. Mr. Rivera does have several priors. However, these he has 2 prior convictions from what I see here. However, it's defense's position that does not create the belief that he's a danger to the community. Furthermore, we're unaware of any prior bench warrants that he might have had or failure to appear. And Judge, he's lived in Miami his entire life. He's been a member of this community. His family is all down here. And he also works down here.
The 2 convictions were for second-degree felony and a first-degree felony.
Yes, Judge. And those were not non-violent felonies.
The second-degree felony says here possession of a felony weapon.
Yes, Judge, that is a felon in possession of a
Felon in
firearm.
possession. Okay, just making sure. And the first felony is or the first degree felony was substance selling
Yes,
in a near a school. Is that what that is? Sorry, I'm getting less information on the prior conviction form than anything else. All right, state.
One moment, Your Honor. I'm trying to look up what the case that the officers in this case were responding to, which are relevant.
Current
Apologies,
charges.
I can't hear the state's arguments.
He's the state is looking up the charges for which this misdemeanor relates, like what the officer responding to. On my end, I see current charges for a second-degree felony, a FA weapon possession felon again, third-degree felony, grand theft with the firearm, I believe, and 2 other felonies. I don't know what those are because again, they're in shorthand.
So, Your Honor,
So 4 felony charges, 3 second-degree felonies, 1 third-degree felony, and this first-degree misdemeanor.
do we have a felony on for this defendant today?
Corrections, is this defendant returning today for bond hearings for felonies?
Yes, Judge.
Yes, he's returning today.
So then I'll address release on the felonies.
Okay, so with misdemeanor, what was the public defender's office request for misdemeanor?
Judge, yes, in which case we'd be requesting a $1 bond since there are other felony holds.
No objections from state? $1 bond? I'll address release issues. Public defender, I don't know if you're returning later. Please don't make the argument that I gave a $1 bond on the misdemeanor at the felony later.
Yes, Judge.
Okay.
I won't be the attorney in the felony court. However, I will leave that in my notes.
Yes, that happened a couple times yesterday. So just want to note that I'm not considering the felonies at this point.
Yes, Judge.
All right.
Judge, is there anything else
ordering?
that needs to be?
No, there's nothing else for that case, I don't think.
Okay.
Thank you. Did I have Mr. Diaz yesterday? Is this Mr. Diaz?
Judge, this is not Mr. Diaz. This is Mr. Fernandez Delos.
What happened with Mr. Diaz?
Judge, I'm not entirely sure. If I could take a second. to see what's
Diaz.
there.
He left the room yesterday, from my recollection. He was behaving very erratically. He left the room during my hearing yesterday.
Judge, corrections just advised me that they're bringing him now, possibly.
Okay, well, be advised, again, he behaved erratically when he was in the room yesterday.
Yes. Judge, Mr. Fernandez will need the assistance of the Spanish interpreter.
Yo le voy a servir de intérprete, joven.
This was reset for a probable cause determination today.
Habíamos postergado la audiencia para el día de hoy para llevar a cabo una audiencia a ver si existe suficiente fundamento legal.
And the issue yesterday was with argument that the reference to a crack pipe with an unknown substance was insufficient to establish probable cause.
Y se alegaba el día de ayer que cuando se trata de una pipa, no se puede usar no se puede utilizar la pipa para sustentar la acusación sin conocimiento de la sustancia.
State, do you have anyone here to testify or?
¿La fiscalía tendrá algún testigo?
Again, the argument yesterday was that under the statute, there has to be an intent to use the drug. And without knowing the substance, the argument was you can't establish probable cause that the substance was.
Can we just inquire if Officer Hernandez was on the platform?
Officer Hernandez, are you in the platform?
El argumento el día de ayer era que para poder establecer el intento de uso de la pipa tenía que tener conocimiento respecto a la sustancia. ¿El agente policial se encuentra presente?
If we can just pass this for a moment, he was notified that the hearing was at 9:30, and given the time, I'm not sure if he logged off already. If we can just contact him to log on.
Sure, we'll pass this. Please let me know when he's available, he's online.
Vamos a postergar, señor, tome asiento y le vamos a traer cuando esté de regreso el agente policial.
This is also, thank you. All right, is Mr. Diaz there? Where's his paper? Here.
Yeah, Judge, he's not here. I believe they're trying to bring him on Zoom now. I don't have access to the Zoom platform from where I'm standing, so I can't see if he'd be on there.
We have Mr. Marshall, he's the next.
Okay, all right, I'll take Mr. Marshall next. We had the same thing reset for probable cause determination in this case as well. Again, similar argument made. The last pipe had burnt residue on one end, but no description of what that would be or not.
We are on the case of
John Marshall.
John Marshall, case ending 6657.
Is it 6657? I have no idea where am I looking?
Yes, there are two cases. The new case is drug paraphernalia possession. B 25 16657. And then the folder, which is a bench warrant. That has to be established a statute incomplete.
It's here yesterday. Okay, so there's for now, do you have an officer or anybody here to help with the probable cause determination?
One moment, Your Honor, somebody conferred with my colleague, I didn't see, I only have two cases illegal for, probable cause.
The other officer for the other case is just logged onto the platform. If you need us to contact this assistant.
Officer Spencer is present for defendant John Marshall Jr. case. So let's, all right. All right. The state is looking up the case and I will assume they will call the Officer Spencer to testify. And Mr. Officer Hernandez will be next.
Hey, Your Honor, just, if you don't mind, just one more moment, just so I can. Your Honor, you said we have Officer Spencer on the platform for this case?
Yes, Officer Spencer has identified himself as the officer present for the John Marshall Jr. case.
Yes, good afternoon, Officer President.
Officer Spencer, good afternoon.
Oh, hold on. If you could turn on your video and can we swear him in?
Yes, please raise your right hand. Do you see him?
I don't see Officer Spencer yet. Officer Spencer?
Yes. Do you solemnly swear or affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Thank you.
Okay, state.
Okay, Officer Spencer, did you, on August 1st of 2025, come to meet a man who would later be known to you as John William Marshall Jr.?
Yes.
And do you see that person on the platform today?
Yes.
Can you please point him out and identify him by an article of clothing?
He is gray hair and he's wearing a green garment.
May the record reflect that the witness has identified the defendant. Okay, so officer, on that date, did you see did you see the defendant in possession of a glass pipe?
Yes.
And did you see him in possession of that glass pipe in Miami-Dade County?
Correct. Miami-Dade County, Miami Gardens.
And did the pipe have a burnt residue?
Yes.
And what, if anything, was that burnt residue?
Well, it was burnt. I could not tell exactly what it was, but from my training and experience of being assigned to a unit, previously be assigned to a unit that handled narcotics and firearms violations, having a burnt crack pipe is consistent with crack cocaine use.
Okay. And And was there anything about the location or the location of where you found the defendant with this pipe that contributed to any sort of indication that the residue was of an illicit substance?
Well, the location that the defendant was in, which was the gas station, that's a known location a well-known location for firearm and narcotic violations also. So.
Okay. No further questions, Your Honor.
Public defender, do you have any questions?
Yes, Judge. Good morning, officer. So.
Morning, sir.
Morning. When you say that that's a well-known location for narcotics and firearms, do you know how many narcotics arrests you've made in that location over the past year?
No, I do not know.
Would you say that it's more than
But
3?
I can't say. I know we do get a lot of complaints, call for service at that location for narcotics violations as well, people loitering around the location.
Okay, but you can't specifically recall how many that might be.
No.
Okay. Now, you said that you saw Mr. Marshall with the pipe. Did he ever tell you that was a crack pipe?
No.
Is it from your experience that you came down to the fact that it was a crack pipe?
Yes.
Okay, and you never did any rapid testing on the substance in the pipe?
No, I did not.
You never sent it off to a lab?
No.
Does anybody that responded to it with you have any further experience with narcotics than you do?
Yes, there's other officers who same experience and training.
Did they do any analysis on the pipe?
No.
Did anybody do anything further than see the substance in the pipe and make an arrest?
No.
Okay. No further questions at this time, Judge.
Okay, any argument on probable cause this time?
Yes, Judge. The defense would argue that in this case, the officer has stated that it was from his experience that he believed that this was a crack pipe. However, it was never specifically mentioned by anybody that it was a crack pipe or that it was used for that. Furthermore, there was never any testing done on the substance or any further investigation done past seeing that there was a substance in a pipe that looked like a crack pipe. It's also the defense's position that although on the arrest form and in his testimony, the officer said that this is an area that's frequently trafficked with people who have narcotics or firearms, and there's many arrests here. There was not a specific number or even a range that could be given when I asked him about specifically how many arrests were made for those charges or how many arrests were made in connection with narcotics. At this time, it would be the defense's position that the state hasn't satisfied probable cause to continue to hold Mr. Marshall.
State.
Well, Your Honor, the standard here is while this is a probable cause hearing, it is reasonable suspicion of criminal activity. The defense is scrutinizing the how persuasive this evidence is. However, this is an analysis of the state's burden of production here, and the standard meeting reasonable suspicion is a low threshold. In fact, the lowest threshold. So the facts presented at this hearing are sufficient to support reasonable suspicion. And Your Honor, to reiterate, for possession, Officer Spencer found the defendant in possession of a glass pipe. The nature of the object, the pipe had a burnt residue, indicating it was used to consume drug. Knowledge, the presence of the burnt residue supports the conclusion that the pipe was being used as drug paraphernalia, and possession was knowing. Finally, location and behavior, loitering near the gas station without conducting business, which may indicate intent to use or distribute drugs. But the key fact here is the possession of the paraphernalia itself. And for these reasons, Your Honor, we ask this court find that there was sufficient reasonable suspicion here for this case to be disposed.
Judge, if I may. In their examination, the state did not bring up any evidence regarding Mr. Marshall loitering around the gas station. And there was no evidence that anybody from the gas station requested Mr. Marshall to be removed, or there are any calls from the gas station.
Okay. I find probable cause for the charged, the charged in the A form, based off the officer's testimony. Any argument on bond?
Yes, Judge. In this case, we would be asking for Mr. Marshall to either be given. Apologies, Judge, I'm just looking through the information. Judge, we would be asking for an ROR or release to pretrial services in this case with an alternate bond.
State. There's another case we're gonna talk about now. It's a bench warrant for $2,000.
Right, Your Honor. So, the defendant has a history of not abiding by court orders here, and we think anything lower than the standard bond amount on this case, Your Honor, the state submits would be insufficient to secure the defendant's presence.
Is he eligible for PTS? Anybody know?
Don't know, but you can order them in, Judge.
Okay. All right, PTS with a standard bond, alternate, it's a standard bond. 1,000?
For the drug paraphernalia, Your Honor, the standard.
$500. $500. Sorry, my apologies. And the and for the bench warrant, does the public defender's office, and I'll read a stay away order as well for related to the misdemeanor. The defendant is ordered to stay away from the target on 5601 Northwest 183rd Street. The bench warrant, it's an open case from 2018. It's case number B18-027303. It's for a second degree misdemeanor for petty theft. The judge was Martin Shapiro. I don't know, October 29th, 2018, that was the date the bench warrant was issued. Any argument on willfulness? It was an arraignment.
Judge, at this time, I don't have any arguments to make as to willfulness. We would be asking that the bench warrant be modified to match the bond that was given in the drug paraphernalia case.
Okay. We'll do so.
Your Honor, if I may, the state would object to a $500 bond on the petty theft. There's the defense is not.
The bench warrant's for $2,000.
Right, Your Honor. So I would just ask for the standard amount on the 2,000.
Well, that's what, sorry, I apologize. I will give $2,000 bond.
Thank you, Your Honor.
Are you granting these standard bonds or this was pretrial?
So for the bench warrant in the 2018 case, I'm converting the bench warrant that's for $2,000. I'm converting it to a bond for $2,000.
And the new case, what was the bond?
It's pretrial services, and the alternative $500 bond.
So the bench warrant is straight bond and the new case is pretrial.
Yes.
Correct. Thank you.
Yep. Yes, of course. All right. Thank you. Send to the next defendant and give us a couple minutes. Just straight black. It's fine. It's to have something to drink.
Okay, got it.
Flavored water.
Yes. Okay.
Judge, apologies. Corrections is asking if we'd like to bring Mr. Fernandez back next. That was the PC.
Correct. Yes, that's
Yes,
correct.
Okay.
Yes.
And he will need assistance of the Spanish interpreter.
Okay, great. Give us a couple seconds to our side. I can get it. I just don't want to interrupt you doing the thing. Anybody else in the courtroom could also help themselves to coffee or donuts or whatever else is there still available. No. There might be old bagels from yesterday, so can vouch for its tastiness. Thank you, sir. Appreciate it. Ready when you want.
Yes.
Right?
Okay, yes, go ahead.
All right, Mr. Fernandez de las Santos, I think.
Fernandez de las is what I have, Judge.
Let's see, yeah, Fernandez de las, sorry. Again, yeah, you are charged with a first degree misdemeanor for drug paraphernalia or possession of drug paraphernalia with intent to use. We had a, Madam Interpreter, go ahead, sorry.
I'm sorry, Your Honor, it's a misdemeanor and what?
Sorry, misdemeanor charge for possession of drug paraphernalia with intent to use.
Tiene una acusación de delito menor, es tenencia de instrumentos para el consumo de drogas.
And we had a hearing yesterday that I reset for probable cause determination.
Ayer llevamos a cabo una audiencia y tuvimos que postergarla para el día de hoy para establecer el fundamento legal.
So we have now excuse me, an officer here to testify on behalf of the state.
Así que ya tenemos ahora presente un agente policial para brindar testimonio a favor de la Fiscalía.
Officer Pereira, can you please turn on your video?
El
And
agente Pereira, por favor, activa su cámara
you get sworn in.
para prestar juramento.
Please raise your right hand.
Levante la mano derecha.
Good morning. Can you hear me?
We need you to turn on your video.
Hi, good morning.
Good morning. Please raise your right hand. Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Thank you.
Ya ha prestado juramento el agente policial.
Sorry to interrupt, but Officer Correa is here for the defendant Jose Belize Rodriguez, and I believe the defendant standing next to defense counsel is Mr. Fernandez de
De
las.
las. Oh, who's here? I thought Officer. Oh, Officer
El agente,
Hernandez. Sorry, Officer Pereira.
Yes,
Sorry about that. Yeah, called you in the wrong case. So
no problem. No worries. I'll wait.
Officer Hernandez, let's swear in Officer Hernandez now.
Hi, good afternoon.
Good afternoon.
Do you solemnly swear or affirm the testimony you're about to give is the truth, the whole truth, and nothing but the truth? If so, say I do.
I do.
Thank you.
ya ha prestado juramento el agente policial Hernández.
State.
Thank you, Your Honor. Sergeant, good afternoon.
Good afternoon.
Buenas
Will you,
tardes con la sargento.
will you please state your name for the record?
Nombre para las actas.
Sergeant Rainey Hernandez.
Sargento
Okay.
Reini Hernández.
And what is your current employment status and where do you work?
¿Cuál es su empleo y dónde trabaja?
I work for Hialeah Police Department. Patrol.
Trabajo en el Departamento de Policía Patrullero de Hialeah.
And were you working in your capacity as a sergeant or police officer on August 1st of 2025?
Yes.
El día 1 de agosto del 2025 estaba trabajando en calidad de sargento. Así es.
And on that date, did you come to meet a man who would later become known to you as Rydell Fernandez de las?
En
Yes.
esa fecha conoció a un hombre cuyo nombre y apellido conocería después como Raidel Fernández Devas.
Yes.
Sí.
And do you see that person on the platform today?
Lo ve al individuo en plataforma el día de hoy.
Yes.
Sí.
Will you please point him out by an article of clothing?
No las podía señalar por medio de una prenda de vestir.
He has a jumper, looks like jumper orange, right next to another man. That is,
Parece que tiene un mameluco naranja parado al lado de otro hombre.
And when you came upon the defendant, was that Miami-Dade County?
yeah, Miami-Dade County in the city of Hialeah.
Cuando tuvo el encuentro con el acusado fue en el condado de Miami-Dade. Es correcto, dentro del condado de Miami-Dade, ciudad de Hialeah.
And did you observe the defendant drinking a 16-ounce beer near a shopping center?
Lo vio el
Yes.
acusado tomando una cerveza de 16 onzas cerca a una tienda.
Yes.
Sí.
And were there signs that prohibit such drinking within 100 feet of the store?
Yes,
Habían-
it was right behind him.
Habían letreros que prohibían la actividad de consumir bebidas alcohólicas en el área. Así es, el letrero estaba justamente atrás de la persona.
And is that why you initially detained the defendant?
Y por eso es que lo detuvo el acusado.
Correct.
Correcto.
And during that search, did you find a crack pipe with an unknown black substance in the defendant's pocket?
Correct.
Mientras hacía la requisa, encontró en los bolsillos del acusado la pipa para consumir sustancias. Así es.
And what was, if anything, that black substance?
¿Qué sustancia era la sustancia entredicha, negra?
Well, it looked like a residual pipe with inside the pipe was like a black substance. It appeared to be crack cocaine based on the years of experience that I have 7 years working on patrol.
Parecía ser un residuo negro que estaba dentro de la pipa de vidrio. Parecía crack de cocaína, según mi experiencia de 7, 8 años trabajando en patrulla.
So a pipe containing a black substance supports a suspicion that the defendant was intending to use or ingest a controlled substance?
Encontrarse en tenencia de la pipa con el residuo negro indica que ese es el intento para consumir.
Correct. Sorry, I got confused with the translating. Correct.
Okay, and
Correcto.
are crack pipes commonly considered drug paraphernalia?
Este tipo de pipas normalmente se consideran instrumentos para consumir crack de cocaína.
Correct.
Así es.
And are they used to ingest controlled substances?
¿Son estas únicas? ¿La pipa se utiliza solamente para estas sustancias reguladas?
Not necessarily.
No necesariamente.
Okay, so in this case, what is the illicit substance that you suspect the defendant of consuming with this crack pipe?
En este caso, ¿cuál es la sustancia ilícita que usted sospecha contenía la pipa?
To me, it looked like crack cocaine, but to confirm the substance, I send it to the lab, Miami-Dade lab, to get tested.
A mis ojos parecía crack de cocaína, pero para hacer la prueba fue enviada al laboratorio de Miami-Dade.
And has that yielded any results? Has the lab yielded any sort of results or confirmation as
¿Ya
of
le ha
yet?
brindado resultado el laboratorio en cuanto a la sustancia?
No, because the defendant got arrested on Friday and we sent it to the lab on Friday afternoon. It takes a while for us to get the results back.
No, porque el acusado quedó arrestado el viernes y después de horas de su arresto mandamos la sustancia, el artículo al laboratorio y toma tiempo hasta que recibamos el resultado.
No further questions, Your Honor.
No hay más preguntas por parte de la Fiscalía.
Public Defender's Office.
Yes, Judge. Morning, Officer Hernandez. How are you doing?
Hi, how are you? Good.
It's good.
La defensa saluda a la oficial, a la sargento, perdón.
Now, Officer Hernandez, earlier you had said that you had pulled out what seemed to be a crack pipe from my client's clothing, correct?
Nos dijo anteriormente que usted le obtuvo de la persona de mi cliente algo que parece ser una pipa para consumo de crack.
Yes.
Así es.
Did you take any photos of that pipe?
¿Tomó fotografías a la pipa?
No, no pictures were taken, but it's on my body cam and also in evidence at the station.
No se tomó fotografía alguna, sin embargo, todo aparece en mi cámara corporal y tenemos elementos de prueba en la estación de policía.
And earlier you said that the pipe could be used to ingest other things. Could you just tell me what some of those other things are?
Usted nos dijo anteriormente que la pipa se puede utilizar para ingerir otras sustancias. ¿Puede indicarnos cuáles otras?
Well, like any other tobacco product, I guess.
Me imagino incluimos cualquier tipo de producto de tabaco.
So it can be used to ingest things that are legal items to possess.
Puede utilizarse para consumir sustancias lícitas, ¿verdad?
Yes, you can use it for whatever you want, basically.
Sí, se puede utilizar básicamente para lo que uno desee.
And you weren't able to do any rapid testing on the substance in the pipe that night?
¿No le pudo hacer una prueba rápida esa noche?
No, and it was not at nighttime, it was in the afternoon. We don't carry the test kit usually. That's why we send it to the lab.
No, aparte no fue de noche, fue durante horas de la tarde. Además, no es nuestra práctica portar esos kits de pruebas.
But had that pipe been empty with no residue, would you have still arrested Mr. Fernandez at that time?
Si la pipa no hubiera tenido residuo alguno, ¿aún así hubiera arrestado al señor Hernández?
Of course not.
Por supuesto que no,
Because there has to be drug residue in it in order to make the arrest for these charges.
porque tiene que tener droga residual para poder generar el arresto.
Correct.
Correcto.
And prior to the arrest, you weren't able to confirm whether the substance was actually illegal or not.
Y antes del arresto, usted no pudo confirmar si de hecho se trataba de una sustancia regulada o no.
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 In fact, a pipe like that can be bought in a lot of stores across Miami.
De hecho, una pipa de ese tipo se puede comprar en muchos tipos de tiendas acá en Miami, ¿verdad?
I imagine, yes, I guess.
Me imagino que sí, supongo.
For tobacco? For tobacco?
Para
Yes.
tabaco, sí.
Yeah.
No further,
I'll say.
No hay más preguntas por parte de la defensa.
no further questions at this time, Judge.
Dave, any additional questions?
No, Your Honor.
All right. Any argument?
Judge, defense would argue that PC in this case has not been satisfied. As the state stated earlier, that the officer needs to have a reasonable suspicion. However, in this case, we heard testimony that there was a pipe. It had residue in it, which appeared to be possibly crack cocaine based off of the officer's experience. However, that hasn't been tested. Officer Hernandez herself said that there's a lot of options as to what substances could be in there, some of which are legal substances to own. It's a defense's position that there's no probable cause in this case and that Mr. Fernandez should be released outright.
Su señoría, queremos argumentar respecto a la base legal, donde la Fiscalía señala que tiene que tener el agente policial una sospecha razonable para generar el arresto. Ella misma nos ha confirmado que hay una variedad de sustancias que son legales que pueden contener la pipa y no se le ha hecho la prueba aún. Por tanto, afirmamos en la defensa que realmente no se ha establecido el fundamento legal.
State.
Thank you, Your Honor. This court should find probable cause, and that follows for at least two reasons. The defendant was found with what appears to be a crack pipe containing an unknown black substance. These pipes are commonly considered drug paraphernalia under the statute because they are used to ingest controlled substances. As the witness testified, the pipe contained a unknown black substance, which supports the attempt to use or ingest a controlled substance. The defense, again, is arguing whether or not the defense's argument lends towards whether or not the state has met its burden of persuasion, not production. This is a scrutiny of the state's burden of production, and there was reasonable suspicion to investigate this crime, and there was probable cause to arrest for this crime. And for those reasons, Your Honor, we ask this court find probable cause in this case.
Su señoría, solicitamos que declare que sí existe base legal en este caso, porque como bien lo dijo el agente policial, las pipas de este tipo normalmente, según estatuto de ley, se utilizan para consumir crack de cocaína. Además de eso, lo que estamos aquí poniendo a prueba no es la persuasión ni la producción que ha presentado la Fiscalía, y pensamos que eso se puede librar en un momento futuro, pero declaramos que sí existe base legal, su señoría debe aseverarlo.
Okay, based on the officer's testimony, I find probable cause. Again, the argument on both of these cases that so far for probable cause has been kind of a reasonable doubt argument, not a reasonable suspicion probable cause argument. So again, find probable cause. Any argument on the bond or release conditions?
Judge, we would ask for standard bond in this case.
No objection, Your Honor.
Okay, and the standard
Bond
bond,
is 500 for the nine. Alcohol consuming in the order 150.
okay,
May I answer really, Your Honor?
yes.
El señor juez indica que de hecho hay base legal y el argumento en este caso no ha sido tanto respecto a la sospecha, si fue razonable o no, sino más bien la duda. Por tanto, declaro que sí hay base legal y se va a emitir monto estándar de fianza, 500 por un cargo y 150 por el otro.
All right, and I think is there a stay away order for this one as well, or not?
No.
No? All right, thank you very much.
Hemos concluido, señor. Gracias.
Doing.
Can I get the bond amount, please?
Okay, count one, 500, count two, 150.
Thank you, Marcus.
You're welcome.
Well.
Oh, that was from yesterday. Somebody, we don't know that.
Yeah, thank you.
You got it.
At the time it was considered that, yeah.
All right. All right, Mr., is this Raymond Evans?
Yes, sir.
Yes, Judge.
Okay. You're being charged with, or there's a bench warrant for your failure to, let me try to figure this out.
He's also out on probation. F 21-18602.
F-21 was I apologize, taking notes.
F 21-18602.
Okay, so felony probation, and a bench warrant, related to a an assault on a police officer or law enforcement officer, threatening a enforcement officer. I don't know what the amount of that bench warrant is.
$100.
$100 for that bench warrant, okay?
Yes.
That's what we're here for?
Yes.
Oh, this is a little different than the other stuff. All right, thank you very much. Any probable cause argument or any issue, sorry, any kind of defenses for the bench warrant?
Judge, no probable cause argument or arguments as to the warrant. We would just ask for a $1 bond in this case, being that there's probation holds.
Okay. State,
No objection. Your Honor.
all right, it's $1 bond. Probation hold. All right. Count two, $1 bond.
You show 2 counts, Judge?
Well, count 1 was administratively nulliprost, the assault. So we're just doing the threaten with the Leo. Count 2 only.
Sorry, it's only the there was a null pros for the other count that was referencing, I suppose. So the
assault was done in July 7th, 2023.
okay, so all right, so $1 bound for count 2. The other count was null pros, so we're only showing one count that's active.
Thank you, Judge. I got it.
All right, thank you. And it's a $1 bond. Thank you. I have someone raising their hand as an iPhone. Not sure who that is. Again, another iPhone hand raising. I don't know who you are, iPhone.
Your Honor, do you want the announcement in Spanish?
Sure.
Persona que está en iPhone, si es que perdón, que ha levantado la mano, si está vía telefónica, apriete asterisco 6, y si no, active su micrófono en la parte inferior izquierda de la pantalla, por favor.
I think we have to allow them to speak, but I'm not going to allow someone to speak unless I know who they are.
Es nuestro intento dejarles manifestarse, pero no puedo hacerlo sino hasta saber quién es cada cual.
Is that the prior defendant's spouse?
I'm sorry, Judge.
Sorry, I have some communications from 12:58 p.m. and via chat. Someone wrote, "I'm his wife. We did not receive a court date in the mail, but his bondsman arranged, I'm assuming, for him to be seen the 13th of August. He's not on probation and this charge was closed. Due to work, he turned himself in early as he's a security guard and didn't want to risk getting arrested at work. He just came in for this in March."
Judge, I believe that may have been referring to Mr. Raymond. However, I don't know.
Right.
We do have Mr. Cortina here besides me.
Give me a second. Sorry, I have some paperwork I'm getting back. Sorry, all over the place for you.
Could you write the
Dollar bond.
yeah, could you write the, oh, you wrote it there, probation. That's perfect.
Thank you. We have here Mr. Cortina.
Yes, Judge.
He doesn't need the services of interpreter.
No, Judge.
Okay, Mr. Cortina, you are here on a first-degree misdemeanor for trespassing property after warning, and 2 local ordinances. One disorderly intoxication, a municipal ordinance, and a resisting arrest without violence municipal ordinance. Any probable cause argument?
No probable cause argument, Judge. We'd just be asking for a ROR in this case. He has no violent priors. I see he has a withhold of adjudication for disorderly intoxication, which is not a conviction. However, every other case that he's had opened has been dismissed so far. And none of them have been with violent allegations.
Okay, probable cause found, state.
Your Honor, we would be asking for asking for standard bond on the trespass, elevated bond on the disorderly of $300, due to the withhold. And Your Honor, while defense is correct, it's the withhold of adjudication is not a guilty verdict. It's not, it doesn't signify innocence either. So we would ask for elevated on the disorderly and standard on the R1.
There's a third count.
Yes, there's a third count for resisting arrest. Violence. What's the position, state's position on that?
Standard bond amount on the R1 resistant.
Okay, I'm going to issue standard bonds for all three. So first degree misdemeanor is a $500 bond. And both local ordinances are $150 bonds. And that is mostly for the continued conduct. I know this is not necessarily close in temporal proximity, but it's repeat offenses. And the stay away order, please stay away from, you not please. You are ordered to stay away from the following address, the Walk on Bistro, 9065 Southwest 162nd Avenue. And the order shall remain in effect until the case is closed, modified by the court, or for a period of 6 months. Okay? We count 1, 500, count 2, 150, and count 3, 150, 150. For a total of $800. All right, thank you very much. Sorry.
Your Honor, Joanne Hennessy for the city of Miami Beach for defendant Harris.
Okay, so this is your case, not the state's.
That's correct.
All right, so Mr. Harris, you are here charged with a violation of a local
Judge,
ordinance. Yes.
Mr. Harris refused. This is Mr. Lusma that's next to me.
Okay, Mr. Harris refused. Is this his?
Thank you, Your Honor.
Did he refuse yesterday? Or no, this is the first day he's coming in?
I think
It
it's
looks
the
like he
first
may have
day.
refused yesterday.
Oh,
We're gonna pass Mr. Harris, Judge.
yeah, he did not refuse yesterday. He wasn't unless.
Correct, we're gonna pass him. He didn't
Thank you.
refuse.
Okay, he hasn't refused. We're passing it.
No.
Okay. Okay, this is a Lusma then?
Yes.
Okay. This is, you are being charged and you have two other felony or two other felony issues. Are those coming to
On the
me?
bar here, calendar next.
Okay, it's next. All right, so we're here today now though, Mr. Lusma, with a first degree misdemeanor charge for providing a false name and identification after arrest. Any probable cause argument?
Judge, no probable cause argument. We'd just be asking for a $1 bond in light of the pending felonies.
State?
No objection.
All right, $1 bond because of the pending felony bond hearing coming later today. Again, please don't argue that you are entitled to a $1 bond based off of my determination now on this misdemeanor. Okay?
Yes, thank you, Judge.
Sorry.
Judge, I'm standing here with Mr. Azari.
So Mr. Rosari, the current charge, or this is for a bench warrant of $1,500. I, he failed to appear. I don't know if it's an arraignment, or a trial of some sort. I do not know what the proceeding is, but the bench warrants for, the first degree misdemeanor resisting officer without violence. Is there any argument for the bench warrant?
Judge, right now, we have no probable cause arguments. However, we do have an argument as to the bond in the case.
Okay, probable cause found. What's the argument on, the release?
Yes, Judge. Currently, he has a $1,500 bond on the bench warrant. We would be asking for admittance to the TAP program and an alternate bond of $1,500. This would make it so that he has his references there. He can be reminded of court, and he has that service there, but also it would still have that added action of the $1,500 alternate bond.
Date?
Your Honor, we would be asking for the standard bond amount here and no pretrial services.
Okay, I'm looking at his, there's a lot of charges on this prior close cases, in 2023, grand theft. I know there's withhold adjudication, but there's a lot of activity there. And there's a bench warrant, failure to appear. So I'm going to convert the bench warrant to a standard, or to the bond amount of $1,500 to secure his appearance at the trial.
Judge, would you be willing to go lower than the standard bond? As I said, Mr. Azari is unhoused. It would be defense's position that on a misdemeanor case, he is entitled to non-monetary bond. The court has found him to be, a flight risk and a possible risk to the community, it would seem. However, if we could reduce the bond without maybe giving him a program, that way.
State any argument about reduction of the bond?
Yes, Your Honor, this is a standard bond amount based off of his failure to appear. So that's the base, the legal basis for the standard bond amount here is outlined by the fact that the defendant has a history with this court on this charge for not appearing in court. So the defense has given no reason as applied to that legal basis as to why this should be reduced.
I'm gonna order it at $1,500. I understand, public defender's office. Your point is valid, that is the general circumstance. But again, I have a laundry list of prior issues that brought him into the system, and a lot of notes here about failures to appear, and just generally, this is a flight risk issue, and also repeat offenses, a lot of offenses. So I'm concerned about the continued violations if he's released.
Fires and flight risk.
All right. Thank you.
Would that standard bond 1,500, Judge?
Yes.
Thank you.
Okay, Mr. Berger is next.
Judge, we need to pass to get Mr. Berger.
Okay. Mr. Henderson is here.
Pat Henderson.
Patterson Henderson. Is Takian Moore here?
Who is that, Judge?
Defendant Moore?
It should be Stevenson John. The next is printed up.
Your Honor, Joanne Hennessy for the City of Miami Beach for regarding Stevenson.
Why do I have Moore and most people push it? Give me 1 second. I don't have the documents in front of me.
Judge, I'm here with Mr. Stevenson.
Right. I don't have the I'm looking through my own documents. Give me a second. Bear with me. I'm sorry. Yeah. Right, burger, we passed burgers, maybe use after burger. All right. John Long Stevenson.
Yes, Judge. I have Mr. Stevenson in front of me or beside me, and he will not need the assistance of any interpreter.
Okay, and I understand he's being charged with a violation of a local ordinance. Entering after hours a parking establishment, assuming, or park?
A park, Your Honor.
Okay. All right, any probable cause argument?
Judge, no probable cause argument. We just asked for him to be either ROR'd and given a date certain or released to the TAP program. This is the allegations in this case is that he was in a park after hours. He's not a danger to the community. In terms of the priors that I have here in front of me, there's only a prior indecent exposure, which was no cross from 2024. However, Mr. Stevenson should be released on his own recognizance.
City of Miami Beach?
Yeah, Your Honor, I'm not sure if Mr. Stevenson is originally from Miami or how long he's been here. There is a very short prior list. I would just ask for a standard bond, given that I'm not certain of the existence of any out-of-state priors.
Oh, defender's office, how long has he been here?
Judge, I had spoken to him. He goes between here and Palm Beach, I believe, since. So he's been in Florida for roughly a year, Judge, going between Miami and Palm Beach. However, the defense is not aware of any priors that he may have picked up during that time or before that time. But again, this is the allegation here is him being in a park after hours. We would ask for him to be ROR'd and given a date certain.
Okay, I'm gonna ROR. And I'll tell him I'll do a stay away order. And the homeless calendar date, would I have that? I put it somewhere here.
Judge, I don't believe that there's going to be a homeless calendar continuing from now on. I believe that we're just giving them a date certain and
Right, well, correct. But we are giving him a date certain. So the date certain for this individual would be September 10th, 2025. It's 8:45 a.m. in courtroom 6-8.
Is it 6-8, Your Honor? Have they changed the?
Yes, we changed it.
Yeah, it's changed to 6/8. I've got
Thank
it
you, Your
here,
Honor.
my notes. Right. So again, ROR, and I'll read the stay away order. $800 block of, defendant shall stay away from the following address. 800 block of Loomis Park, Miami Beach, Florida. So, in other words, stay away from the park in which you entered, after hours. Thank you.
We're going to pass, Mr. Arango.
Passed, all right. I don't have Mr. Rango's. Oh, you have. All right, thank you. Is this Salgado Castro?
Yes, Judge, and he will need the assistance of the Spanish interpreter.
Okay.
Your Honor, Joanne Hennessy for the City of Miami Beach. This is the state's case at this time, but there's a ordinance.
Okay.
I'm just announcing my appearance.
Thank you, appreciate it.
Señor Salgado Castro, yo le voy a servir de intérprete. Se acaba de anunciar la fiscal del caso.
Okay, Mr. Salgado Castro, you are charged with two separate charges.
Tiene dos cargos distintos, señor Salgado Castro.
First degree misdemeanor for trespassing property after a warning.
Delito menor en el primer grado, intrusión tras advertencia.
And violation of a local Miami Beach ordinance, which prohibits camping.
Y también quebrantamiento de una ordenanza municipal de Miami Beach que es campamento ilícito.
Any probable cause argument from the public defender's office?
Argumento respecto a la base legal.
No probable cause arguments at this time, however, we do have a probable cause argument in the camping charge. However, we do not for the trespass case, Judge.
Tenemos un argumento no en cuanto a la base legal, pero sí queremos argumentar en la acusación del acampado, del campamento.
State.
So just as to the, well, the camping ordinance for Miami Beach, I think that belongs to the Miami Beach for them to argue the probable cause.
The state's flipping it over to you, Ms. Hennessy.
Judge, should I?
Thank you.
Pasamos con la fiscalía.
I'll await the argument, I guess. I think the probable cause in the affidavit is sufficient, but I'm not sure what the objection is.
Voy a esperar que argumente la defensa porque no estoy segura qué es lo que me quieren argumentar porque me parece que el informe de arresto basta.
Judge, according to the Miami Beach ordinance that the camping prohibited is charged under, the police need to offer him shelter or a place to go in the alternative. And here on the arrest form, the officer simply lists that he is well aware of outreach programs that have been offered to him and have made no attempts of seeking shelter or help. It does not say that they gave that offer to him in this specific incident. In fact, it implies that it wasn't given to him in this incident, but it's been given to him in the past. We would say there's no probable cause for these charges and he should be released outright.
El argumento de la defensa indica que para poderle acusar de este cargo, tiene la policía por ley que ofrecerle albergue y resguardo. Y no solamente que no lo han ofrecido, sino que además mencionan que en el pasado le han ofrecido programas de albergue y él no ha hecho ningún intento por acogerse. Por tanto, la defensa quiere que declare el juez que no hay base legal para el cargo.
Your Honor, if I may.
Yes, you may.
Thank you. First of all, I would just argue that the offer of shelter is a affirmative defense. The elements of the camping charge are found in 7045 parenthesis 1, A, B, and C. And what is described in the A form meets those elements. He had he had some bedding, he had personal belongings around him, and he was using the lifeguard stand as shelter. So he's met the definition of public camping or sleeping, and that the offer of shelter is an affirmative defense. And then secondly, I think that the offer of shelter is also not absolute. That if he's been offered it in the past, that might be, it says notwithstanding, let me see. There's a person who's ineligible for shelter for any reason, but not limited to, and then it has a series of items that would be not limited to. So it's possible that because he had been offered it in the past, there was no reason to offer it to him again. In any case, the first thing is it's an affirmative defense. The second thing, it's not absolute. And if there's a requirement for a probable cause hearing, I'm happy to see if we can get a officer here for tomorrow.
I'll have a problem. I'll find probable cause on this.
If I may, it's affirmative defense, yes, but it's
I'm
also an
sorry.
argument.
I'm sorry. Before that, I would have to interpret Ms. Hennessy first,
Yes.
please. And interpreter clarification. Ms. Hennessy, you said 7041 and then something I missed and then ABC.
I'm sorry, 7041. I'm sorry, 7045 is the ordinance, and the elements are defined. The definition is 7041A, 1A, B, and C.
Thank you, madam, for aiding the interpreter. Nos indica la fiscal que el elemento que argumenta el abogado de defensa es para el momento de la defensa en el juicio, no es para ahora. La fiscalía declara que hay base legal porque el informe de arresto indica que el señor tenía artículos de cama para dormir, artículos personales. Aparte, está mencionado también en el informe de arresto que el señor se había ubicado debajo del sillón de los salvavidas y estaba usando el albergue de esa edificación de madera para poder resguardarse. Aparte, lo de la defensa no es algo absoluto. El hecho que ya la policía ha mencionado que en otras ocasiones ya le han ofrecido albergue, más bien demuestra que no había que hacerlo en este caso. Ahora, si desean, yo programo mi audiencia para establecer base legal y hago venir al policía el día de mañana. El señor juez declara que hay suficiente fundamento legal. Thank you, Your Honor, and Ms. Hennessy.
Defender?
Yes, Judge. This is an argument you make on first JOA, which means that it is an element of the crime that needs to be proven. In this case, it's an element of the crime that needs to be alleged on the arrest form. There's no probable cause that there was ever any offer of shelter given to him on this instant. It's the public defender's position that he should be released outright.
Su señoría, el elemento que menciona la defensa, que es el ofrecer albergue, es uno de los elementos cuando uno primero pide, por primera vez, perdón, cuando uno pide por primera vez exoneración de todo cargo. Por tanto, es uno de los elementos que tiene que estar presente desde la orden de arresto. Por tanto, creemos que no hay base legal.
Understood. Reading within the four corners of the A form, the defendant is well aware of the outreach programs that have been offered to him and has made no attempt to seek shelter. I don't read this A form and that statement the way the public defender's office does, as some sort of implicit acknowledgement that shelter was not offered.
Según mi lectura de el informe de arresto y los parámetros que me presenta, no entiendo la forma como lo está interpretando la defensa, más bien yo lo entiendo como que ya se le ha hecho saber respecto a los programas de ayuda y albergue, y el señor no ha hecho intento alguno.
In fact, the preceding sentence is referring to a conversation the officers were having with the defendant. So the way I'm reading this A form within the four corners is that a product of that conversation is that the officers became aware that he has awareness of the outreach program.
Y aparte de eso, veo que hay conversaciones previas con los agentes policiales y este acusado respecto a los programas de ayuda, y más bien Lo que queda claro en el informe es que el producto de esas conversaciones anteriores se ve claramente en base a mi lectura y los parámetros de este informe de arresto.
This is an issue you can raise at a subsequent hearing, not at the bond hearing.
Esta es una audiencia que podemos sacar a relucir en un tema que podemos sacar a relucir en una audiencia futura, pero no en esta que es la audiencia de primera comparecencia.
Okay, I find probable cause.
Bien, señores, existe suficiente fundamento legal.
In that case, we would be asking for an ROR with a date certain, Judge.
En ese caso solicitamos libertad bajo palabra y que le dé fecha a ciencia cierta.
Any opposition to that, those release conditions?
Yes, Judge, given his list of priors, we would be objecting to that, we'll be asking for the standard bond.
La Fiscalía se opone a la solicitud de la defensa en base a la larga lista de antecedentes penales anteriores que tienen que ver con la misma conducta.
Okay, standard bond here, let's see what it says.
500 for the trespass and 150 for the camping.
All right. Standard bonds for both counts.
Monto estándar en ambos cargos. It was 500 plus 150, Your Honor, for the interpreter?
Yes.
Yes.
Thank you. 500 y 150 son los dos montos de fianza que tiene el caballero.
And to be clear, the rationale is, it's an extensive
Is he found?
list of priors, or at least charges.
Con efectos de claridad, tiene un largo prontuario.
Judge, Mr. Salgado had already been removed from the room.
Oh,
We
okay.
have to bring him back because he stayed.
Oh, we need to bring him back because I'm going to read a stay away to him.
Yes, Judge.
Thanks.
Señor Salgado Castro,
Judge,
Yes.
I apologize. Mr. Salgado is back here. I've been informed that he does understand English.
Okay.
So we will no longer need the assistance of the interpreter.
understood, thank you.
All right. She got some exercise in her lungs and vocal cords. All right. The defendant shall stay away from the following address: 17th Street, Beach, SURD, SURD. I don't know what SURD is. Anybody know?
Service Road.
Service Road. Okay. There you go.
Although I think that might be an error since he was arrested at the lifeguard stand.
All right. Yeah. Let's have it modified here. Okay, all right, sorry, the defendant shall stay away from the following address: 17th Street Beach Lifeguard Stand, Miami Beach, Florida. This order shall remain in effect until case is closed, modified by the court for a period of 6 months. I guess he knows what it is. Thank you. All right. Yes, you're free to go, sir. Well, free to leave the room.
Ask corrections if we have any of the ones we passed.
Judge, more
Yeah.
here.
Okay, Mr. Moore, after Mr. Moore, corrections, if anybody has been passed, please get to the folks who've been passed. Take on Moore, take on Moore, okay. You're here on a charge for first degree misdemeanor trespassing property after warning. Any probable cause argument?
Judge, there's no allegation that Mr. Moore was on the property at the time the police were located. Or that at the time the police responded to the location or was arrested. The address is, the arrest location address is listed on the arrest form. However, in the arrest form itself, it does not say that he was where he was when the arrest occurred or when the stop happened.
Date?
Yes, so on the eighth one, it does says I was dispatched to the address of the courtyard, and then in the third sentence, it says upon arrival, meaning implying that upon arrival to the courtyard Marriott, he located and spoke with who later became known as a defendant.
Probable cause found. All right, argument on the release conditions?
Judge, we would ask for him to be released on his own recognizance and given a date certain, or given the TAP program. Mr. Moore's priors consist wholly of trespasses that the defense is aware of. He's not a danger to the community. I do also see a conviction for resisting without violence. However, he's not a danger to the community and he's not a flight risk. He's closed out several cases with this court, which means he is willing to abide by the terms of release and come to court.
Okay. Date?
Yes, as to his priors, we do see that he does have some violent one as to battery and battery on a Leo. While they were no cross, we don't know the reason as to why they were no cross. That could be dismissed for either an officer failure to appear or different things that we are not aware of at this time. So given his list of prior charges, we'd be objecting to an ROR, we'd be asking for standard bond.
Judge, that's those charges were dismissed. It doesn't matter necessarily why they were dismissed. You may consider them, however, they were dismissed at the end of the day for lack of evidence, whether it be because the witnesses failed to show up, whether the state no longer wanted to go forward. The defense would say those should not be considered when determining his release.
Okay, you asked for TAP? Is that, you asked for that at some point?
Judge, yeah, so we would be asking for either ROR with a date certain or TAP with a date certain.
It's TAP with date certain.
No, be
Sorry,
ROR.
TAP, TAP.
And what's the alternate bond, Judge?
The $500 alternate bond. Is there anyone ready for corrections? Excuse me, from corrections for the cases we passed?
Mr. Henderson.
Mr. Henderson, okay.
Which page is that on?
Is Clinton Henderson, page 38? Says? No, this can't be it.
Page 7.
He's out on felony bond. F-24-18053. He's coming, 1 second.
Is it F211053?
F-24-18053.
F24-18053. Okay. We have a lot more cases, Madam Interpreter. Big stack.
Judge, I think there might be a few cases on from yesterday as well. I have looks like 3 or 4 cases here from yesterday.
Can you say it again? Sorry.
Apologies, Judge. I do see, it looks like we may have 3 or 4 cases on from yesterday as well. I'm not sure if you'd like to wait till the end of calendar. I do have Mr. Henderson here with me now.
Yes, I do.
Yeah, end of calendar. Okay, Mr. Henderson, you're here now for a first-degree misdemeanor resisting officer without violence to his person. There's another felony case open. Any probable cause argument?
Judge, no probable cause arguments at this time. We'd be asking for a $1 bond in this case in light of the felony hold.
State.
No objection.
$1 bond given the felony hold.
$1 bond?
Yes. Yes, I found probable cause.
We have Mr. Arango next.
Sure.
Your Honor, Joanne Hennessy for the city of Miami Beach. Regarding Arango.
Good afternoon.
Good afternoon.
Okay, these are 2 alleged violations of local ordinances from Miami Beach. Entering a park after hours and camping prohibited.
Yes, Judge. Mr. Rango is coming in now. Judge, I have Mr. Rango here with me now. He does not need the assistance of the Spanish interpreter.
All right, Mr. Rango, you're being charged with 2 violations of local ordinances. 1 for entering a park after hours and 1 for camping on a location that's prohibited. Any probable cause arguments?
Judge, no probable cause arguments. We'd just be asking for ROR and a date certain in this case, or TAP in the alternative.
How long has this individual been in Miami or in Florida?
Judge, he lives in New York. He is he comes down here for work on and off. He's informed me.
The arrest form has a New York address, Your Honor.
Okay. So City of Miami Beach, what's your release conditions?
Yeah, based on unknown priors, I would request a standard bond in both charges.
And these, excuse me, public defender, what were you asking for?
Yes, Judge. Look, I had asked for TAP. He's not eligible for TAP since he has a New York address. However, we'd be asking for an ROR with a date certain, or in the alternative, we would be asking for a reduction in from the standard bond.
Okay, I'll give you RORs on both.
Thank you, Judge. And he will need a date certain.
There's going to be a stay away order, and the date for the hearing will be September 10th, 2025 at 8:45 a.m. in courtroom 6-8.
I'm sorry, Judge. What was that court date?
September 10th, 2025 at 8:45 a.m. in courtroom 6-8.
Thank you, Judge.
And the stay away order. The defendant shall stay away from the following address, 800 block of Loomis Park, Miami Beach, Florida.
Judge, is there a stay away order that needs to be read to him in this case?
Yes, I just read the stay away order too.
Oh, apologies. Yes.
You have to stay away from the 800 block of Loomis Park, Miami Beach, Florida.
We have an out of term, Mr. Dumas, number 31. He's on page 9.
Judge, and I do have Mr. Dumas here with me.
Okay, Mr. Dumas, you're being charged with second degree misdemeanor for petty theft. And a bench warrant was issued for you in another case. Another petty theft. Case number B25-011497. Any arguments?
Yes, Judge. As for the new charge, there's no PC arguments. However, for the bench warrant, Mr. Dumas has informed me he never received notice that the notice in the mail went to a different address and that he wasn't able to learn of his next court date. Being that, we would ask that this bench warrant get set aside and we would ask for an ROR in the new case, the petty theft.
Or is the address issue? If I can have a corrected address, if that's.
Judge, it is 5329 Northwest 17th Avenue, apartment 410, Miami, Florida, 33142.
What was the address the notice was sent to?
Judge, Mr. Dumas said that it was 400 something, but he does not know the exact address.
400 Northwest Third Court?
Yes. Yes, Judge.
Is that a prior address or?
Yes, Judge. He used to live there.
State?
As to the probable cause argument regarding the case that's before us today, the one ending in 6698, I do have the arrest form. It was not on the packet, so I would understand if ACC Provis doesn't have it, I could send him a copy of it. But as for the A form, there is probable cause stated on that one as to the incident that happened, independent of the one that's referred to in the one ending in 97.
Okay, I don't think the.
Court has it either.
No, Public Defender's Office, I don't think made an argument about the present charge, the second degree misdemeanor petty theft.
They made an argument about probable cause as to the one that's before us. They said that there was no probable cause listed in the A form, and it says the A form is referring to B25, the one that ends in 97 from an earlier day of 422. However, the one that was before us today ends in 6698, and it's an arrest that happened on August 2nd at the Walmart as well. Which I don't know if your honor has either, because it wasn't provided to us. But I have the A form pulled up through our system.
The
arrest on?
Yeah, the arrest on this one we were talking about, I thought they said that there was no argument on probable cause. Public Defender's Office? For what reason?
Yes, Judge. I made no probable cause arguments. I was solely talking about the warrants.
Oh.
Yes. We would stipulate to probable cause. We're only saying that he did not have notice for purposes of the warrant.
Yeah, so I'll set aside the bond on the 9/7 case or whatever, is 9/7?
That's the paper filings.
Yeah, because it went to the wrong address. So
Just be asking for standard bond,
what is the standard bond for both
150.
cases? Excuse me?
150 for the petty theft.
For petty theft? Public Defender's Office?
Judge, we would be asking for the release on his own recognizance in the new case and for the bench warrant to be set aside and him be ROR'd in the bench warrant case. As we said earlier, he did not receive notice in the mail of the case. He does seem to be interested in closing out this case based off of looking at his prior records. He does have priors. However, that indicates that he has closed out cases before. He does come to court. And it's our position he's not a flight risk.
Okay, and
No objection to that. That's prior to 1997.
all right, RORs on the again, setting aside the bench warrant for the 97 case and an ROR on the new case number.
What's the bond for the bench warrant? How is he being released?
ROR,
So both cases are, Judge?
yes. And I'm going to read a stay away order from case number 97. You are to stay away, I think it's the same Walmart, from the following address, 3200 Northwest 79th Street, Walmart. Okay?
We have Mr. Glover, number 40, page 12.
Judge, I have Mr. Glover here with me. He does not need the assistance of the Spanish interpreter.
Information from him. Okay, Mr. Glover, you're being charged with first degree misdemeanor trespass property after warning. Any probable cause argument?
Judge, no probable cause arguments. We'd be asking for an ROR at this time. Looking at the record in front of me, it does not appear that Mr. Glover has any local priors. Being such, we would ask for him to be ROR'd with a date certain.
No objection, Judge.
All right.
He's being RR, Judge?
He's being ROR'd. The permanent address is unknown. Is he homeless?
Yes, Judge, he is homeless.
Do you receive mail anywhere?
Did you get it at Camilla's house?
Camilla's house. I can get at Camilla's house.
Okay, Camilla's house. Otherwise, either way, I'm gonna give you the date now, September
Yeah.
10th.
Okay. I can pick it up there, right?
No, you're getting notice now.
You're getting notice now from me. Okay,
Oh,
I'm gonna give you this.
Show up in.
September 10th, 2025 at 8:45 a.m. in courtroom 6-8. You have to appear at that hearing. Okay? And the stay away order, no, is there a stay away order in this case?
No.
All right. Thank you.
Have a good day.
Sorry. Who's next?
500 for Mr. Glover, Judge?
No, Mr. Glover was a ROR.
Thank you.
Any past defendants or on the next on calendar?
Next on calendar, it should be Hernandez Alfie.
Do you have a Lehman, corrections? Jason Lehman?
Going to pass, Mr. Lehman.
Oh, no.
Judge, we have Mr. Andre Bacon here. It is on page 9 or number 29 of the list today. And he will not need the assistance of the interpreter.
Okay, Bacon. Okay. Andre Bacon. Let's see. You are being charged, sir, with the first degree misdemeanor on trespassing property after warning. Any probable cause argument?
Judge, we do not have a probable cause argument at this time. We would just be asking for Mr. Bacon to be released on his own recognizance and given a date, sir, or apologies, he does have an address. So we would just be asking for him to be released on his own recognizance, Judge.
Okay, Mr. Bacon, is that your address?
Yes,
16350 Northwest 41st Avenue?
Yes,
Is it a house or an apartment?
a house.
Okay,
It's a house, Judge.
all right. And state, any argument about ROR? I think that was a request from Public Defender's Office.
We would be objecting and asking for the standard bond. This year, in January, he was convicted of another trespass in an area similarly to the Miami Gardens. There was another Marathon gas station. So for that reason, we just be asking for the standard bond given the repeat events.
Okay. How long has Mr. Bacon lived at that address or in Miami-Dade County?
Judge, he's lived at that address and in this county his entire life. Mr. Bacon does come to court. As his prior show, he does close out his cases. So it's the defense's position. He's not a flight risk. All of his priors are.
It's fine. ROR.
Thank you, Judge.
Stay away order. I'm going to order you, Mr. Bacon, stay away from the following address area: Marathon Gas at 16701 Northwest 42nd Avenue, Miami Gardens, Florida.
Judge, I'm here with Mr. Hernandez. He's on page 8 of your calendar or number 28 in the order.
Is Alfie Hernandez?
Yes, Judge.
Okay, Mr. Hernandez, you are being charged here today with a first degree misdemeanor for petty theft between $100 to $750. Probable cause argument.
Judge, no probable cause arguments. We'd be asking for the TAP program in this case.
State.
Given the fact that this even have no objection to staff program.
Okay,
Judge, I apologize. I can't hear the state.
no objection to the TAP program.
Thank you.
TAP. Any alternate bond amount?
Judge, the standard bond in this case is $500. We'd ask for $250 alternate bond.
State.
No objection, Judge.
$250.
That was with tap, Judge?
Yes, tap alternate $250 bond.
Thank you.
Thank you. And obviously probable cause found. I don't know if I said that or, oh, stay away order. I'm ordering the defendant to stay away from the following address: 19501 Northwest 27th Avenue, Miami Gardens, Florida, 33056.
Next on calendar or a recall?
Say it again, Marcus.
Next on calendar or recall?
Mr. It should be Hale, next on calendar.
Hale.
Yes, I have Mr. Stephen Hale with me right now.
He's next on calendar. I guess. What happened to Mr. Gay?
The bond out.
Bond out. Okay.
Yeah.
Here. Put it here too.
Yes.
Mr. Lee's later, or Lehman. Mr. Hale. Okay, Mr. Hale, I understand you are being charged with multiple misdemeanors today. First degree misdemeanor for threatening bodily harm on elected official, family member. First degree misdemeanor resisting officer without violence to his person. Second degree misdemeanor disorderly intoxication, and second degree misdemeanor petty theft. Any argument on probable cause?
No probable cause arguments, Judge. We'd just be asking for, we'd be asking for ROR or, in the alternative, the TAP program. Mr. Hale has, does have priors. However, it's the defense's position that he is not a threat to the community. Furthermore, he's not a flight risk in this case, Judge. We'd ask for either ROR or TAP.
The state would be objecting to the ROR, specifically as to that he's not a danger to the community. His most recent charge, which was closed not last month, was indecent exposure and criminals. So for those reasons, he will be asking for a standard bond, especially given the nature of the charges that are here today.
What were the charges recently?
Indecent exposure and criminals. It closed out July 21st, 2025.
So, okay, resisting officer without violence, with violence, right? Third degree felony?
Correct. And the standard for the bonds is that he poses a risk of physical harm, which, while we understand indecent exposure and criminal mischief might be concerning to the state, it's the defense's position it shouldn't be considered as heavily as it would had it created a concern for physical harm, Judge.
Judge, he does have a prior as well of resisting with violence, which he was convicted for November 2024.
Right, and this particular charge is about threatening a law enforcement officer's family, correct?
Yes, Judge.
Okay, so threatening harm.
Correct, Judge.
All right, what are the, you were asking for public defender?
Judge, we'd be asking for him to either be released on his own recognizance with a date certain or to go into the TAP program.
State?
Again, we'd be objecting to both and asking for standard bond on all the counts.
Standard on threatening is 1,000 and resisting 500.
And TAP, remind me, TAP, is he released, or is TAP,
It's alternate bond, Judge.
right, and the TAP program, we're releasing him to the homeless program, correct?
It's not homeless, it's TAP within jail. They come to see if he needs services.
Okay, I'll order TAP with the alternate, bond standard amount. And a stay away order.
George, you said tap with standard alternate bonds?
Yes.
Judge, I have Mr. Puebla here with me.
Did Mr. Hale, I was supposed to read or was going to read a stay away order.
I apologize, Judge. Mr. Hale was taken from the room.
Can we bring him back?
I'm asking now, Judge.
Can you start on this, the next offender, Judge? We're gonna get Mr. Hale back.
Oh, okay.
Already en route to the unit, so they gotta go get him.
Okay. Julio Enrique Puebla.
Yes, Judge. He will need the assistance of the Spanish interpreter.
Julio Enrique Cueva, yo le voy a servir de intérprete.
Okay, Mr. Puebla, you've been charged with first degree misdemeanor, a bench warrant for failure to appear for a petty theft.
Señor Puebla, queda usted arrestado en base a autos de detención por falta de comparecencia ante un cargo de hurto menor.
And the new case is a local ordinance violation of consuming alcohol near a store or selling alcohol.
Y el nuevo quebrantamiento de ley se trata de quebrantar una ordenanza municipal de consumir o vender alcohol en las inmediaciones de una tienda.
Do I have argument on either of those?
¿Argumento por parte de alguno?
Judge, we have no probable cause arguments for either of the cases. We'd just be asking for Mr. Puebla to be ROR'd. We understand he's been issued a bench warrant before. However, defense believes that should be entitled to ROR in this case.
Su señoría, no tenemos ningún argumento respecto a la base legal del cargo. Sin embargo, queremos solicitar que le otorguen libertad bajo palabra. Ya él ha tenido órdenes de arresto por lo mismo, pero pensamos que se le debe otorgar nuevamente libertad bajo palabra.
State.
Judge, we would be objecting to the ROR given the bench warrant in his case of his previously and also in his prior, as recent as 2024, he has one resisting without violence and also one felony weapon possession by felon. So for those reasons, we'd just be asking for the standard bond.
La Fiscalía manifiesta que tiene varios antecedentes penales y solicitamos, por tanto, monto estándar. Your Honor, I couldn't hear all the charges that the state was saying. I don't know, they're not close to their microphone. So I did like an ambiguous statement.
As recent as 2024, he has been convicted of a felony in possession of a weapon, as well as resisting an officer without violence. So for those reasons, we would be asking for the standard bond amount. And also for the fact that he has a bench warrant open.
Basándonos en que tiene la orden de arresto pendiente y que tiene antecedentes penales recientes, tan recientes como 2024, tenencia de arma como delito penal y resistirse al arresto sin actos violentos. Por esos tres motivos solicitamos el monto estándar de fianza.
Okay, I'm gonna convert the bench warrant to a bond of $1,000. That's what the warrant was issued, and I didn't hear any defense or excuse for it, and obviously shows that he's won't appear at court. And I'll ROR on the alcohol consumption.
En cuanto a los autos de detención, lo voy a convertir en monto de fianza, ya que los autos de detención eran de 1,000, va a quedar en 1,000, y así aseguramos que se presente. Además, la defensa no ha presentado ninguna excusa ni motivo. Le otorgo libertad bajo palabra en el cargo relacionado con bebida alcohólica.
Judge, any stay away order in this case?
I don't see one. Hold on. This is no stay away order for this case.
Was that standard bonds from Mr. Julio?
Yes, I converted the bench warrant to a $1,000 bond.
The other was ROR.
And Judge, I do have Mr. Hale here to be spoken to about the stay away order in this case.
Okay. Give me 1 second. Mr. Hale, you've been ordered to stay away from the following address area: CVS at the located at 3349 Pan American Drive. Okay.
Yes,
Thank you.
Good.
Hale? Hale, yes.
Martinez Christopher refused court, reset for tomorrow.
What about Mr. Armani Kendrick?
Judge, I have Mr. Gabriel Spain here. I believe Mr. Kendrick bonded out.
Your Honor, Joanne Hennessy for the City of Miami Beach regarding the Gabriel Spain. There's just a misdemeanor included at this time. It is the state's case.
I don't know if it's Ron. Give me a second. Give me a second. Did Mr. Kendrick bond out?
The bond
as
out.
represented? Okay, Mr. Spain. Mr. Spain, you are being charged with 3 violations, 2 first-degree misdemeanors, 1 for cannabis possession, 20 grams or less, and 1 for drug paraphernalia, possession with intent to use, and a local ordinance, public property conducting business. Any probable cause arguments from the public defender's office?
Judge, no probable cause arguments. We'd just be asking for him to be released on his own recognizance. He's lived in Miami his entire life. And as far as the defense is aware, he has no priors. He's not a threat to the community, nor is he a flight risk.
They.
We would just be asking for standard bond.
And what are the standard bonds for this?
Bond,
1,150. Wait, no, that's Martinez. I'm sorry.
It's 500 on the M1 cannabis, 500 on the M1 drug therapy manual, and 150 on the ordinance.
This is first defense.
Judge, as far as the defense is aware, I don't see any priors on the record right now. The allegation basically stems from the officer saying that Mr. Spain was selling fruit, and that's where the arrest comes from.
Selling fruit?
Selling fruit.
Without a
That was the allegation on the arrest form without a permit. But
Your
again,
Honor.
would ask for ROR.
Go ahead, Ms. Hennessy.
On the arrest form, I mean, it's called a lemon Spanish limes. And it says he had 40 bags of Spanish limes, the Mamocillo, which I believe is an alcohol.
Judge, the
And
arrest
it
form
is-
says a bag of fruit.
If I could have a second, Your Honor. The violation is still about selling product without a permit. And he's selling, in addition to the drugs or the Mamacilla, he has other things, but he's selling items on the beach without a permit, and that is a violation of the city ordinance.
Okay, and ROR on all three counts. Do you have an address, Mr. Spain? Is that your address?
Yes.
Okay.
No, oh, Judge, he's informed me that that is not his address.
What is your address?
7140.
7140
Give me 1 second. 7140
Northwest, oh, apologies.
Northwest.
Northwest 20th Street. Sunrise, Florida. And Judge, he's not entirely sure of the zip code. He believes it's at 33311.
House or apartment?
House or apartment?
It's a house, Judge.
Okay. All right, ROR on all three counts.
Thank you, Judge. Judge, any stay away order in this case?
I didn't receive one, I don't think.
Thank you, Judge. I just want to be sure to make sure we're not taking him back.
No, I appreciate it. Thank you.
Definitely.
Mr. Bennett is next. Oh, sorry.
Judge, I believe we may have to pass for Mr. Bennett. The next one we have is Mr.
Are we passing or is he refusing?
Gonna pass.
Okay, it's passed, Mr. Bennett. Justin Davis next.
Bond out.
Bond out. All right.
Gomez Castro, bond out.
Give me a second. On both, I have two files here. I guess he bonded out in general.
Judge, I do have Mr. Mauricio Perez here with me.
Oh, there's three, sorry.
He's on page 12, number 41. And he will need the assistance of the Spanish interpreter.
Interpreter present.
Okay, so, um, is he here later today for the third degree felony? Grand theft?
Lo vamos a tener presente para la audiencia de primera comparecencia de delitos penales, hurto mayor.
Judge, I believe corrections has confirmed with me. Yes, he does have the felony on for later today. We have no PC arguments, and we'd just be asking for the bench warrant to be modified to a $1 bond in light of the felony.
Sí, su señoría, me han confirmado el personal de la cárcel que tiene que presentarse a las audiencias por delitos penales más tarde el día de hoy y solicitamos que convierta la fianza a $1 ya que tiene que encarar el tribunal penal.
Hey.
Sorry, which case was that?
Mauricio Enrique Perez, he's here for a bench warrant, and there's also a third degree felony that he's coming back on later today.
That's correct.
And I see he may also, it looks like this bench warrant's attached to a no valid driver's license case, Judge.
También tiene un caso de no portar licencia válida.
And also drug paraphernalia with looks like possession injectable or injections, I don't know.
Y también tenencia de instrumentos para el consumo de drogas, parece que es una jeringa, una inyección.
So the, okay, so this was all part of the same, I'm just a little confused because we have a bench warrant on the B-24 and that's associated with the F-25.
I assume they picked him up on the F-25 and they have a bench warrant, so they brought him in with the bench warrant, but.
La fiscalía está un poco confundida porque la orden de arresto es a partir de un caso que es B-24, pero el auto de detención está relacionado con el caso F-25.
Yeah, you bench, right. So. No, the state would be asking for standard bond on the NVDL, the no valid driver's license, and the B-24 case, which is also a bench warrant. So the state would be asking for $1,000 on the misdemeanor paper file and $2,500 on the NVDL, the no valid.
La fiscalía solicita montos de fianza estándar, es decir, en el caso B-24, $1,000 y el de no portar licencia válida, $2,500.
The license is a $2,500?
Por lo de no portar licencia válida pide $2,500.
Standard bond on my side says $150.
Los montos de fianza en mi material indican 150 cada cual.
No, $150 for the no valid driver's license.
$150 para la acusación de no portar licencia válida.
And the bench warrant was for $1,000 and it's a $1,000 bond.
Y autos de detención se había fijado $1,000 para esa orden de arresto y se convierte al monto de fianza en $1,000.
There's 2 counts.
Dos cargos.
The petty theft as well.
Tenemos hurto menor también.
Not sure why I can't even look up this no valid case on my system.
No sé por qué no me sale en el sistema este nuevo caso de no portar licencia válida.
It's just asking for the standard as listed, Your Honor.
Solicitamos monto estándar, su señoría.
Public Defender's Office, why should I depart from the standards?
Yes, Judge.
¿Por qué me indica la Defensoría que tendría yo que cambiar los montos de los que ya son estándares?
Judge, we'd be asking for the $1 bond because in this case, he does have the felony hold, which he will be held on even past paying the bond in this case. But furthermore, without knowledge of the allegations in the felony case, seeing that that is a grand theft, it's still the defense's position that he is not an actual physical danger to an individual in the community. He has come to court in the past, or apologize. He does have the bench warrant. However, we would still say that he has lived in Miami. He has told me that he's lived in Miami for several years now. He's a member of our community, and he is committed to coming to court and closing these cases. And he's not a physical threat to somebody or physical risk of harm.
And Your Honor, if I may, despite all of that, the defendant still does not show up to his bill dates.
Okay, I'm gonna issue standards and we'll address the grand theft.
May the interpreter relay, Your Honor?
Yes.
La defensa solicita que le bajen los montos de la fianza porque aunque pague su fianza, igual va a quedar detenido con el caso abierto ante el Tribunal Penal. Y por más que tiene esta acusación de hurto mayor, él no presenta peligro para nuestra comunidad, lleva años viviendo en Miami y está comprometido con llegar al final de sus juicios y causas que tiene que encarar. Nos indica la fiscalía que de todas maneras él tiene costumbre de no presentarse. El señor juez otorga montos estándar de fianza.
What is the standard? I'm converting the bond, the bench warrant to the standards for their offense on this one. What's the first degree misdemeanor standard for drug possession, paraphernalia, and injection?
Quisiera saber cuál es el monto estándar para el delito por medio del cual tiene la orden de arresto, el de tenencia de instrumentos para el consumo de drogas o inyectarse.
Paraphernalia is 500, Judge?
Instrumentos para el consumo de drogas es 500 el monto estándar.
That's right, Your Honor.
Okay, and what's the petty theft?
Y el hurto menor,
150.
150.
Okay, so for the no valid driver's license, 150.
No portar licencia válida, 150.
For the bench warrant, again, the bench warrant issues for drug paraphernalia, $500.
La acusación de tenencia de instrumentos para el consumo de drogas, $500.
And for petty theft, $150.
$150 por hurto menor.
All right, and I'll address the felony later today.
Más tarde vamos a abordar el caso penal. Gracias.
Hopefully I got it right.
You can find that in some.
Judge Corrections has asked me if we can call Mr. Tony Harris's case. It's numbered at number 18 on the calendar today. And I'll get you a page number for that. We would be waiving his presence for this.
Okay. This
Your Honor, Joanne Hennessy for the city of Miami Beach.
all right, this is a open container, possession, serve, sell, Miami Beach ordinance. Any probable cause arguments?
No probable cause arguments. We would just be asking to either release him on his own recognizance, Judge, or release him to the or release him on pretrial services. He does have substantial priors. However, as far as I can tell, it doesn't mean that he does show up to court in Miami-Dade County. It would indicate that he's not a flight risk. And from looking at the arrest form, he is a resident of Miami-Dade County, so a member of our community. I think ROR would be appropriate in this case, Judge.
We have his list of priors. Do we have his list of priors here? Miami Beach.
Your Honor, I'd ask for standard bond in this case. Mr. Harris has a adjudication from July 23rd for trespass. Last year in June, a false name after arrest. The prior year burglary of a dwelling. And then there's several priors to that, but just request standard bond.
What is that standard bond?
150.
Okay, pretrial services or standard bond of 150?
Pretrial alternate?
Yes, pretrial alternate 150. Pretrial services or alternate 150 bond.
Bradford. Here, come stand next to me. How long you live in Miami, Mr. Bradford?
I can hear you.
Apologies, Judge. I do have Mr. Bradford here.
Okay, Mr. Bradford. There's a bench warrant for what's the bench warrant is for failure to appear on June 3rd, 2025 for report with Judge Urbistando based on an underlying charge of driving with license suspended knowingly. The bench warrant is for $1,500. Any argument on that one?
Yes, Judge. I've just spoken with Mr. Bradford. I'd like to inform the court that the reason he received the bench warrant is he was placed on calendar to accept a plea in his case, and he was Baker acted prior to that, which caused him to miss court because he was being held on the Baker Act, Judge.
State. Is there any Baker? Where were you Baker acted? Hospital?
He was at Jackson Hospital, Judge.
On which case?
The AL27QAE. That's the bench warrant.
Q AL27Q
AE.
AE. What date was he Baker acted?
On what date were you at Baker acted?
Judge, Mr. Bradford and myself are not sure of that. Typically, I would be able to get those records from the hospital if I had some time.
On the data. Was required to appear for fingerprints on June 3rd, but there are no notations.
Judge, I can't hear anything that.
This is the clerk's office talking to me. He was supposed to report for fingerprinting on June 3rd, 2025, and our system's not reflecting any notations about any sort of, I guess, Baker acting.
And Judge, if I may, on May 28th, 2025, he did accept the plea in Judge Urbisando's courtroom and told to report in person. Then on June 3rd is when he failed to appear. So unless he got Baker acted in those 5 days, the state would be objecting to that argument, given the light that we have no evidence of these medical records.
And Your Honor, just important to note here, he was picked up on this bench warrant. Bench warrant for driving while license suspended was picked up driving.
Okay. I have no proof of the Baker Act, and that occurred on that particular date. And again, Mr. Bradford was driving while license suspended and unknowingly did so again. So I'm going to convert the bench warrant to the amount of the bond, $1,500.
Judge, I apologize, but if the fact he was driving was relevant in this case, because he's not being charged with a DWS again. So it seems like he may have gotten a good license since then, possibly. If he's not being charged again with it. I do understand the court and the state's concerns, but I would just like to note for the record that if driving was an issue in this current instance, there would be a new charge for that.
His driving privileges are suspended.
Yeah, he still has license suspended. Oh,
okay,
and,
Judge.
and just for the record, his driving privileges have been suspended since 2021.
Okay, so again, for that, I'm just going to convert it to the
bench warrant.
yes, $1,500. There's also the misdemeanor for false name identification after arrest. Any argument on that?
Judge, no probable cause arguments. We would just ask that this be set at a $1 bond.
Okay, what's the standard? $500.
Your Honor, the standard is $500.
Right, which would I be adding to $1,500 bond? So, or is that the state wants to do that? The standard?
Standard bond, Your Honor, please, for the false name after arrest.
Okay.
I think it's safe to assume, Your Honor, that the false name is because he knew that he has suspended driving privileges and a warrant for his suspended driving privileges. When he was pulled over, he then gave a false name.
Any priors, anything else? My consideration?
Yes, Your Honor, we have.
Recent priors?
Correct.
We have long history, but they're pretty old, right? 2014 is the most recent, other than
Yes, sir. I mean, he does have a 2022 that I do see, Judge. However, his records indicate that he has completed probation. He's had it modified, revoked. However, he has done probation, which means that he is able to continue to show up for things. Defense's position is that he's not a flight risk.
All right, well, I have my concerns about that. Again, I don't know, today, right now, what I know, I don't have in the system, should be marked there. And I have no information about that. He was also aware that he was supposed to appear on that date, and I haven't heard anything about any attempts to contact the court to explain his not appearance for to Judge Restando to reschedule the reporting obligation. It's now been 2 months since that reporting obligation, so I'm assuming that he was not Baker acted for 2 months.
Judge, he is telling me that he did reach out to the court after he was released from his Baker Act to try to set aside the bench warrant.
Has their hearing been scheduled or anything like that that would suggest that there was a communication with the court?
But I was actually in that boardroom with Judge Restando, and I can say that it has not been years since then.
Yeah, so it hasn't been reheard, but any efforts?
Judge, so he is telling me that he did schedule a hearing for motion to set aside bench warrant, and he received cancellation notices on 2 different occasions for those hearings. The defense does not have more information in front of them. However, based off of what he's been telling me, it seems like he has been making a good faith effort to get this taken care of. It's the first time he's failed to appear in court.
Shows no ruling on the motions.
But they have motions?
There was motion, but there was no ruling, and since June, nothing else happened.
And Your Honor, for the record, it is not the first time he's failed to appear from court. He failed to appear on this series of this DWLS plus 2 infractions, which he picked up in March. And he also failed to appear on his prior collection of criminal and civil infractions collected on February of 2024. So this is a repeated history of failure to appear in court despite court orders.
Okay, I'll just, the $1,500 for the bench warrant and standard for the where is it?
DWLS.
Fake name, the false name,
First name, 500.
$500.
No, that's from the previous defense.
Oh, I was like, I didn't order
Can't
that.
catch up that fast.
Sorry, I didn't order that.
It's fine.
Oh, hold on, this is,
Judge, I'm here with Mr. Merced. How you doing?
hello, sir. All right, we have multiple issues here. A $3,500 bench warrant for failure to appear, I suppose, with the drivers based on driving with license suspended charge. I really don't have a lot of information about that on my end. State, do you have any information on that other than I have a BW? Oh, no, I have it here. Sorry, it's separate documents all over the place. Not your fault, just in case. Not Marcus's fault.
Yeah.
Okay, the bench warrant failure to appear on February 24th, 2025 for an arraignment with Judge Alvarez Zane. And again, the driving with license suspended knowingly, that's case AE 5F MDE. Any probable cause arguments or any arguments against the bench warrant?
Judge, no probable cause arguments for the new cases. I did speak to Mr. Merced, and he did say that he was unaware of his court date when the bench warrant was issued. We would argue that it's not willful. If the court is not inclined to vacate the bench warrant for that reason, or to set aside the bench warrant for that reason, then we would ask for ROR or the pretrial services and the alternative on all the charges.
Right, Your Honor. So being unaware of your court date is not a valid excuse for not showing up for your court date. If the defendant or the defense has not submitted that the defendant altogether forgot that he has been charged with criminal charges, and it is incumbent on defendants to update their addresses and to check the clerk of court's websites for any sort of subpoenas and notices for future court hearings. This is criminal court. So that is not a valid excuse for saying that it's not willful. It certainly is willful.
Okay, so let's say I convert the bench warrant to a $3,500 bond. What is your arguments on the others? On the other 1, 2, 3, 4, 5, 6, 7, 8 different charges for which he's here today?
We're asking for standard on all of it, because he has, Your Honor, to complement the resisting without violence bench warrant, the defendant has failed to appear for criminal traffic charges since 2021. He has outstanding criminal traffic charges from 2021. This is somebody who habitually does not show up to court.
Public defender?
Judge, we would be asking if you were going to transfer the bench warrant into a bond, we would be asking for either below standard bond or $1 bond in the other charges. The point of bond is to ensure that they're able to come to court and to keep them from fleeing if that's at risk or being a harm to the community. All of these charges are that the defense sees in front of me right now are nonviolent. And even though he may have a history of bench warranting, it does not mean that he is completely going to ignore court. It seems like he just doesn't receive the notice in the mail, and once his address is updated, it's defense's position and Mr. Mercai's position that this
Is he employed?
Yes, Judge, he's self-employed.
Self-employed, what does he do for self-employment?
Judge, he does landscaping.
And Your Honor, if I may, this defendant was picked up driving while his license was suspended. His license has been suspended since 2021. And so we're asking for standard bond.
That's fine. Look, part of I understand, and the public defender's office generally likes to focus on 2 of the 3 factors for the bonds and the fact that there are standard bonds. One of the factors that kind of gets overlooked is, again, the failures to appear or the trying to secure a person's attendance in court proceedings. If there's a bench warrant for $3,500 issued by Judge Alvarez Zane, who I have the pleasure of knowing as someone who doesn't seem eager to raise bonds and doesn't seem eager to punish people in that sense. So I view it as she's aware of a failure to appear and raised it more than she, I would believe, generally does. So I'm going to order the standards for the other cases and $3,500 converting the bench warrant to secure his attendance.
So all the bonds say the same, Judge.
Yes. I'm going to write this out now.
Yep. As to each count.
Judge, is Mr. Mercai needed for anything further? A stay away order?
Count 1 is 500.
Give me 1 second. I don't think we have a stay away order.
No. Count 1 is 500. Count 2 is 150. Count 3 through 8 is $500 each.
Okay. And the other paper has the conversion information.
You're gonna pass Mr. Williams Dante. The next defendant is Marcel. Mr. Marino was Ward D, reset for tomorrow.
Who? Williams?
Marino Augusto. He's in Ward D, reset for tomorrow. We're passing Mr. Williams Dante, Judge.
Okay, passing him. All right. Is Mr. Bennett here? Nicholas Bennett, we passed him earlier.
No, Judge, I have Mr. Santiago Acuna Milan next to me right now, and he would need the assistance of the Spanish interpreter. He's number 48 on your list.
We're still passing Bennett.
Marino Augusto, you said what are we doing with Augusto? Marino?
He's in Ward D, reset tomorrow.
Page 4.
Okay. Can you put Ward D there? Is it B or D? David. Word. Oh, D. Oh. So who do we have here now?
Mr. Acuna Milan.
Yes, Judge.
He has an immigration hold as well.
And he will need the
California,
assistance.
Milán, yo le voy a servir de intérprete, manifiesta el personal de la cárcel que tiene orden de detención por parte de la entidad migratoria.
Any probable cause argument?
Argumento en cuanto a la base legal, señores.
Judge, no probable cause argument. At this time, we'd be asking for a $1 bond in light of the ICE hold.
No queremos argumentar nada, su señoría, pero en vista de que hay orden de detención por parte de migraciones, solicitamos que le imponga el monto de fianza en la cantidad de $1.
Date.
No objection, Your Honor.
No hay objeción por parte de la Fiscalía.
$1 bond.
$1 monto de fianza.
Thank you.
Gracias.
Officer Pereira, how you doing?
Good afternoon, Judge. I'm sorry to interrupt. I apologize. I've been on since 10:40 this morning. I received a call from the state yesterday, and they told me to log in at 11. Reference a discrepancy on the A form. It was just a matter of provide the date of birth of the victim, and I was able to give the state the victim's driver's license with the date of birth. So I don't know.
That's felony, isn't it?
Yeah, it's the last PC here.
Yeah, it's the last PC hearing of the day, and it's a felony, so we're on misdemeanor traffic now. Still.
Oh, okay, so do you more or less know what time it's gonna be more, so okay.
I mean, I wish I did. You know, there's an argument on each one of these cases, so.
Okay, no problem. I'll wait. Thank you, Judge. Appreciate it. Sorry about that.
Would you mind if I took the officer's phone number and I gave him a call and see?
Officer Pereira, would you give your number to?
I appreciate it. Thank you so much. Yeah, sure. Mhm.
Just send me an email on top of the last one you sent me with your number.
Okay, no problem. Thank you.
Thank you.
All right, thank you.
Thank you.
Who do we have?
Yes, Judge. We have number 49 on your list, Mr. Desmond McKinney.
Who's also known as Melvin Rivers?
Yes, Judge.
Okay, so multiple, right? We have
Yes.
a driver with driving with license suspended knowingly. Reckless driving bench warrant for $3,000 for failure to appear for a trial before Judge Gonzalez Cuervo.
And he also has an AC no bond hold.
AC no bond hold. It's an additional charge. No bond hold. Is that what it is? AC.
He was booked on the same day, Judge, not new. He's held no bond on the AC.
Okay, what's the AC number or case number?
F-25 1218.
You want to do a felony hold on
Yeah, so I'll do a felony hold.
it? Okay.
All right.
Thank you. What's his defense?
Yeah, do we have any probable cause or any sort of arguments?
Judge, no probable cause arguments. We'd be asking for a $1 bond in this case in light of the no bond alias Capius and his felony case.
Alias Capius. All right, I heard that yesterday for the first time and did not commit it to memory. All right, so
To pick up one.
oh, it's pick up article. Thank you. No one told me that yesterday. All right, so okay, probable cause found. I don't see yeah. Yeah, and it's a no bond hold. So okay, so dollar bond for the remaining ones, including the That's all right.
Each case $1?
Yes,
That's
given
one
the
WE and DE.
WEDE, I think that's it, right? Yes, WE and DE. And a felony hold given F 25-1218.
He's already been held, no bond.
Yeah, yep, no bond. All right, good. Thank you.
Judge, I'm here with Mr. Anthony Bush.
Okay, so Mr. Bush, what does he have? Accident, false report. ALC 9598. Any probable cause argument?
Judge, no probable cause argument. We'd be asking for an ROR in this case. He has no priors that the defense is aware of. And he has lived here his whole life. He has a stable address, work, and family here. He's not a flight risk. And no prior failure to appear is on top of that, Judge.
State.
Just give me a moment to look up. No objection.
All right, I was inclined to do that anyway. ROR. But please remind him that, as he's heard from other people, well, I don't know if he's heard, but ROR, he's promising to come back and to appear at other proceedings. Failure to appear is going to make things worse, not better.
Yes, Judge, I will tell him that now. Judge, we have a case that we had passed earlier, Jason Lehman. It's number 27 on your calendar. I'll get you a page number for that now.
Your Honor, Joanne Hennessy for the city of Miami Beach.
Okay, violation of two local ordinances, Mr. Lehman, related to prohibited camping and consuming alcohol or serving alcohol.
It's drinking in public, Your Honor.
Okay, thank you. Drinking in public. The A form is more specific than the other form I was looking at. Thank you. All right, any probable cause arguments?
Judge, no probable cause arguments. We would just be asking for Mr. Lehman to be ROR'd and given a date certain, or in the alternative to be placed in the TAP program. His priors are all nonviolent. They're the defense is only aware of camping prohibited, alcohol consumption, and park after hour priors. He's not a threat to the community. Mr. Lehman has informed me that he's lived here for 3 years. He is a part of our community. And he is not a flight risk. He has nowhere else to go besides South Florida, so he's not going to flee South Florida.
City of Miami Beach.
Yeah, Your Honor, just to be clear, Mr. Lehman has had 5 adjudications or 6 adjudications since September, including drinking in public, camping, and park after hours, all violations of Miami Beach ordinance. I would just ask that this, in this case, the standard bond be assigned.
Okay, I'm gonna do tap, and the alternative, standard bond. And it's 150 each.
It is, Your Honor.
Obviously, probable cause, giving no argument on that.
And Judge, before they take him, is there a stay away order that is going to be?
There is a stay away order. Thank you for asking. The stay away order. I'm ordering you, sir, to stay away from the following address, 306 Lincoln Road. This order shall remain in effect until case is closed, modified by the court, or for a period of 6 months. Thank you. This is
Judge, this is Mr. Nicholas Bennett. He's number 37 on your calendar for today on page 11.
Okay, Nicholas Bennett, you were arrested and charged with first-degree misdemeanor for trespassing property after warning. Any probable cause argument?
Judge, we don't have a probable cause argument at this time. We'd be asking for tap with an alternative bond in this case.
What's the bond amount?
Standard bond in this case is 500.
State,
That's right, Your Honor. Standard bond is 500.
any objection with tap alternative 500?
Just, there are, the Cleveland Lake Jack and grounds, collecting from them.
Excuse me?
The state
You-
would object, I'm just collecting the ground from them.
Judge, I can't hear the state's arguments. I don't know if they're away from the microphone.
So they said, and I'll tell them to get closer to the microphone. This has been a problem all day.
Thank you, Your Honor. The defendant has 13 open cases. We would be asking for the standard bond in that one.
Where are the 13 open cases though? What are they about?
There is a misdemeanor battery, felony resisting, misdemeanor battery, 2 more ordinance violations. 1, 2, 3, 4, 5 other open trespass cases, misdemeanors, another open felony battery, another open misdemeanor battery, another open misdemeanor resisting charge, and then 2 more open misdemeanor trespass charges.
And okay, the batteries are all recent and open?
I would have to look at each recent as to when the transaction happened. I would have to look at the case. I have future hearing dates coming for the most recent hearing dates on these are for September 17th. But the felonies go as far out as February of next year. And yes, and they all happen one happened in 2021, one happened in 2024, another happened, and then the rest happened in 2025.
And
So
they're violent. Are they batteries? You said batteries?
There are 1, 2 batteries. There is a resisting with violence felony charge. For these, and then another battery in Miami Beach under the ordinance. So under these grounds, Your Honor, we would be asking for an elevated bond of $1,000.
Judge, if I may, given that he has other open cases, which the defense was not aware of prior to this, we would be asking for a dollar bond in this case. Despite the behavior that the state has discussed, this current charge in front of the court is a trespass after warning. He has other battery cases, yes. However, he is being held on those cases, it would seem, and so it would seem like in the substantial interest of justice, a dollar bond would do that.
Is corrections, is he being held on any of these felony cases? Separate from this?
According to the jail card, he's not, Judge.
Excuse me, he's not?
According to the jail card, he's not being held anything but this case here.
All right, $500 bond.
Your Honor, if I may, has the misdemeanor portion of the jail arraignment calendar been completed? And it's just traffic remaining?
There's a stay away order for Mr. Bennett.
Oops.
Sorry.
Apologies, Judge.
There's Henry Diaz.
There's Henry Diaz, Miss Hennessy. I don't think Henry Diaz has anything to do with Miami Beach. Johnny who? Johnny Berger.
Berger, I saw also.
Henry
Also
Diaz and Johnny Berger refused court. Reset tomorrow.
Okay. So Mr. Diaz, as Public Defender's Office, I'll talk to you in a second. So Mr. Bennett, the defendant shall stay away from the following address. Okay, you are ordered to stay away from 860 Ocean Drive. Okay, and this is an order that will remain in effect until case is closed, modified by the court for a period of 6 months. Okay? Thank you. Mr. Diaz. All right.
Judge Wood.
Mr. Diaz, okay, so he was here yesterday. He was supposed to be here today. He's refused both days or had issues both days. So now we're on the 48th hour, or, second day of this.
Yes, Judge.
I'm appointing the Public Defender's Office. I appointed him yesterday. You are his counsel. If you can look over the A form and let me know if you have any probable cause arguments based on the A form.
Judge, I looked over the A form earlier. We don't have any probable cause arguments. We would be asking, Judge, we would be asking for a $1 bond in this case. It does look like he has other open cases and he does have priors. We think that a $1 bond would
You
be.
waiving a presence?
And yes, we would be waiving his presence.
Okay, and state, I have an NBC notation here.
No, I just don't have the case. Last name Diaz.
Yeah, Henry Diaz. He's case number M25-16650.
It's on page 4, bottom of page 4.
He's been charged with first degree misdemeanor for criminal mischief, more than $200, less than $1,000. 2025 is he's looks like he's in hearings all every day of the week. No worries.
The defense is asking for what, a $1 loan?
Hmm?
Yes.
He's homeless.
Yes, Judge.
And the reference yesterday, I believe he was behaving erratically in court. I don't know what's causing that, but I assume, I don't want to make an assumption actually, but it may be mental health problems.
He's
And
in the
he is-
forensic cell, Judge.
Excuse me?
He's been held in the forensic cell.
Okay. I don't know what that means, but
So, the state would be asking for standard bond here, just based on the priors. And based on the transactions, we're in today.
Judge, the current open cases I see are all nonviolent trespasses and petty thefts. I think a $1 bond would be appropriate in this case.
The grounds for that are exclusively because the defendant has nonviolent priors open.
No, as I stated earlier, state that he is not a threat to the community and he is not a flight risk. He clearly has priors here, which means that he does not flee court. I appreciate the state's concern, however, I believe a $1 bond is in best interest of everybody here.
I'm assuming these hearing dates, how, 1, 2, 3, 4. Several in cases. Okay.
No, I would just say that being nonviolent is necessary to not be bright line precluded from pretrial release. However, it is not sufficient alone to qualify for a $1 bond. So despite the defense's arguments, the state would be stands on its argument as to a standard bond amount, which is generous.
Judge, we would defer to the court.
Okay, $500 bond. Improbable cause found, just in case.
So, Your Honor, I
And
believe with those two resolved, the misdemeanor portion is completed, if I could be excused.
You may be excused.
Thank you, Your Honor. Good day.
Thank you.
Confirm this one was being reset, Judge.
Johnny Burger is being reset.
Yes, Judge. May I ask what page, Mr. Oh, number 21. Yes.
And why is he's refusing?
Yes, Judge.
Okay. Who's next?
Yes, Judge. We have Mr. Raul Brugo Frometa here.
And he's out on felony bond. F25 9426 Alpha.
Who is it? Verdianis?
I apologize, Judge.
We're going out of order several times today, so I've been having
Yeah.
issues.
He's
With a B?
on page 17 of the calendar. It's Brugal Frometa. First name Raul Eduardo.
Okay, yes, so he's got a bench warrant for $500 for failing to appear on 6/17/2025 for trial with Judge Nunez. He has he's reporting on 8/13 for Judge Verdianis in a felony case as mentioned by corrections. Is there any probable cause argument or argument with respect to the failure to appear on 6/17/2025?
Judge, as for the bench warrant, Mr. Brugal Frometa has informed me that he was in court that day and that he had taken, or he had believed his case had resolved. He seems unsure of why the bench warrant was placed from that day. We do not have anything to confirm this. I can look back for notes of my colleague perhaps if we have more time. However, that's what I'm being told right now.
So in your defendant's argument is that Judge Nunez issued a bench warrant to a compliant defendant.
Judge, it's sometimes it does happen by mistake. It's not something that the public defender is saying happened out of any maliciousness or intent, but it is something that does happen sometimes by mistake, where somebody who is present before the court accidentally gets a bench warrant placed on them.
No notation, it was at trial.
There's no notation in the system, and it was at trial. Defendant also has not filed a motion.
I'll be able
Judge, the warrant was just placed on the 18th, which might be why he didn't realize that he had a bench warrant on him, since he had gone to court. He did tell me he did think this case was closed out, which is why he wouldn't do any more due diligence of looking into the case further, thinking that it had closed out that day.
Bench warrant was issued the day after the trial.
Your Honor, this case is not resolved. And the defendant failed to appear on.
Was he represented by counsel,
June
Mr.?
30th. Yes, he's represented by the public defender's office.
Okay, so the public defender's office would know whether it's resolved. So to either Judge Nunez made this mistake, the public defender's office is not aware of the mistake and did nothing to correct it for its own client, and the state also made a mistake. Okay, again, based on what I'm hearing, I'm converting the bench warrant well, is a felony. Is he out on the felony? I guess he was out for the felony, and he's appearing on the 13th.
Yes, Judge.
Okay.
But we would be asking for an elevated bond. He was to government on a no valid bank driving without a valid driver's license and license. Privileges are revoked, which means he's driving on rotation.
Judge, again, we can't hear the state over here. Apologies.
Microphone, please, folks.
That we would be asking for an elevated bond. The defendant was picked up driving again with a no valid driver's license, and we do see that his privileges are suspended still. So for those reasons, we'd be asking for an elevated bond.
I'm not gonna elevate. I'm gonna turn the bench warrant into a $500 bond. I just.
And Judge, sorry, the arrest form says he was the rear occupant of the vehicle, not driving the vehicle, but.
For what?
In this instant case, the arrest form says that he was not driving, he was the rear occupant of the vehicle.
Where does it say that?
Judge, page 2, paragraph 2, contact was made with rear occupant of the vehicle, the defendant who consensually provided me his name.
The state does not see that.
Where are we looking? I cannot see this.
Judge, you may have a page missing. I have 2 pages here in front of me. I don't have a way I can share my paper with you.
What's the date of his arrest form?
Yeah, which is the date of your arrest form?
I'm looking at August 2nd, 2025. When he was picked up on this bench warrant.
That's page 2.
Okay, so he wasn't driving this instance is what you're contending he wasn't driving?
Judge, based off the arrest form, yes, I just wanted to make sure the facts were clear, since the state had said that he was pulled over in this case.
Okay, that's not impacting my decision here. My impact is that he failed to appear for a trial. And I don't, right now, off of what I'm being told, I don't believe the testimony or the theory that everyone comedy of errors led to him not to appear at a trial that he thought was resolved. Okay, so bond for that case, I'm setting it at $500.
And that's on the ALEJR9E, correct?
Yes, it is. That's all we're here for, correct?
Yes.
All right, $500 bond.
Next case.
Judge, yes, I'm here with Mr. Junior Machado Ramirez. He will need the assistance of the Spanish interpreter. You can
And
find him.
he's a fugitive from Soto, Florida. No bond.
Señor, yo le voy a servir de intérprete. Nos indica el personal de la cárcel que está prófugo de otro condado de la Florida sin monto de fianza alguno.
Okay, Mr. Machado Ramirez, you've been brought before me today on a driving with license suspended, operating while driver license suspended, cancel revoked.
Señor Machado Ramírez, le han traído ante mí el día de hoy por una acusación de conducir con licencia suspendida, revocada o anulada.
And I understand that you have from corrections a no bond fugitive issue from Soto County.
Tengo entendido a partir de los agentes de la cárcel que tiene una orden de arresto, una orden de captura por parte del condado Soto, sin monto de fianza alguno por estar prófugo.
Any argument on probable cause?
Argumento en cuenta a la base legal.
Judge, no probable cause arguments at this time. We would just be asking for a $1 bond or a reduced bond from the $150 standard.
No tenemos argumento alguno respecto a la base legal en estos momentos, su señoría. Solamente solicitamos que le dé monto de $1 de fianza.
State.
La fiscalía.
No objection, Your Honor.
Okay, $1 bond.
Monto de $1 de fianza, señor.
Next case.
Yes, Judge, I'm here with Kevin Florenz-Lenis, number 60 on your list today. He will need the assistance of the Spanish interpreter.
Interpreter present.
Okay. Mr. Flores Lenis, you have
Señor
a
Flores Lenis,
you have a bench warrant for $1,000 issued to you for failing to appear on May 29th, 2025 for arraignment with Judge Nelson.
Señor, tiene una orden de captura con la cantidad de $1,000 por falta de comparecencia el día 29 de mayo del 2025 ante la juez Harris.
You also have a traffic infraction for no motorcycle driver license. You're not being held on this one.
También tiene una infracción de tránsito que es no portar el endoso para conducir motocicleta. Sin embargo, eso no es lo que lo deja detenido.
Any probable cause argument?
Argumento en
Judge-
cuanto a la base legal, señores.
No probable cause arguments at this time. We would be asking for the bench warrant to be converted into a $1 bond or the standard bond for this charge, which I believe is $150.
Señoría, no queremos argumentar la base legal del cargo, solamente solicitar monto de fianza en la cantidad de $1 o lo que sea correspondiente al cargo y su monto de fianza asignado.
State would just be asking for the standard bond.
150 or the conversion? Okay,
La fiscalía solicita monto estándar de fianza.
Did I hear the $150 bond, Judge?
yes, $150 bond.
Thank you.
$150 monto de fianza, gracias.
Next case.
Judge,
That's all we have on calendar.
yes, I believe that's it for the county calendar.
And
Got a bunch of these. Bond outs or what's going on?
let's see. I have some cases that weren't announced. Pablo Nunez.
Bond out.
We have Cesar Marino Matamoros. It's also second case in that one. Cesar Marino Matamoros.
That's a bond out. Perez Garcia is a bond out as well, Marcus.
Okay,
Leyva Rojas, bond out.
okay.
Zambrano Carlos, bond out. Stanley Darrell, bond out. Brown Stephen, bond out. 1 second. Jackson Karan, bond out. Zacharias Hernandez, bond out. Davis Jr. Clarence, bond out.
Give it, we're a little slower than the announcements.
Say it again.
We're a little slower than the announcements. Give us a break for a second so we can catch up.
Okay, sorry.
Sorry about that.
Zacharias bond out
Yes, Marcus.
and Davis.
Bond out. Did you get Jackson Karan?
Yes.
Anybody else?
Yes.
We have Latroy Dante Williams. We passed him originally. Is he refusing?
Reset NBC.
Is there a Raul Cusco?
Cruz.
Sorry, I heard Cusco.
He's off calendar. Case was already heard.
Off calendar, already heard. Said 2025. See.
Gomez Castro was a bond out as well. I don't know if you had it already. And Davis Justin, bond out.
Judge, I just want to confirm, does that conclude the misdemeanor calendar?
It appears to conclude misdemeanor counter. Thank you very much. You're excused.
Thank you, Judge. Have a great one.
You too.
Excuse me, Marcus.
Yes.
The last defendant, Flores Linus, that was 150, correct?
Second. Correct.
Thank you.
Welcome.
Want thank everyone in the courtroom. Thank you so much for helping me. Made my life easier.
We still have felonies, right, Your Honor?
Yes, we do.
Okay, no, because you sounded like in a goodbye kind of tone.
Yeah, I was saying goodbye to misdemeanors.
Right.
Misdemeanor folks. Felonies on their way, I assume. Okay, I resisted a donut all day long, and I will now.
Recording stopped.
This is the first time you eat, Your Honor, today? I would have already dropped dead. I cannot interpret if I'm hungry or cold, etc.
All right, this is
Recording in
Judge
progress.
Perez Santiago. Everybody in the courtroom ready? Okay, Judge Perez Santiago, we're in the felony bond hearings calendar.
Raise the right hand.
All rise and raise your right hand.
You ain't gotta worry about it.
Todos de pie, levantar la mano derecha.
They're right, yes, sorry, they're right.
Do you swear affirm the testimony you're about to give be the truth, the whole truth, and nothing but the truth? Say I do.
Jura o afirma que el testimonio que darás la verdad, toda la verdad y nada más que la verdad, diga lo juro.
Yep, I think they said it. They're sworn in now. All right, can I get appearances from all attorneys?
Thank you, Your Honor. Assistant State Attorney Nicholas Whitaker on behalf of the state.
ASA Alexa Borges on behalf of the state.
Assistant Public Defender Kelly Foster.
Okay, and that's it. I think anybody else making appearances?
Your Honor, this is Jude Faccidomo. I'm here on behalf of Karen Richardson, private counsel.
Thank you. Okay, so I have some folks I'm calling out of turn, but just we can find Karen Richardson also because their counsel have been out here all day. So I'm trying to take them out of turn.
Thank you, Your Honor. Yeah, I'm subbing in for Miss Marino. She had her own baby shower to attend, so.
Wow, okay. All right, and that's can't think of something better to do.
I'm sorry, Judge, not to cut you off. Who are we taking out of turn?
I'm taking other folks out of turn as well, but I just wanted to warn corrections that I would like Karen Richardson to be taken out of turn.
You know the number on the calendar he is?
Number 12.
Number 12?
Yeah, that's after you guys.
Okay.
All right, so first person that I think is whose corrections have in queue?
Judge, we have the people that we.
Right, so you have Roberto Rodriguez.
No, Judge, we're gonna do DeMarcus Davis for the record. It was NBC reset for tomorrow.
Okay. This is Marcus Lamar Daniels or
Davis.
Davis.
Lamar Davis. NBC reset for tomorrow.
Lamar Davis.
This is an added charge for him.
Russian, what number that is? Because I took 55 all the way down.
No, I said 50. 50.
Oh, 50.
Yes. Hold on.
What was the name again?
Is it DeMarcus Davis?
Yes, Judge. NBC, this is a reset for tomorrow. Added charge.
Okay, all right, so Drake Alexander Davis. You said reset for tomorrow?
Reset for tomorrow for DeMarcus Lamar Davis.
I was tempted to ask again, but as a joke. And he's refusing, or what's the rationale?
NBC, Judge.
NBC. All right. Thank you. All right. Do you have Karen Richardson already, so I can take her out of turn, or?
No, Judge, we have a couple of out of turns, and then we can do Miss Richardson.
Okay.
This is not the right person. David.
Ah.
Is that person yours? Sorry.
Thank you. Starting off real well. Let's see. All right, Michael Miller.
Judge, can we jump? I'm sorry, he's from out of facility. Can we jump to Mr. George Lopez, number 56? Transportation is here to pick him up, so we're gonna address him. Judge Louis Lopez,
All right.
added charge.
Yes, Mr. Lopez. Okay, I'm gonna appoint the public defender absent state any statement from me otherwise. Mr. Lopez, do you need interpreter services?
Sí, sí.
Ya, señor López, el señor juez le acaba de asignar a la Defensoría Pública. Ahora escuchemos.
Okay, so Mr. Lopez, you've been charged with third-degree felony, battery by detainee and visitor or other detainee.
La acusación en su contra, caballero, representa un delito penal en el tercer grado, agresión corporal contra otro detenido o visitante.
Any probable cause argument?
Argumentos en cuanto a la base legal, señores.
No, Judge.
Okay, PC found.
Señor juez, declara que hay base legal.
Any arguments for release conditions?
Argumentos en cuanto a la liberación.
No entiendo.
I don't understand. May the interpreter rephrase, Your Honor.
Judge, he's in on another charge. You just asked for a $1 bond.
Date?
Your Honor, I apologize, we're still trying to find this one. Last name Lopez, right?
Yes.
Page 18.
Señor, lo que estaba diciendo el señor juez es solicitando si la defensa o la fiscalía tienen algún argumento. La fiscalía está ubicando su caso, esperemos.
Jorge Luis Lopez. This is second battery by detainee.
Yes.
Segundo cargo, nuevamente, de agresión corporal por parte de un detenido.
Okay, and I have two other charges, third degree felony assault aggravated with deadly weapon and petty theft, in which he will stand trial on August 25th, 2025.
Tenemos dos cargos más, hurto menor, para lo cual se le llevará a cabo el juicio en julio del 2025.
Those are the two cases I see open.
Y también acometimiento con agravantes y uso de arma mortífera. Your Honor, did you say the petty theft is in July 2025?
August 25th, 2025.
Oh, thank you, Your Honor, for aiding the interpreter. Tenemos el juicio para el delito de hurto menor el 25 de agosto del 2025.
Obviously, he's being held.
They would have no objection to the one. What did you say?
$1 bond.
$1 monto de fianza.
Okay, $1 bond.
Listo, $1 de fianza.
Thank you.
Gracias.
Sorry. Is this Michael Miller now, or am I going in order? Marcus Daniels?
Michael Miller is NBC, reset for tomorrow.
Judge, on the not brought to courts, are you appointing the public defender's office?
Yes. PD appointed for Naprata Courts. They will be reset for tomorrow. Is this Quandre Felton, or where are we going in order?
Reset for tomorrow, not brought to court.
Judge, we'll waive his presence and you can set bond.
Okay. NBC. Waive presence. Okay, and Mr. Felton's being charged with a third-degree felony battery by detainee on visitor or other detainee, so he's an added charge. What are the other charges? Do we know?
Other charges he's in custody in is a trespass and a burglary of structure, petty theft.
He's already in custody?
Yes.
Okay, and he's awaiting a report on August 15th, 2025, or reporting.
Yes, Judge.
State? Well, actually, did you ask for a bond or any release conditions?
Judge, I did not, but we would ask for a bond. We would be asking for a bond. You can set standard bond.
Okay, standard bond. What is the standard bond for this one? Let me check.
It needs to be set by you, Judge.
Yes, third-degree felony. What's standard third-degree felony? Battery and detainee. Who does?
It's up to you, Joe.
Glazer?
5,000 is standard, but she put 20,000 for.
Okay. All right, $2,500. I'll go with Judge Glazer. And a probable cause finding, of course. Felton, sorry. F 25 016 548. $2,500. No, sorry, it's the
Yes.
misdemeanors. I write it in there.
Yeah.
Felony, I gotta write it in there. Okay. Raul Cruz,
NBC reset for tomorrow, added charge.
public defender, are you waiving presence?
We'll waive his presence. And
And this is again added charge. So this is a third-degree felony battery by detainee on visitor or other detainee.
we'll ask for a $2,500 bond, Judge.
Date. How can I help you stay more organized? Because it's not your fault. We're going out of order.
Right now, we're on cruiser order.
Yes, sir. Page 17, top left corner says.
And next will be Roberto Rodriguez and then Marquise Daniels. And then we'll be taking number 12.
Raul Cruz, for the state's benefit, has an arraignment on August 7th, 2025 in case number F 25-013-673 for a third-degree felony. Looks like possession of a substance. I don't know what CONT means. And misdemeanor drug paraphernalia, injectable, I suppose.
Control substance.
Controlled substance. I'm a civil division guy. Sorry. Thank you.
We did have the misdemeanor file, so he's gonna review the prior example. We went to the
Excuse me?
You have the misdemeanor packet, so you're reviewing it now to give you an answer, but we don't have the felony packet.
He's being held, correct?
Yes, sir.
Yes, this is an added charge, Judge.
Okay, they're asking for standard $2,500. It's not standard, I guess, but it's $2,500. Judge Glazer tends to do that for these types of cases. All right. Ah. Count one, right?
Yes. Just one count.
Yes, sorry. When I sign it up here,
Please.
and I put NBC wave down here. I don't know if that matters. But... I know corrections just gave me some information about the next people, but Ward D for Marino, Augusto Cesar Marino.
Yes, Ward D is reset for tomorrow.
Okay. So Roberto Rodriguez.
Reset NBC added charge.
Waiving presence.
Judge, I am. We'd ask for Ron Rodriguez. We'd ask for 2,500.
He set for arraignment August 6, 2025, third degree felony. Also battery by detainee. And a life felony, murder second degree, he's not getting out. No bond for that, right? So what are you asking for?
You can do the 2,500, Judge.
All right, I'm gonna give a $2,500 bond. He's there for the life felony.
Your Honor, the Senate fine, but F1 will be 10,000.
This is-
Everybody didn't. Yeah. Aggravated.
Oh, sorry, I was looking at the third degree felony. All right, he's got a first degree. $10,000. Okay, $10,000. With standard. We'll get it eventually. Probable cause found. On these NBC cases, I'm finding probable cause unless stated otherwise. Okay, is it Slovius Jermaine Epps next?
No, Judge.
Who's next after Rodriguez?
We have Marquise Daniels, NBC added charge.
Marquise Daniels, NBC added charge. Okay, public defender, you waiving presence?
We'll waive his presence, Judge Wax, with standard bond.
State. His trial on August 11th, 2025, for second degree felony burglary of an occupied dwelling. See if he has anything else. He also has a second degree misdemeanor being tried that day, August 11th, for criminal mischief, and a third degree felony for battery by detainee, set for trial that same date.
They would be asking for a $10,000 bond, Your Honor.
I'm gonna give a standard bond. Is that $2,500 for this? This is the third degree felony. Who's next?
Your number 12, Karen Richardson.
Okay, Mr. Facidomo, or back, did I pronounce that right? Facidomo?
You did, Your Honor, yes.
Just to be
Okay.
clear, Mr. Daniels is 10,000.
Excuse me?
The last defendant, the bond.
No, the last defendant was a $2,500 bond.
Thank you.
All right, Miss Richardson, is she here?
I don't see her in the room, Your Honor.
I would like to make the court aware that the victim is on the Zoom platform and would like to be heard.
I see Mr. Ortega there. Okay, so, Miss Richardson,
Yes, Your Honor.
you are being, your counsel, Mr. Facidomo, is present with us. So is the victim or the alleged victim, and we are being charged with a third-degree felony for burglary on an unoccupied structure.
Who's the victim?
Karen, I'll handle it, okay?
Oh, I'm sorry.
That's okay.
I'm sorry.
Okay, so we are, again, any probable cause arguments?
Yes, Your Honor, I actually have several, and I'd like to inquire of Ms. Ortega and have her sworn in, please.
Okay. What's, are you gonna make them after you take your testimony?
Let me give Your Honor a little context here. The business in question was run and owned by Miss Richardson's now deceased long-term domestic companion, who I believe is Miss Ortega's father. This is a probate matter that somehow escalated into this criminal matter. Ms. Richardson aided in the business, worked with her. I'll refer to him as her husband, but they were never lawfully married. This is not a burglary. There's no criminal intent here. This is something that needs to be litigated in the probate division. There is an existing will that names Miss Richardson as the sole beneficiary, which is being challenged, my understanding, by Miss Ortega. Again, something to be litigated in probate, but not worthy of an arrest for a felony charge of burglary. And so Your Honor knows, Ms. Richardson's purpose for being at the business was to inventory the equipment. It's an automotive business that does repairs, and there's obviously a lot of expensive equipment that's all going to be part of the estate. The estate is going into probate because it is being challenged, so that those items needed to be inventoried. And that was her purpose for being in the business. No criminal intent to commit a felony therein, so there's no burglary.
Okay, all right, but that's not within the four corners of the A4, correct?
No, Judge, but Your Honor is aware that under the statute, you can take proffered testimony, and I can inquire of Ms. Ortega and put it into the record.
Okay. State.
Thank you, Your Honor. This court should find probable cause, and that falls for at least 4 reasons. 4 reasons is applied to the elements of this crime. First, entry without authorization. The defendant hired a locksmith to gain entry into a business that was closed and unoccupied without permission from the legal owner. The defendant was previously warned by police and a detective that she had no legal right to enter or take property due to an ongoing probate process. Second, unoccupied structure. The structure was confirmed to be unoccupied at the time of entry. No one else was inside the building during the offense, satisfying this element. Third, no assault, battery, or weapon. There's no mention of any assault, battery, or use of weapon, which aligns with the requirements in subsection 4A. Finally, Your Honor, intent to commit a crime. Ms. Richardson, the defendant, exited the building carrying multiple plastic bags and a camera not belonging to her, which was found in her car. Though she claimed she was retrieving personal property, she took items belonging to the estate, including a $400 camera. This suggests an intent to commit theft, which satisfies the requirement of burglary with an intent to commit an offense inside. This is, again, Your Honor, a scrutinization of the state's burden of production, not a scrutinization of its persuasiveness. And for these
Your Honor,
reasons,
if I
we
may
ask
just
this court-
respond. So I'm not addressing the issues of whether there's a burglary of a battery, because I don't think that's relevant for the court's consideration. Ms. Richardson is authorized to enter the premises, notwithstanding what's in the arrest affidavit, where it claims that she was trespass warned. She was an authorized entrant into the premises. She worked with her now deceased husband on the property. Miss Ortega does not own the business, nor does she own the building itself. She's not authorized to enter a trespass warning. She has no standing. Therefore, she cannot bar Miss Richardson's lawful entry into the premises. This is not a burglary, Judge. It's simply not within the intent of the statute. It doesn't meet with the criminal intent requirement under the elements. And again, if Your Honor will allow me to inquire of Ms. Ortega, I think we can flesh that out a little bit better.
Sure, go ahead.
Can we have her sworn, please, Your Honor?
Madam Clerk?
Raise your right hand.
Yeah, our hands are risen.
Do you swear affirm testimony about to give you the truth, the whole truth, and nothing but the truth? Say I do.
I do.
Can you state your name for the record, ma'am?
Stephanie Ortega.
What is your relationship to Jerry Ortega?
I am his daughter.
Okay. And Jerry Ortega owned Automotive Care, the business in question?
Correct.
And he passed away in July?
17th, correct.
Okay. And Automotive Care is the business located at 5600 Northwest 84th Street?
84th Avenue.
Avenue, sorry.
Correct.
And Jerry Ortega was in a long-term relationship with my client, Miss Richardson?
On and off, yes.
Okay. And prior to his passing away, he executed a will, correct?
That is in question. It is invalid for now.
Okay,
For the
so
time
there
being.
is a will, but you are contesting it, correct?
Correct.
And that will that you are contesting lists my client as the sole beneficiary, correct?
Allegedly.
Well, are you contesting it?
Yes.
Because it lists her as the beneficiary? Okay, so I don't.
Yes,
think
and for
allegedly
other
applies.
reasons, but yes.
Okay. And you are, in fact, the complainant in this, or alleged victim in this criminal matter, correct?
Correct.
You don't own the property at 5600 Northwest 84th Avenue, do you?
I do not, but I am next of kin.
Okay, but your next of kin again is being contested because she is the sole beneficiary in the will that you are challenging, correct?
Correct.
Okay. And you don't own any shares or are not listed as an agent of Automotive Care, the business, correct?
Correct, and neither is she.
And you are the one who told the officers that the property belonged to you and that she did not have authority to enter, correct?
Incorrect.
How did that information come to be known?
Myself and my two siblings wrote a letter to the landlord of the business, letting him know that since estate has not been opened, we would like to ensure that my father's estate and property was protected. So we wrote a notarized letter. The landlord agreed to change the locks to protect my father's estate until this has been run through Florida court and decided. Therefore, we were allowed to change the locks. And so the locks were changed and a security system was installed since Miss Richardson had already trespassed on July 19th.
And through that security system, you're the one who saw her enter the premises?
Correct.
And you're the one who called the police?
Simply Safe called the police because it was connected to the alarm system.
Okay. And again, you do not have any ownership interest in that property, correct?
I do not. Other than protecting my father's estate.
And again, we can agree that there is not currently an open estate, but the existing will does list Miss Richardson as the sole beneficiary.
I have filed and there is a local and state case number with my attorney and in the court.
Okay. And again, that is to challenge the fact that the will lists her as the sole beneficiary of the property owned.
And for other reasons.
Okay.
But yes.
But we can agree that the property inside the building is part of the estate, and that estate currently lists Miss Richardson as the sole beneficiary.
Yes, but the lease, she is not on the property lease. It is only my father.
Okay. And again, he is deceased.
Correct.
And has an existing will you are challenging, right?
Correct.
And that existing will lists Miss Richardson as the sole beneficiary of his property.
Correct.
Okay. Nothing further, Your Honor.
State?
Do you know if that will has, Mr. Ortega, do you know if that will has been filed with the city or with the city of Miami?
Can you?
Do you
From
know
my
if that will,
knowledge,
go ahead.
from my knowledge, it has not been filed. She was told on July 19th when the police first stopped her to ensure that she filed that will. That was on a Saturday, to file it on Monday morning. She told the police she would. It has since been 2 weeks and she has not filed the will.
Okay, no further questions, Your Honor. Can we address our arguments now?
Sure, Mr. Fedgedomo?
Yes, Your Honor. So again, back to the elements of a burglary, there does need to be the intent to commit a crime therein. That does not exist, so there's no probable cause for the burglary. Additionally, the person who barred Miss Richardson from the property that she had ready access to as part of the business that she ran with her then husband, or now deceased husband, had no authority to do that. She doesn't have any ownership interest in any of that property. So there cannot be a burglary. There cannot be a trespass. But for sake of argument, that is the best case scenario for the state here, a probable cause finding for a trespass after warning. For the sake of expedience, Judge will stipulate to that as for a standard bond on the first degree misdemeanor.
State?
Your Honor. Element 1, entry without authorization, right? So she was not authorized. The defense is not arguing that. The defense is not arguing to the element 2 of an unoccupied structure, or element 3, no assault, battery, or weapon, and intent to commit a crime. The defense's response to that is there is no intent. But Your Honor, obviously there's never direct evidence of intent. It's circumstantial. And taking property that belongs to this estate and clearly not the defendant is sufficient for probable cause in this case. And for those reasons, Your Honor, among many, we ask this court to find probable cause.
Right. So then the landlord, based on her testimony, then the landlord changed locks?
Judge, I don't think anybody here has any direct knowledge of who changed the
If
locks.
I can respond,
Excuse
I
me,
do
ma'am.
have
Excuse me,
knowledge.
ma'am.
Mr. Ortega?
Thank you. Your Honor, the issue here is that my client had authority to be in there simply because.
How can you establish what the authorization was? Because she's not on the lease. She has a relationship with the deceased, but she's not on the lease. And she's not currently in her will has not been filed in probate or acted on.
And again, that's
by operation
temporary
of law.
stipulation to the trespass.
Okay, but under operation of law, does the fact that the gentleman passed with a will automatically mean that she has authority to go anywhere which had his name on it?
No, Judge, but you have to take the facts as they exist, which is that she worked in a managerial capacity in this business.
And the locks were changed, correct?
I don't know that, Judge. I don't know that to be the case.
In the A form, doesn't it reference that?
Yes, it does, Your Honor.
Judge, I have no personal knowledge of whether the locks are changed or not. I'm looking at an arrest form that says there was a locksmith. If somebody changes the locks to your home, you're entitled to enter your home. You can't have somebody bar entry. And Your Honor, sorry to interrupt, but you can't infer from the changing of the locks that the locksmith barred her, or that the landlord barred her entry. That's a inference that the court's drawing from the fact that the arrest affidavit simply says that a locksmith came and allowed her entry. That's not part of the record at this point, Judge. There's nothing in the arrest affidavit that says the landlord barred her from entry. That would be required. And Your Honor's picking up on a very important point, that there's nothing in the arrest affidavit or the testimony, and the landlord's not present to say, I told her she could not enter. So that is required for the probable cause determination as well. And Your Honor, I think I can make the court aware as to the second prong, a little bit of information about Miss Richardson. She was in this relationship with Mr. Ortega prior to him passing for 15 years, did work in the business. She's a longtime life resident of South Florida. She has two daughters who practiced law in South Florida. She has no prior criminal history. This not only does it not meet the elements, Your Honor, the legislative intent of burglary is not met here. This is not what criminal statutes are used for, to litigate personal probate matters in the criminal court. Additionally, she was held with no monetary bond overnight, going on past 24 hours now. And that is outside the parameters of 907.041, because this is an unoccupied structure. It does not fall under 5A16, which is burglary of a dwelling is required to prevent a monetary bond. She should have posted bond 12 hours ago, Your Honor.
Any argument to that in response to the last point?
I'm sorry, Your Honor, exactly which point there were.
The last point about the fact that she should have posted bond 12 hours ago at 4 a.m. by 4 a.m.
Judge, she couldn't because of the type of charge. It has to be, the bond was set, so she couldn't post a bond.
And that's a misreading of the statute, Your Honor. She should have had a standard monetary bond set. This is an unoccupied structure. The statute prohibits the setting of a monetary bond on the burglary of a dwelling. I can cite for you if you'd like, Your Honor.
Charges that supposed to have standing bonds is to be set.
And that may be an issue with law enforcement or with corrections, but I think it's worthy of the court's consideration as well.
I'm being told it has a reference to a new statute.
Yeah, 907.041, subsection 5A, number 16. The new statute, which passed in 2023, prohibits the automatic monetary bond setting on what are deemed to be dangerous felonies, and then it gives you an enumerated list. But burglary of a dwelling is very different than what we have here, which is the burglary of a structure, Your Honor. And arguably not even that.
Okay. So what about the first issue about unauthorized, about the absence of evidence or in the A form about it being unauthorized? There is a reference to having a locksmith post Miranda, but does that necessarily on its face establish not having authorization or access?
With him. That she already entered the property right now because the will is not even submitted and the who is in possession of that property is in contest. By the next things would be the witness in this case. There's already been litigation proceeding where he says he was not able to consent to the property.
Can you hear Mr. Fajadomo?
I cannot, Your Honor.
The facts that we have here, simply put, is that the defendant unlawfully entered an unoccupied structure. The defense has submitted that the lawful grounds are based off of an unfiled will, which is erroneous as applied to the law. There is an intent here to commit theft because she stole property that is not hers. There's been no permission or legal right outlined by the defense. And for those reasons, Your Honor, this court should find probable cause.
Judge, brief response. Ms. Ortega has no standing here to bar my client from the property. Your Honor cannot infer simply because a locksmith was used that all of a sudden her right to enter that property has been removed. Ms. Ortega is challenging a will. She's arguably admitted to fraud here because she told the landlord via a written letter that she had a interest in that property. By her own testimony, that's in dispute. So what we have here are two conflicting positions on a will, on an estate. We do not have a criminal offense, but important for this court's consideration, for purposes of probable cause. Ms. Ortega has no standing to bar my client.
Okay, okay, I'm gonna cut this off, all right?
Okay.
So the fact that the landlord changed the locks and did not give a key to, there's nothing
We
in
don't
here.
know that to be true though, Your Honor.
Yes, well, I mean, why would you bring a locksmith out to the property if you had a key to the property?
If locks are changed, there could be any number of reasons, but the court can entertain hearsay for purposes of these hearings, but cannot rely solely upon it. Ms.
Okay.
Ortega is telling you what the landlord told her.
Okay, and I'm also reading from Miss Richardson, post Miranda comments where she said she brought a locksmith to make her a new key to the business so she can enter and retrieve some personal property. So she
Right.
didn't have access to the building, and there's nothing, she had no access. Probable cause
So if-
found.
Your Honor, if I may, I don't mean to belabor the point, but that very section that Your Honor just read negates the criminal intent. So if we're going to rely on it, right, we're going to rely on that section to say she did not have authority to enter because the locks were changed. We have to take it as a whole. And it says that she went in to retrieve personal property. That is not a crime.
But she also retrieved a
Again,
that was not hers, so therefore
Right.
that is not personal property, but.
That's fine. The record is very clear, all the arguments, all the testimony. I'm finding probable cause in the totality of the A form and the testimony, okay? Probable cause, let's move on. What's the standard bond? What's the argument of release conditions?
Your Honor, I think standard bond of $2,500 should be sufficient here from Ms. Richardson. We're not going to belabor this point any further.
What's the basis for the $7,500?
The standard level, standard bond is $20,000. Probably might have an updated, all else we got $7,500.
I can't hear them, Your Honor, but I'm curious as to
So
why.
they thought the standard bond was $7,500 and it's a misread of the statute and the uniform statutes, excuse me, the bonds. $2,500 bond.
Thank you, Your Honor. May I address Ms. Richardson just very quickly? We're going to have that bond posted, Karen. You'll be out later, early morning. Thank you, Your Honor. Thank you for taking us out of turn.
500.
$2,500 standard bond. Yes.
Thank you, Your Honor. Nice to see you.
Thank you very much. Oh, wait, Mr. Richardson, I'm sorry, Mr. Facciadomo, did he log off? Well, I didn't hear argument on this. Stay away order. She's gone. I don't know where the Facciadomo. Yeah, she's gone and Facciadomo's not there.
We can do it in division, Judge.
They'll do it in division. Next case, who's next case? And I have got the hand up by the bond hearing, TGK. What's going on there? Why is her hand up? Can I allow them to talk?
Judge, I believe this is Mrs. Cabrera. She's number one.
Yes.
So I have a bunch of cases that we haven't called. What's going on with those?
We're starting with
Tolovius Epps, Lauren Ware, Edwin Rivera, Sonia Lusma, and Mauricio Enriquez Perez. That's who I had before, Ms. Cabrera.
Corrections one.
Judge, we're starting from the top. Laura Cabrera.
Correct, what happened to the ones you told me out of time for?
We had them this morning, but we could do Miss Cabrera and then we can go to Miss Ware.
Okay, because you guys just all over the place.
Yeah. This has been all day. All right. Miss Cabrera, do you need a Spanish language interpreter?
No, Judge, she does not.
Okay, we've got a second-degree felony for deadly missile, shoot or throw, and a second-degree misdemeanor for criminal mischief, $200 or less. And we've got a notation here that Ms. Cabrera is out on bond on 2 separate felony charges. Case number 25-4674 and F-25-4769 before, I guess is Judge Miranda?
Yes.
All right. Any probable cause arguments?
Judge, no, we'd ask for standard bond.
State?
It's gonna be a whole judge in state division.
Okay.
It's gonna be a whole.
So yeah, just to hold that.
All right. The hold, and want the standard bond also, or just the hold?
No, we need the holds and then
Standard bond,
also the
thank you.
bonds, Judge.
Okay, felony, hold, or whatever. What are the cases?
F-25, 25464.
4674 F25 4769 out on bond. And all right, count one, $7,500. Count two, $150. Okay, thank you very much, folks. And probable cause found. Who's there's a stay away order for Miss Cabrera. Is she gone? Can you bring her back? Not that way, I mean, she's being held, so she's gonna be staying very well.
And there's gonna be a hold, Judge, so we're gonna set it for division tomorrow. So.
He's back, Judge.
Okay, she's back. Miss Cabrera, you are ordered to stay away from the following address in the event that you are out at City Hall, 8401 Northwest 53rd Terrace. Okay?
Just he didn't hear you. That's
Thank
it?
you.
Yeah, thank you.
Mr. Pechodomo, I called you earlier. I don't know if you're still on or gone, but I called you earlier because I was going to call your client to read a stay away order, but or inquire about that, but we'll handle that in division. Not we, someone else will handle that in division. Who's next?
Lauren Ware.
And Mr. Epps? Okay, Mr. Epps isn't there. All right, Miss Ware, I believe I had you earlier.
Yes, you gave, it was $1 bond on a misdemeanor. She's here for the cocaine possession and drug paraphernalia.
Okay, the 3rd degree felony and 1st degree misdemeanor for drug paraphernalia, possession with intent to use. Any argument of probable cause?
No, Judge, we would ask for standard bond.
State?
No objection.
All right, standard bond is what? Please?
100 count 1, 500 count 2.
How much is count 1? Sorry?
2,500.
All right, 2,500. And count 2?
500.
I apologize for asking about these. I usually go off my list and since we've gone out of order, I don't even know where we are. All right. All right, I got it now. All right. Probable cause found. Who's next?
Edwin Rivera. We
Okay,
had
Miss.
this morning. He was
Yes, Miss.
bond. He's back for the felony cases.
Señor Rivera, necesita intérprete, ¿verdad? ¿No? ¿O sí?
No, he does not.
Thank you.
Okay, so Mr. Rivera, you were here this morning, but now you're here on a 2nd degree felony, written threats to kill or bodily injury, and a 2nd degree felony for firearm, weapon, ammunition, possession by a convicted felon. Any probable cause arguments, PD?
Judge, we just asked for standard bond.
State?
No objection.
Felony, 2nd possession. Okay, stay away order as well. What's the standard bonds for both of these? Mr. Rivera, I'm ordering you to stay away from the and not have contact with the following named person hereinafter the victim, Stacy Machado, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited.
Yes, sir.
What are the standards? $7,500 each.
It's to be set by you, Judge. You said 2,500 each?
$7,500 each. Count one, count two. Sorry.
Next one we have is Sony Elsama.
And correction, can you just give us the page number?
He's number 35 on the calendar.
Hold on.
So, Mr. Lusma, I see here, just so everybody knows, I have a note here that says on community control probation for case number F24-12049.
He's in custody on that, Judge.
He's in custody on that. Okay, so he's in custody.
Judge, we asked for a standard bond.
Okay, state.
The standard bond for the trafficking charge is $50,000.
That's not standard.
No, yes.
It would be 10,000 or 15, girl.
10 or 15,000?
Yeah.
Okay, I'll go 15.
Count one, you said 15,000.
Yes.
Count two, 2,500.
Yes.
And that felony bond.
He's in custody on that probation, the F24-12049.
Please add a charge in your correction.
No, it's just he was booked with the probation violation.
They should be old.
Okay.
Must be old. Oh, yeah. Standard bonds are the whole, Your Honor.
Okay, hold. Felony hold.
So, 50,000, 500 is the whole.
Hold for the division judge.
No bond on the probation.
Sorry, I took this from you. Thank you. All right. Is this Enrique Perez, Mauricio Enrique Perez? Okay, he was here earlier today. He's now here in a third-degree felony grand theft case. Enriquez Perez.
He's right after this. The one we just did.
Okay. Mauricio Enrique.
Judge, I'm sorry, I can't hear the state if they're saying something.
They're kind of mumbling about trying to figure out what case number it is.
Oh.
I
Judge,
promise I
don't have
will.
a PC, I don't have a PC argument, but I'd ask for a $2,500 bond.
Okay. State.
Yeah, that's.
No objection to the standard bond.
Okay, standard bond for Mr. Enriquez Perez, $2,500. Probable cause found.
Judge, can you grab the A form for Laura Cabrera that you did? I just want to make sure the bond, I have count 1, 2,500 and count 2, 150.
Right. $7,500 and $150.
Thank you.
All right, we're back to the beginning of page 1, Amber Odom,
Bond out.
bond out, okay. Did I write that on this?
Yes.
Natasha Coleman? Is that Natasha Coleman?
Yes, it is, Judge.
Okay, so you're here on a third-degree felony for controlled substance, possession of controlled substance? Any probable cause argument?
No, Judge, but we would ask for pretrial services. She has lived in South Florida all her life.
Okay. Date? The address listed here, what address is that? Is her, does she live there with family? Does she have any relatives?
Judge, she lives at 3020 Northwest 60th Street. She lives with her boyfriend.
Okay. What's the address again?
It's 3020 Northwest 60th Street, 33142. This is it.
Okay, she lives with her boyfriend. All right, so she has a boyfriend. Does she have any other family in the area?
No, Judge.
Does she have any employment?
Whoops. No, Judge.
Okay, but she's lived here her whole life and she's 43, so she's born in Miami and stayed in Miami her whole life?
Yes, Judge.
Okay.
Judge, the state would be asking for a standard. She does have a history of failure to appear to pay for her traffic summons. Or not only to be able to appear before the criminal court for those traffic tickets.
What, I don't see the history. I don't have it in front of me. So how much are we talking? How many times?
And since 2024, 1, 2, 3, 4. Twice.
Right, once in November 2024 and another, and then most recently, June 9th, 2025.
And so were the bench warrants issued in those?
Yes, Your Honor, these were failure to appears that resulted in B6. So it's even beyond showing up. They just moved the case into collection.
Okay. Public Defender's Office, any response to that?
Judge, I didn't hear the last part, but
There, go ahead, state.
On case AL2K50E, the defendant failed to appear and the court moved the case into collections under D6. So they suspended her license.
and Judge, I would just say that understanding that she may have had a D6 for collection fees or not non-payment, we would still ask that you give her pretrial services. She would have to check in and she'll be able to get out. She's not working, so she can't afford the standard bond.
Yeah, it's not for it's not for payment, it's for failure to appear. That's why she was suspended, and that was as recently as that went into effect on June 9th of 2025.
All right, were those was she ROR in those cases? Was she PTS in those cases? What's going on in those cases? Do we know?
look it up, Your Honor.
And those were traffic citations?
Criminal traffic.
Criminal traffic, right? So she was here a little earlier, that thing. Okay. I'm gonna do pretrial services, alternate standard.
Alternate will be 2,500.
Yes. Mostly because she's not a flight risk. I understand she failed to appear for the other things is more serious. Ashley Jennings.
Yes, it is, Judge.
Okay, so this is a third-degree felony for child neglect with no great bodily harm. There's
Yes, it
9
is,
counts.
Judge.
There's 9 counts.
Yes, there are, Judge. We don't have a PC argument. I don't see any other priors on her local sheet. Would the court be inclined to give her pretrial services because standard bond on each of those 9 counts she would not be able to afford?
She doesn't qualify. State any argument?
Well, she, not, if she doesn't qualify, I don't think there's any.
No, on any
Oh,
Reese conditions.
Standard bond is fine then, on each count.
How old are these children?
Judge, from 1 to 10 years old.
What's the standard bond for each of these?
It's to be set by you, Judge.
Okay, right. All right. Because the bond purpose is for appearances and for harm, physical harm, danger to the community, I'm gonna give pretrial services. She's also the biological mother of these children, but the allegations are fairly severe. So I have some hesitation in doing this, but again, the rationale behind a bond is not to punish, it is to secure a person's attendance and to protect people from harm. I assume these children also will not be in her care at this point, this time? Is there a related case based on this? DCF or something?
I believe she has a DCF case order. I do not know what the conditions of her DCF case is.
The kids are in my care.
They're still there? What she's saying that the kids would still be in her care. What I would ask that the court make as a condition is that she has to comply with whatever the case plan is with DCF as part of her condition of release.
I will add that to the conditions of relief that she has to comply with DCF's case plan. But pretrial services and the alternate bond for each one, $2,500 each, so. Excuse me, pretrial services, I'm ordering her in, yes. And what did I say, additional conditions? Comply with DCF case plan. That for each of those counts was the alternate was $2,500 for each.
It's 9 counts, Judge.
Yep. 9 times $2,500 is the alternate. Who's next? Is this Alina Corbato?
No, don't go anywhere. I have a notation here and I'm also visually seeing some erratic behavior. I don't know how to call it erratic, but just yesterday was reset for medical, and so today you're here. You've been charged with 3rd-degree felony for grand theft and a 2nd-degree misdemeanor for criminal mischief. Any probable cause argument? No, Judge, I do not. Judge, would the court consider sending her to the hospital for stabilization?
What is her condition? Do we know? Is it mental health?
I do not know her diagnosis, but it is mental health. If the court's not inclined, we just ask for standard bond.
She's asking to be sent to medical, to stabilization.
Reset for tomorrow. You'll check with them. Yes, sir.
Okay, all right, I'm gonna reset this for tomorrow. I haven't asked State, but State, I'm observing her. She won't look at the camera. She's looking down. She's tried to leave the room a couple times at least. So resetting for tomorrow. I have made probable cause determination. She's there, she's present. But I'm resetting for tomorrow for medical stabilization.
Check and see if you have benefits.
Okay, the public defender has to check if there's benefits.
So it'll be reset for tomorrow for hospital placement.
Yes. We're to Jasmine Jones. I think yesterday she was also supposed to be here, and she was reset for medical. Is she here now?
Yes, Judge, this is Ms. Jones.
Yeah, they.
This is a 2nd-degree felony for robbery, strong arm. Any probable cause argument?
I do not, Judge. We'd ask for standard bond.
Give me 1 second. Okay, so is there anybody here for that case? There's like anybody in the panel? I have a question for somebody.
Your Honor, no one has indicated that they're here for this case.
Okay, thank you. All right, so you said no probable cause argument?
That's correct, Judge.
All right, and any argument on release conditions?
Judge, we just asked for the standard bond.
State?
Your Honor, no objection to standard bond.
Okay, and there's a stay away order?
Yes, Your Honor.
All right, so I'm gonna issue the standard bond. This is a 2nd-degree felony with, it says strong arm. Is there a weapon involved or no? What is it $7,500? Bond amount?
Second degree.
$7,500, okay, standard bond, $7,500. And I'm gonna order you to stay away and have no contact with the following named person here and after the victim, initials DB, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times. Also, electronic contact such as emailing, texting, Facebook messages, or by Twitter is prohibited. This order will remain in effect until the case is closed, okay? Or unless it's modified by division judge. Is that Vicky Snow?
It is, sir.
I am seeing that she's trying to speak, or
She was just acknowledging that it was her.
okay. Thank you. Again, for her sake, I've appointed the public defender's office to represent you. So I'll be communicating with you through the public defender's office.
Judge, we don't have a PC argument. We'd asked for a dollar bond. I see that she's in custody on 2 other cases.
What are the 2 other cases? This is a 3rd-degree felony battery by detainee. So this is an.
I'm sorry, one other case. One other case.
What's the other case?
One in the box, F25010538.
Oh, sorry. Yes. Okay. Burglary of an unoccupied. All right. And petty theft. All right. That's felony case. So felony trial coming up August 25th, 2025. State, any objection? She's being held.
No objection, I do stay away.
Okay. We'll read a stay away order. $1 bond.
I guess he's in.
Okay. Yes. Wait. I'm gonna verbally tell you to stay away from the or not have contact with the person that caused this battery. So Leslie Martinez, right? The police stay away from Leslie Martinez to the extent you can. Hold on, $1. Yeah. Given the trial and the felony and the misdemeanor. This is Denise Moreno.
Yes, Judge.
Judge, she's a VFOX. She's a sentenced inmate. Her sentence expires today.
So was this charge?
This looks like it's an old charge, that it was an incident that happened back in March before she even took the plea on this other case.
With my sister,
What's the added charge? The 2nd degree of battery aggravated? And this is
no, it's not.
Yes, it was the aggravated battery charge. It on the A form, it has a listing date of, or incident date of March 14th of 2025.
okay, since she's been I suppose in custody.
Well, she came back into custody, it looks like, from, if I'm reading CJIS correctly, to do a weekend sentence.
And I'll go back on house.
That's correct, Judge. She was booked August 1st. Her sentence expired. They took her into custody because I guess she's doing a weekend program. Her sentence expires today.
On the other charge, or I'm
On the sentence charge, F 23-15455, and then they added this battery aggravated domestic violence.
But just, was it casted, was it just one weekend too? Was it more?
How many weekends did she have to serve for
I'm
the
not-
other?
Doesn't state that on the jail card.
No, but she said the sentence expired.
I don't know the whole particulars of her sentence, but my understanding that I'm getting from her is that every year she has to do at least one weekend in jail while she's on supervision. And so
Okay.
this was her weekend for this year.
For this year for the other charge, and now this is a separate charge from March that we're having today.
Correct.
Okay. Any
And so I don't
problem?
know.
Go ahead, public defender.
I do not have a probable cause argument, Judge, but I would ask the court to release her on this particular charge. She is doing supervision. And then she will have to come back to answer for this charge in court since it's an older case charge.
State.
State has no objection given the fact that she's been showing up to her, I guess, detention and whatever she has to do, so state has no objection to it.
Okay, so ROR.
Yes.
Okay, ROR. Am I reading a stay away order? Yes. Okay. Ms. Moreno, you are prohibited from having any contact with the following named persons here and after the victim. Initials RV, which appears to be your sister. Directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. You must stay away at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook Messenger, or by Twitter is prohibited. All right. You're released on your own recognizance. I'm going to put in my notes over here. Shakia Jenkins.
Yes, Judge. This is Shakia Jenkins.
Okay, yesterday we reset this for today based on medical. This is several charges: felony murder, first degree with a deadly weapon attempt, second degree felony with a firearm weapon, or possession of a firearm by a convicted felon, and second degree felony written threat to kill or bodily injury. Any probable cause arguments?
Judge, I don't have a probable cause argument, although the A form does indicate that they both showed up for an encounter, but I would be asking the court if you would consider issuing house arrest level 1.
Count 1 is no bond. Okay. State.
I think there's limited discretion here, Your Honor. There's no bond.
The biggest. Okay. Yeah. No bond for count 1. Obviously, then no bond for count 1. She's either counts. She's detained. Right. Count 2 and count 3. Any argument, public defender?
Judge, we would ask for a standard bond. So on the count 1, I'm just making sure you're saying that it's no bond?
Yes, no bond.
Okay. Was there a motion for detention filed?
State.
Yes, it seems like there was.
There was a motion for detention filed.
You have it, Judge?
I don't know if I have it.
Yeah, you have it.
Let me check if I have it.
I have it, yes.
What's count 2 and 3?
Count 2 and 3 are for felony, felon in possession of a firearm and written threats, kill, bodily injury. Let me see if I,
We'd ask for standard bond on those, Judge.
okay, where the standard bond for those? $7,500 each. And probable cause found. Okay, the motion's coming
And
up.
Oh, okay, and then if we just ask that it be set to be heard on the motion within 5 days.
Public Defender's Office is asking to be heard in the motion within 5 days.
Yes, it will be set in front of the video.
Okay? It'll be set before the division judge?
This is Judge. Oh, Judge, yeah.
Jason Block.
Yeah, the conference, the couple of those days.
So it'll be on Thursday. Okay? Third day of August 25.
Sorry, Your Honor, it's just standard bond for the name.
Oh, wait, There's the motion. I don't sign this, right? Oh, yes. Yeah. Oops.
State, please. Vote.
All right, so you have a hearing within Thursday, okay?
I told her, Judge, we now have Miss Cherry in front of us.
Okay, perfect. All right, thank you. Who do we have? Who do we have? With Ms. Jenkins, it's, I guess the division judge will handle this.
Oh, I'm sorry, it's Miss Fritza Cherry, Judge.
I have her out on felony bond F-25 13792.
Can I say something?
What? No, hold on. And Judge, we would be making a PC argument that within the four corners of the that mere proximity is not enough to find probable cause for her to be in possession of the items found by the officers. We'd be asking the court to find no probable cause.
Okay, so third degree felony, cocaine possession, state.
They would argue that there was probable cause, this was made on the stop was made on a photo. And so therefore felony stop was conducted when they were stopped, they were seen to have cocaine, plastic bags of cocaine, whether it is cocaine or not, is not what's being tested right now.
Or the argument isn't whether it's cocaine, it's about the proximity not being enough for possession.
Yes, Judge, we're just saying that not within the four corners of the A form, it doesn't show that the client had knowledge or control over it, and just being in proximity in the vehicle is not enough to establish PC for her on the drugs. She wasn't charged with the car theft.
Your Honor, if you just give me a moment to review it, I'll be able to provide another moment. And before I review this, Your Honor, I just wanted to point out that I just want to make sure for Ms. Jenkins, standard bond on the remaining two charges, $7,500 each. And I just want to point out that there is, okay, never mind, I don't want to confuse. I'm gonna review this, Ms. Cherry's, it's just a moment. Okay. The argument that constructive possession is not.
No, it's not about the amount. It has nothing to do with the amount. It has to do with the fact that she's in the front seat. She doesn't have possession. There's nothing in the A form, Public Defender's Office, nothing in the A form, according to them, that establishes that she knew that the cocaine was in the car, or she had control over, or anything like that. It just says she was in the front passenger seat. There are drugs in the vicinity.
Okay, well, again, Your Honor, there is no direct, there is.
Public Defender, you want to repeat your argument so I don't have misstate or mischaracterize or confuse the state?
Sure. Yes, Judge. So we're just saying that mere proximity is not enough to establish knowledge and control when you're talking about constructive possession, which is what this case is, because the officers indicate that they find something on the passenger floorboard by the sill of the door after people are gotten out of the vehicle, meaning when they were searching the vehicle. So we're just saying her proximity of being by the drugs in the vehicle is not enough to establish probable cause.
What's the legal basis for that argument? There's never going to be direct knowledge of, there's never going to be direct evidence of knowledge. That's always proven through circumstantial evidence. And the circumstantial evidence here is that she was, I believe, the only person in the car.
No, in this
The
particular
passenger-
case, oh, sorry.
In the passenger seat, which is where the cocaine was.
No, but that's.
Yeah, but she was in the passenger seat. The cocaine was not found in the passenger seat where she was sitting on it. There's nothing in the A form that the officer alleges that there were furtive motions or movement, that she was trying to place something, kick something, move something. It is that they pulled the car over for a bolo. They removed the gentleman and then her from the car, and then they found these drugs in the door sill. I believe it says on page 2, the bottom of page 1, and under the front door of the passenger side. That does not establish that she had control.
Are you arguing that under these facts and circumstances that the driver is could be under constructive possession?
Correct, because there's 2 people in the car, so they can't say who was in possession of it. And this is not her vehicle. She's the passenger of the vehicle. And there's nothing else from the A form that establishes that the officers thought that she was doing something that associated her with the things that they found once they searched the vehicle when it was stopped.
I can reset this for tomorrow for a probable cause determination for additional information. All right. Is this Rachika Jenkins?
It is, Judge.
All right, this is a 2nd-degree felony for robbery, strong arm. Any probable cause arguments?
I do not have a probable cause argument, Judge.
All right. No probable cause argument. Okay, what any release
Judge,
arguments?
would the court consider giving her pretrial services? She doesn't have, at least on her local parties that I can see, she does not have any felony or misdemeanor conviction.
State.
That is correct. No local priors, Your Honor. I'm just giving a moment to review any additional priors that I have to find here.
And just while the state is looking, my understanding is that she doesn't have any other ones, but obviously the state can look. I don't have access to that. The address on the arrest form is her correct address. She lives there with her sister, and she's lived in the community for over 27 years.
She's lived in this community for over 27 years? She's
Yeah,
occupation, it says occupation handler. What is that?
Judge, she's not employed at the moment.
Okay. What was handler?
That was FedEx.
Okay. Does she have consistent employment other than that? I know she's unemployed currently, but did she have consistent employment?
No, she did not.
Okay. And does she have family other than
other than her sister?
Yeah.
Her aunt, her mother passed away. Right?
Okay.
So she has her sister and her aunt.
So family here as well. Okay. And this is the robbery is removing the cell phone of her girlfriend and throwing it. Correct?
According to the arrest affidavit.
All right. State.
I'd just like to point out that the defendant has had a criminal traffic history. criminal traffic charges, procured, by the defendant in August of 2020
And can the state please, speak into the microphone? I see the public defender having some issues.
I apologize, Your Honor. Thank you. Criminal traffic charges from August 2020 and October 2024, to which the defendant never appeared in court for. She still has outstanding failure to appear, suspensions on her license, which remain which
Understand.
are still suspending her driving privileges. So the defendant has a clear history of failing to appear.
Okay.
So the state would be asking for the standard bond amount and no pretrial services.
What is the standard bond amount? $7,500. Public defender?
Judge, I don't know about the traffic things. That's what the state is seeing. I can't comment to that because I don't have access to that, but we would still, if it's within the court's purview, to give her pretrial services, as she's not working right now, so she wouldn't be able to afford the $2,500.
It was $7,500.
75.
Okay, and this is, I understand she has not appeared at criminal infractions before, or what were the violations for? Driving without license suspended or something, or what?
Driving with license suspended and then driving without a license and leaving the scene of an accident.
Leaving the scene of an accident. Okay. All right, look, while there's a history at least 2 times of not appearing, this is, looks to me more of a domestic dispute where perhaps there was some sort of cellular phone issue with the dispute, at least from the A form. The phone was thrown and there's no evidence of violence other than obviously grabbing the phone. So it's not like this is a random person that she approached and stole the phone from. So I'm going to give her pretrial services with the alternate bond of standard bond. I'm going to read a stay away order. The defendant is prohibited from having any contact with the following named person here and after the victim. Deconda or Devonda? Devonda Bremer?
Devonda?
Brewer, yeah, correct.
Okay, Devonda Brewer, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contact such as emailing, texting, Facebook Messenger, or by Twitter is prohibited. Again, I am giving you pretrial services. They'll be in contact with you, but I also just want to make sure you understand that if you fail to appear anyway or something goes wrong on this by giving you PTS, as you heard the state, they're already arguing for standard bond. I think things may get worse, not better. Okay.
Sure.
Crystal Cox has a bond out.
Crystal Cox.
Bond out.
Bond out.
And next, Miss Tiffany Bailey.
Lots of people got excited about the bond.
Set for tomorrow refused.
Tiffany Bailey refused. Okay. She refused on A2 will reset for today. Does the public defender's office waive appearance, waive presence?
Normally after the 3rd time.
Judge, you can reset it.
Okay. You're gonna reset Miss
Bailey.
Bailey. Okay. But the public defender's office is appointed to that case. All right. Oh, sorry. Ismael Curbelo. Sanchez, Heath Sanchez. Okay, do you need an interpreter?
No, do you need an interpreter? Yes, Judge.
Okay, Madam Interpreter.
Yes, Your Honor.
This gentleman needs an interpreter.
Your Honor, señor Osmar Curbelo, yo le voy a servir de intérprete.
Gracias.
Okay, this is a second-degree felony for grand theft, between $750 and $5,000. Any probable cause argument?
Judge, I do not, oh, sorry, go ahead.
El cargo aquí presente es un delito penal en el segundo grado, es hurto mayor, en una cantidad entre $750 a $5,000. Argumentos.
Judge, I do not. I believe his last encounter with the criminal justice system was in 2024, and he has a withhold, I think, back from 2016. We'd be asking the court for tax.
Su señoría no tiene ningún argumento, pero debo mencionar que el último caso fue en el año 2024 y en el año 2016 tuvo un fallo sin condena, lo que le pediría es la fianza gratuita TAP.
He is listed as being homeless.
Okay,
Está desamparado.
all right, I'm gonna find probable cause, state.
They would be asking for standard bond here.
Standard bond here is $7,500. Okay, and is that based off of just a standard amount? Is there any argument about a failure to appear or any issues with his appearance?
There are, I do commend the defendant for not picking up any withholds or adjudications since 2015. However, those are also grand thefts, petty theft. There's 2 petty thefts on this defendant's record and 1 other grand theft. So this is a history of repeat of similar types of criminal behavior. And for those reasons, Your Honor, we would ask simply for the standard bond.
Okay, and public defender, where it says here he has a Texas driver's license.
Judge, I would have to inquire with the interpreter. I do not speak Spanish.
Your Honor, I have to catch up. Can I relay from the other thing?
I forget sometimes.
It's okay, me too. La fianza estándar es lo que está solicitando la Fiscalía y donde le felicitamos, señor Curbelo, por no tener ningún antecedente penal desde el 2015. Ahora nos encontramos en el mismo panorama que es hurto mayor. Entonces, es siempre la misma conducta la que vuelve. El señor juez pregunta si hay algún estándar o, dependiendo de la cantidad, cuál sería el monto de fianza. Señor, ¿su licencia de conducir es de Texas?
I got the C part, Judge. So yeah.
Yes, okay. And how long has he been in Miami? I see that he's Cuban ethnicity, but how long has he been in Miami?
¿Cuánto tiempo lleva viviendo en Miami? Veo que su etnia es cubana, pero viviendo en la ciudad, ¿cuánto lleva?
20 años.
20 years.
20 years in Miami with a Texas license plate, or excuse me, license number?
A ver, 20 años en Miami, pero con licencia del estado de Texas. A ver, ¿cuál es el número?
No, la licencia de Texas fue que yo estuve 5 meses en Texas trabajando, pero después vine para aquí abajo de nuevo para Miami.
The driver's license from Texas is because I went over there for work. I was there for 5 months and then I came down here again.
Okay, do you have any employment?
¿Tiene empleo, señor?
Ahora mismo no porque estoy preso aquí, pero tenía un trabajo esperándome y después.
Not right now because I'm here in jail, but I did have a job aligned for me.
Okay, any family in the area?
¿Tiene parientes que viven acá? Parientes.
¿Familia?
Correcto.
Tengo a mi mamá,
I have my mom,
mi tía y mi padrastro.
my aunts, and my stepfather.
Tap assures his appearance, correct?
Yes, Judge. He has to check in with them. And they try to find shelters, bed space for him. Is my understanding.
Ya se han comunicado con el programa TAP, que es la fianza gratuita, programa alterno se llama, The Alternate Program, y ya han estado buscando albergue para el señor Curbelo.
Okay, I'm gonna put him in tap.
Se le otorga TAP, la fianza gratuita,
With an alternate bond of $7,500.
monto alterno de fianza $7,500.
You don't see a history of violence, and he's been in the community for 20 years and has family in the community. I don't think he's a flight risk.
No creo que presente riesgo de fuga, ya que lleva 20 años acá, tiene parientes, familiares y ninguno de sus antecedentes es de índole violenta.
Thank you.
Thank you.
And just for Mr. Sanchez, correct, tap alternate 7,500?
That is correct.
Judge, we have Thomas Rodriguez.
Señor Rodríguez, ¿necesita intérprete?
Oh, he does not.
Gracias.
All right, Mr. Rodriguez, you've been charged with third-degree felony for possession of cocaine in excess of 3 grams, or around 3 grams. Any probable cause argument?
No, I don't have any probable cause argument, Judge. I don't know if the state has anything else on his local priors. I see that this is his only charge. We'd be asking if the court would release him to pretrial service.
I'd love to go home today. I can't.
State?
Okay, we'd just be asking for the standard bond for your
Cocaine possession, okay, and does he have any evidence of appearing or anything like that, or, I mean, this is.
I'm just gonna look it up. No evidence of failure to appear, at least not on, no evidence of failure to appear, at least not on traffic, Your Honor.
Okay, and he's, this is a traffic stop, okay, so he has a vehicle?
Yes, he does.
All right, okay, all right, this is, I'll impose a standard $2,500 bond.
The next one, Mr. Francisco Nogufi. He's reset for tomorrow. He's in JMH.
Okay. Roderick Hagabook?
Whoops, yes, Judge.
He's out on felony bond F-25 14065. He also has a misdemeanor petty theft. It was not on the final calendar. He'll be seen tomorrow on.
We don't have any PC argument. We'd ask for standard bond.
Okay, PC found, state?
No objection, Your Honor.
Okay, third-degree felony, controlled substance, possession of meth, and first methamphetamine, I'm sure. First-degree misdemeanor, possession of drug paraphernalia with intent to use. Okay, what's the standard bond for this? 2,500 in count for count one,
500 for count two.
500 for count two. Okay. You. Antonio Marquez? Marquez?
Bond out.
No. John Johnson?
Yes, Judge.
All right, this is third degree felony or charged with third degree felony for assault and aggravated assault with a deadly weapon.
Yes, Judge. Hold on, sorry. Lost my spot. I don't have a PCR, Judge.
All right, no PC argument. All right, release conditions.
Judge, we'd ask for standard bond.
State.
One moment while I review your own.
Sure.
Did you ask me something, Judge?
No, the state is
Oh,
reviewing to ask the state what their position on the standard bond.
Okay.
No objections to the bond.
All right, I'm gonna impose a standard bond. Is this $7,500?
I have 5,000.
5,000. I saw that and I don't know why I said my mind. All right, and a stay away order. The defendant is prohibited from having any contact with the following named person here and after the victim, Edmund Evans, directly or, Mr. Evans, would you like to be heard? All right, let's allow Mr. Evans to
Hello?
speak. Yes, Mr. Evans, can you turn on your microphone, please?
You can hear me?
Excuse me, can you turn on your video?
Yes, hold on. I'm trying to see how do I do that. How I do that? What I gotta press? Cause I only see lower hand.
Are you on your phone? I don't know.
Yes, yeah, I'm on an iPhone.
Sites, do you know how to do this?
Oh, yes. So in order to turn on your video, regardless of the type of device you're on, you have to accept the panelist request.
Okay, great. We've got Mr. Evans. He's here. Ask him to unmute. That's all right.
Hello?
You look good. You look good. It's all right. You worried, I know. All right, let's Mr. Evans, you asked to be heard. Can we swear in,
Yes.
Mr. Evans?
Yes. I swear.
Raise your right hand. Do you swear affirm testimony about to give you the truth, the whole truth, and nothing but the truth? Say I do.
Yes, I swear to tell nothing but the truth.
All right, go ahead.
I would like to drop the charges for him and y'all could let him go because I was just mad with him. And you know that's my uncle and I don't want to see him that type of predicament, so I feel like I should give him another chance to be out here. I don't want him in there. I just want to let him go. And then the stay away order, I don't want no stay away order.
State.
Thank you, Your Honor. The state will not be dismissing charges at this time.
All right.
Judge, we would ask for a modification of the stay away order, though, to be no harmful contact.
No objection, Your Honor.
Do you have any, I'll ask, Mr. Evans, are you, do you feel coerced to do this in any way?
No,
These
no,
are
this
pretty-
this my mom. I chose to do this.
Okay, this is a pretty serious allegations here about pointing a gun at you and threatening to kill you and your mother.
Yeah, you never said that.
Okay, so how did this, right, you never said any of that?
No, I don't know how all that happened. I wasn't there for all that.
Okay. All right. I'm not gonna modify the stay away order. I understand. This is again, fairly serious allegation. I'll let the division judge, Mr. Evans, I'm paying attention to your request. This is not the greatest forum for it. So I will not modify the stay away order until the division judge can consider on a more, I'm not the division judge, I'm just here for the bond hearings. But your uncle's case will go before the judge in his division, the person responsible for his case. And if there's any motion or anything, any argument or discussion, you can re-raise it and try to see if you can have the stay away order modified. Okay?
Okay, so what y'all gonna let him get the bond?
Yes, he's gonna the standard bond of $5,000.
Okay.
All right, the stay away order, Mr. Evans. I don't know if I finished the stay away order. So I'm gonna order you to have no contact with Mr. Evans, directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contacts such as emailing, texting, Facebook Messenger, or by Twitter is prohibited. This is gonna last until the case is closed or the division judge modifies the stay away order.
Okay, Judge.
All right. Thank you, Mr. Evans.
You're welcome.
Mr. March? No, there's just no way it could be March.
Mr. Carl March refused court, reset for tomorrow.
Judge, you don't have to reset that one. We'll waive his presence. We don't have any PC argument. We'd ask for a dollar bond. He's being held on 2 other cases.
All right, waive presence. All right. State.
Given the fact that he is being held on the other 2 felonies, the state has no objection to the dollar bond.
Okay, dollar bond. All right, next case, is this Max Angerville? No,
Judge, we can.
no, not Max Angerville.
Pass, please.
Pass, okay, we're past Mr. Angerville. Jose Luis Velis Rodriguez?
He's the interpreter? Yeah. I'm staying right here. We need the interpreter, Judge.
This is for a probable cause hearing, so is Mr. Perrera here for that?
It is.
Yeah, please call Mr. Perrera and have him come on.
Your Honor, for the record, the interpreter hasn't moved out of here. It's just that it takes time to click on the buttons and for my face to appear, but I'm hearing everything.
Oh, no worries.
Thank you.
Ms. Gonzalez is here, has not moved from her chair except for the 2-minute break I gave her earlier.
Judge, is the attorney there for the PCH hearing or the police?
The officer is not here yet. We're calling him. He's coming in.
Señor, le vamos a llamar a la brevedad posible.
All right, we'll pass it for a second because I think the police officer is eager. All right, Wilfredo Blanco Diaz or Wilfredo Diaz Blanco?
He needs
Excuse me?
the interpreter.
Wilfredo Blanco Díaz, yo le voy a servir de intérprete.
Okay.
He has a hold for immigration.
Tiene orden de detención por parte de la entidad migratoria.
Judge, we don't have a PC. Oh, sorry, go ahead.
I'm sorry, the gentleman requested repetition. May the interpreter repeat? Your Honor.
Yes.
Thank you. Tiene orden de detención por parte de migraciones. ¿Escuchó?
Yeah.
Yes.
Okay, you're here for a 3rd-degree felony, controlled substance possession, crystal meth.
Se encuentra aquí usted por un delito mayor en el 3er grado, tenencia de sustancia regulada, crystal meth.
We don't have a PC argument, Judge. We'd ask for a standard bond.
La defensa no tiene argumento respecto a la base legal, sin embargo solicita monto de fianza estándar.
State.
Standard bond.
All right, the standard bond for 3rd-degree felony. $2,500. Okay, no threat of force. All right.
Monto de,
2,500. Ah,
monto de fianza estándar en un delito penal en el tercer grado es $2,500, así queda su fianza, señor.
all right, thank you.
Gracias.
No pudiera decir algo más. No pudiera decir algo más. Por la migración, porque yo.
Why is immigration unintelligible? Señor, me necesita que le interprete, ¿verdad? ¿No? Gracias.
Have we found Officer Pereira? Okay, he's just logging on. So the next one will be, we'll bring back Mr. Feliz Rodriguez after this one. All right, Mr. Hernandez. Is this Mr. Hernandez?
Yes, sir.
Yes, Judge.
Okay, this is, we're here on a first-degree felony for selling or I don't know if it's attempt to sell cocaine within 1,000 feet of a church or convenience store. And there's a crack pipe with suspected cocaine residue.
I ain't trying to sell nothing. They just.
Mr. Hernandez, please, the public defender's office has been appointed to represent you. You have the right to remain silent. I will speak to you through your appointed representative. Okay?
Sorry, Judge, the button. We do not have a probable, hold on one second, Judge, sorry. We do not have a probable cause argument, Judge. I know he does have priors. However, we would ask for TAP since he is listed as homeless and does not have the money to post a bond.
State.
Just one moment.
Is this? My. Everything's great.
Your Honor, given the defendant's priors here and these priors are violent,
What are his priors?
the priors go back as far as seems like the late 80s, 1986, and as recently as, sorry, I wish these were in order.
Can you just make sure you're talking to the mic?
Yes, Your Honor, the priors go back as far as 1986 and as recently as, I believe, 2024, most recent conviction, battery. The defendant was also charged at one point with murder. The state would be moving for no bond in this case, and we will file the motion in open court.
And Judge, the only thing I would say to that is that, yes, he was arrested at one time for murder, but he was not convicted of that. That charge was no.
Okay, so
15 element that charge doesn't pop up for the pre-trial detention.
excuse me? Sorry.
This charge that pops up for the pre-trial.
Okay, all right. So we're gonna do a $15,000 bond, standard bond. And state can argue no bond at a later time in front of the division judge.
The officer has advised that I guess he's waiting to be let into the Zoom. He's waiting.
I'm sorry, Judge, that was from Mr. Arnaldo Hernandez, correct?
Yes, Mr. Hernandez. $15,000. This is Mr. Feliz Rodriguez and he needs an interpreter.
Señor
Correct.
Rodríguez, yo le voy a servir de intérprete.
We are here yesterday and today for the third-degree felony, battery on a person 65 or older.
Estuvimos aquí presentes el día de ayer y hoy también en cuanto a un delito penal en el tercer grado que se trata de agresión corporal contra la persona de la tercera edad de los 65 años o mayor.
The arrest form suggests, but does not make 100% clear that the victim is older than 65 years old. So I ordered a probable cause determination hearing for today.
Esta es la conjetura que presenta el documento acusatorio en cuanto a que la persona de la tercera edad puede ser mayor de los 65, pero no está completamente establecido, por eso fijé la fecha de hoy para que se celebre una audiencia para ver si hay fundamento legal o no.
Right? State?
¿Correcto?
Thank you, Your Honor. Okay, let's see here. So,
Can we swear in the police officer?
Va a prestar juramento el agente policial.
Officer, raise your right hand. Do you swear affirm the testimony about to give you the truth, the whole truth, and nothing but the truth, sir? Do?
I do.
thank you, officer. Will you please state your name for the record?
Officer Pereira, City of Miami Police Department.
Let the interpreter interpret. Let the interpreter interpret.
El agente se ha presentado para las actas. El agente Pereira.
And on August 1st, 2025, did you happen to come across a person who would later be known to you as Jose Luis Feliz Rodriguez?
Yes, sir.
El día 1 de agosto del 2025 entró en contacto con una persona cuyo nombre se enteró luego que era José Luis Ruiz Rodríguez. Así es.
And can you speak on the circumstances in which you first came to meet the defendant?
¿Puede explicar, por favor, en qué circunstancias es que llega a conocer por primera vez al acusado?
And please pause every one or two sentences for Madam Interpreter.
Por favor, brinde pausa después de cada una o dos frases para que la intérprete pueda cumplir su labor.
Sure. We were dispatched to a call reference a battery on domestic violence.
Sí, nos despacharon a un llamado por actos de violencia intrafamiliar.
When we made contact with the victim, identified as the defendant's long-term girlfriend.
Al llegar al lugar de los hechos, el acusado se le identificó como persona pareja de la víctima desde hacía bastantes años.
She advised police that they'd been in the relationship for 7 years, currently living together.
Le hizo saber a la policía que llevaban 7 años en una relación convivientes.
She also told us that they were having an argument over some nationality issues.
También nos comentó que estaban discutiendo respecto a ciertos temas de nacionalidades.
At which point the defendant became irate and charged the victim, grabbing her by both arms and grabbing her by the neck.
Momento en el cual el acusado, escuche caballero, el acusado se puso iracundo, agarrando a la víctima de ambos brazos y estrujándole el cuello.
The victim was able to get away and contact the police.
La víctima pudo salirse y llamar a la policía.
She showed us bruises on her arm. We were unable to identify if it was fresh bruises or been there from the past.
Nos enseñó las magulladuras en los brazos o en los moretones y no pudimos darnos cuenta si es que eran magulladuras viejas o frescas.
We then made contact with the defendant.
Ahí nos acercamos al acusado.
And he denied all the allegations.
Negó todas las alegaciones existentes.
That's it.
Eso es todo.
Thank you, officer. And did all of this occur in Miami-Dade County?
Yes, sir.
Gracias, agente. Todo esto ocurrió en el condado de Miami-Dade. Así es, señor.
And what was the age of the victim?
¿La edad de la víctima era cuál?
She was 70 years old. That provided the state with a photocopy of a driver's license.
70 años de edad. De hecho, ya le proporcioné a la fiscalía copia de su licencia de conducir.
I'm sorry, I missed how old you said she was. Can you repeat that?
70.
Okay.
She was born in 55.
Nació en el año 55.
And is her date of birth July 23rd, 1955?
Give me one moment, let me verify.
La fecha de nacimiento es 23 de julio del 55. Vamos a esperar verificación.
Correct.
Correcto.
And is is her height 5'5" as reflected on the driver's license?
La señora mide 5'5", como lo indica su licencia de conducir.
That is correct.
Is her residential address 1045 Northwest 26th Street, Miami, Florida?
La dirección de ella es 1045 Noroeste, calle 25 en Miami, Florida.
Correct.
Thank
Correcto.
you, Your Honor. No further questions?
No hay más preguntas por parte de la Fiscalía, su señoría.
Public defender?
La Defensoría Pública.
And officer, just the information that you gathered in regards to her was from her state of Florida identification or driver's license?
Me indica el policial si la información que usted recopiló es proveniente de su carnet de identificación o su licencia de conducir de la Florida.
It's going to be for her driver's license, Class E.
Información obtenida de su licencia de conducir.
Nothing further, Judge.
Ha concluido la defensa.
All right, any argument on probable cause?
Argumentos respecto a la base legal, señores.
Based on that other information, no, Judge.
En base a la información otorgada, ninguno.
Okay, find probable cause.
Señor juez declara que hay suficiente fundamento legal.
All right, any argument on the bond?
Argumentos respecto al monto de fianza, señores.
Judge, I don't know if the court would consider, I don't know if you can, go pretrial services. I don't see any local priors listed for him.
No sé si contemplaría usted otorgarle la fianza gratuita pre-trial porque no veo que tenga el señor antecedente penal alguno.
With the understanding that there would be a stay away order.
Tenía sentido que existiría la emisión de orden judicial de alejamiento.
Your Honor, the state would ask for the standard bond here.
Fiscalía solicita monto estándar de fianza.
The stay away order that I will be entering, it should be a domestic violence one, shouldn't it? They live together, it says non-domestic violence. You can interpret that, Madam Gonzalez, Mrs. Gonzalez.
Yes, Your Honor. Tendrá que ser la orden judicial de alejamiento de índole violencia intrafamiliar, porque aquí en la documentación indica no es de índole familiar.
Thank you, Your Honor. We'll ameliorate that now.
All right.
La Fiscalía va a corregir la documentación en estos momentos.
Okay, so I will be issuing a standard bond for this. I understand there will be a stay away order. But there is an allegation from the victim in the A form about strangulation around the neck on an argument about nationality.
Se le va a otorgar monto de fianza gratuito, pero existe en el formulario de arresto la mención de estrangulamiento y discusión por temas de nacionalidades.
So, on its face, that appears to be a relatively nonsensical argument that turned into an allegation about grabbing her around the neck.
Entonces, lo que a primera vista parece una discusión sin sentido, se torna en una situación donde la tiene agarrada por el pescuezo.
So while this is the first time that there's at least any evidence of prior or no evidence of prior convictions or other misconduct, again, that's a serious elevation.
Y donde no existe alegato ni mención de antecedentes penales que tenga el caballero en su contra, de todas maneras, estas alegaciones son de carácter grave.
So I'm going to issue the standard bond for that reason.
Por tanto, emito monto de fianza estándar.
It's $7,500, correct?
The third degree, Judge.
Your Honor, interpreter here to state.
25, Judge. It's a third degree.
Okay, $2,500 standard bond.
2,500 monto de fianza estándar.
Well, that's third degree of no force, right? There's force or threat of force against the person. It's 5,000 or no?
It will do force.
Grab her by the arms and
Yes.
around her neck.
Then you can say whatever you think is appropriate.
Okay, well, I think 5,000 is appropriate then. I'm gonna put $5,000.
Con las alegaciones de haberla agarrado del cuello y los brazos, el señor juez le parece adecuado un monto de fianza en la cantidad de $5,000.
All right, and I'm gonna issue a stay away order.
Orden judicial de alejamiento a emitirse.
This is a domestic violence stay away order, so
Ámbito violencia intrafamiliar es esta orden de alejamiento.
if you are able to meet your pretrial conditions bond, do not engage in any criminal activity.
Si es que logra cumplir con las pautas de su pago de fianza.
Do not use
I'm sorry, Your Honor. No puede participar de actividades ilícitas, sorry, Your Honor.
do not use or possess any illegal drugs.
No puede consumir ni estar en tenencia de sustancias ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
No puede utilizar, tener entre sus pertenencias, ni estar en tenencia, o sea, portar arma blanca, arma de fuego, ni municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department.
Cualquier arma blanca de fuego o municiones que tenga entre sus pertenencias debe entregarlo de manera inmediata al departamento de policía más cercano.
And file a receipt with the court.
Presentando recibo ante este tribunal, señor.
You are prohibited from having any direct or indirect contact with the following person.
Tiene terminantemente prohibido contacto de manera directa ni indirecta con la siguiente persona.
The victim, Irma Bolivan, including contact in person and writing by telephone.
La víctima, cuyo nombre es Irma Oliván, no puede tener contacto con ella en persona, por escrito ni por teléfono.
Through social media or any other electronic means.
Con el uso de ningún dispositivo electrónico, redes sociales.
Or through third persons.
Y tampoco a través de terceros.
Defendant must stay at least 500 feet away from the victim.
Tiene que conservar la distancia mínima de 500 pies a favor de la persona, de la víctima.
The victim's home, place of employment, and/or school at all times.
El hogar de la víctima, su lugar de estudio y o empleo en todo momento.
The defendant may return to the victim's residence.
El acusado tendrá oportunidad de regresar en una ocasión a la vivienda de la víctima.
One time only within 48 hours of the entry of this order.
Una sola ocasión dentro del plazo de las 48 horas de la emisión de esta orden judicial.
Accompanied by a police officer.
Debe contar con escolta policial.
To retrieve his personal clothing, personal health items, medication.
Con la intención de recuperar su ropa personal, artículos de cuidado de la salud, medicamentos.
Personal and business related paperwork and work tools.
Documentación personal laboral y también herramientas laborales.
Going to the home or remaining at the home without the police.
Si acude a esta casa o permanece a esta casa sin contar con escolta policial,
Will subject the defendant to arrest.
lo dejará sujeto a esa situación a nuevo arresto, caballero.
The police officer shall request all keys and garage door openers to the home from the defendant.
El agente policial tendrá que solicitar por parte del acusado toda llave o método de ingreso
And turn them over to the victim.
para entregárselos a la víctima.
That concludes this order. The order runs until modified or terminated by the court.
Esto concluye nuestra audiencia. La orden de alejamiento sigue en pie, en vigor y efecto, sino hasta que lo modifique un juez o culmine el caso. Gracias.
Thank you.
Gracias, caballero. Ya se puede retirar.
Sorry, you had this too. Is this Prince Zaimi Santessa?
Yes, Judge.
Is the Creole interpreter present?
Your Honor, the interpreter needs a moment to get one of them. So while I do that, no?
He does
doesn't
not need a Creole interpreter, no.
Okay, sorry, I was reading a message from the chat room.
I think there may be someone else.
Okay, so, all right, so Mr. Interpreter, we don't need you for this one. If you could start reaching out, maybe get them. Because we will need a Creole interpreter for somebody.
You mean there's a witness in the platform?
No, there's somebody's been sending a message, says message from MDCR is the Creole interpreter president. That was at 5:05 PM.
Right away, Your Honor.
Yeah,
it's Do we still need an interpreter, Creole interpreter for somebody else? Sorry for the housekeeping.
I believe that we still do.
I'm from Africa.
All right, thank you. All right, Mr. Santeza. You've been charged with second-degree felony burglary of an unoccupied dwelling and first-degree misdemeanor of criminal mischief of more than $200 and less than $1,000.
Judge, our only argument is that it was a trespass, not a burglary, that there, in the four corners of the A form, it doesn't say that anyone saw or viewed him break the door in terms of the criminal mischief. And when the police entered, he was in there sleeping. We'd ask for TAP, a finding of probable cause for trespass and TAP.
So you're arguing there's no intent to
Commit a felony therein.
okay. State.
One moment, Your Honor, if I can review.
And Judge, while they're looking at that, at least from my sheet that I have, he does not have any local priors.
So, Your Honor, the defense is challenging PC to the felony burglary charge, is that correct?
Correct.
Okay. This court should find probable cause, and that falls for at least 6 reasons here. First, unlawful entry. The defendant entered the building without permission. He accessed the structure via the west side door, and surveillance confirmed he had not exited. This is a structure, not a dwelling. The building appears to be a non-residential structure, which aligns with 810.02 subsection 3B. Damage or forced entry. The door to the room 209 had a destroyed door frame suggesting forced entry, which supports intent. And that goes to my 4th point, Your Honor, intent to commit an offense. While the defendant was found asleep, the damage to the property, most notably the door frame, can imply intent to commit criminal mischief or trespass, which satisfies the statute's requirement of intent to commit an offense inside. No assault or weapon involved. My 5th point, the subject was not armed and there's no reported assault or battery. And to my 6th and final point, the complainant wishes to prosecute. This shows confirmation of the victim's interest in pressing charges, further supporting legal grounds for proceeding under the statute. For these reasons, we would ask this court find probable cause.
Public defender.
I have nothing further, Judge.
Okay, so he commits an offense. It doesn't have to be to commit a felony offense, correct? Just
That's
has to be an offense. And so the intent of the committing the offense therein, I guess inside the building, what's the offense inside the building?
So that's my 4th point, Your Honor, and damage to the property, the door frame can imply an intent to commit criminal mischief or trespass, which satisfies the statute's requirement of an intent to commit an offense inside.
Okay, I think that's a technicality, within the A form. I think the state is correct, but it's a practical matter. It seems like he entered to sleep. But, so I'll probably probable cause. All right, so, what are we asking for in release conditions?
I was asking for tap, Judge, but with an alternate bond of 2,500. Or
Is there any, are there any other priors? Anything else, showing anything? And he's 23 years old. Has he committed any other crimes?
I don't have anything.
State?
No, Your Honor.
This is first offense?
I can't, as far as the local priors that I see here, the state would have no objection to tap with the alternate bond.
Okay, tap with the alternate bond. All right, we're gonna do tap with alternate bond, given this is the first two offenses together. And again, my view, I understand he broke in, and that may be evidence of an intent within the four corners of the A form. But most folks don't fall asleep in the place that they're intending to rob or do anything else that is an offense. So on this, I don't think, that's why I'm giving him tap, so that I don't think he's a flight risk or a danger to the community. Physical harm. What's the alternate bond for count one?
I believe it's 2,500, and somebody can correct me if I'm wrong, and then the other count would be 500.
What did you find count one for? Did you go did you find the what's on?
No, felony two, burglary. $7,500, that's the alternate bond. And the second count is for misdemeanor one, which is what, $500? Okay. That's the alternate bond. So he's in tap, okay?
And what's the alternate, Judge? And it's what, pretrial or tap?
Tap. And it's $7,500 for count one and $500 for count two. Tap because he's homeless. Who's SK? Did Mr. Santeza leave? No, we'll leave this for the sentencing, the division judge.
Yeah, he did.
Okay. Rafael Moya?
Yes, Judge, this is him.
The answer to SK is it's the listed victim who is.
The complainant?
Farms.
Okay. Rafael Moya?
He needs a Spanish interpreter.
Señor Moya, yo le voy a servir de intérprete. Buenas tardes.
Okay, gracias.
Okay, thank you.
Okay, Mr. Moya, you've been brought here on charges of third-degree felony, crack cocaine possession.
Señor, se le ha traído acá el día de hoy por delito penal en el tercer grado, tenencia de crack de cocaína.
And a first-degree misdemeanor of resisting officer without violence to his person.
Y delito menor en el primer grado, que es resistir al agente policial sin actos violentos contra su persona.
Any argument on probable cause?
I do have a probable cause argument.
I'm sorry, madam, did you say there is or there isn't a PC?
There's not.
Thank you, ma'am.
Probable cause found.
Sorry, ¿qué digo?
Yes.
El señor juez pregunta si hay algún argumento de base legal. La defensa no tiene argumento de base legal. El señor juez establece el fundamento legal.
Yes, probable cause found. Thank you. What's the argument on release conditions?
Judge, I don't see any priors, but however, because I lack in Spanish, I cannot tell the court how long he's lived locally, but we would be asking to see if he qualifies for health services.
Su señoría, no tengo información respecto a antecedentes, ya que no hablo español, ni tampoco puedo preguntarle cuánto tiempo lleva viviendo en nuestra localidad, pero en todo caso queremos solicitar la fianza gratuita pre-trial.
State, he does, I have corrections, I believe, said that he does qualify.
Nos habían indicado los carceleros que de hecho califica el señor para la fianza gratuita.
State.
No objection, Your Honor. We just asked for the standard bond on the line.
Ninguna objeción por parte de la Fiscalía, solo solicitando un monto estándar de fianza también.
Does that work for public defenders?
Yes, Judge.
All right, pretrial services, the alternate bond for count one is, let's see, where are you? $2,500, okay. And count two is $500.
Bien, sin ninguna argumentación adicional por parte de la Defensoría Pública, el señor juez le otorga la fianza gratuita Pretrial Services con montos de fianza alterna en el primer cargo, 2.500, fianza alterna, segundo cargo, 500.
Thank you.
Gracias.
Okay, bond for audience.
Inaudible interpreter. Your Honor, you know Creole interpreters there. Carol is here.
All right, and we have the gentleman who needs the Creole interpreter. I believe he's number 38, Jackendi Lewis.
Okay, Jackendi Lewis, and there's a bail bonds person here on behalf of the family waiting on the bond amount.
Your
Okay.
Honor, this is the Creole case.
Yes.
Thank you.
All right, give me a second to get the paperwork.
Monsieur, yaptan, ba yon ti moment pou yo jwen papye yo.
Judge, we don't have a PC argument. We do note that.
Nou pa gen aucun rezon, nou pa gen aucun argument pou nou montre ke gen ase rezon pou sa.
We do note that he, as far as I can tell, he does not have any local priors.
E otan ke m kapab wè, li pa gen aucun antécédent lokal.
All right, he's a third-degree felony, assault, aggravated assault with firearm.
Donc, troisième, sa son crime troisième degré, ou eseye batou moun avèk un zam.
There's probable cause for the charges. State.
Gen ase rezon pou akuzasyon yo, avokat l'Etat.
What is your argument on the release conditions?
Avokat l'Etat ki argument genyen pou kondisyon sa yo.
Just reviewing.
I'm sorry, State, I can't hear you.
I'm sorry, Madam Interpreter. I'm just reviewing the facts of the case at the moment.
And Judge, if I'm reading the calendar right while the state's reviewing it, I think the standard bond would be 5,000. If so, that's what we would be asking for.
E pendant ke avokat l'Etat pou revoa ka, mwen kwa ke kosyon standard la, se $5,000, e se sa nou pral mande.
The A form refers to gang.
Sorry?
The arrest form states that the defendant told the victim, I have a lot of money and I'm part of a gang and have a gun.
Fom arrestasyon di konsa ke moun akuse a di viktim nan, mwen gon paket l'ajan e mwen fè pati don gang.
What is the standard bond amount?
5,000.
Ki kosyon standard la, 5,000.
Your Honor, due to the statements made by the defendant and the nature of this crime, we would ask for the standard bond amount here, Your Honor.
Okay.
Juge, vu krim nan, nature krim nan, avokat l'Etat yo pral mande pou kosyon standard la, juge.
Okay, I mean, I'll order the standard bond, but I want to say I did comment
Ma bal caution standard là, mais faut me dire que m'ta vle faire commentaire ça.
about the statements, but the more I read on the arrest form, doesn't seem like typical conversation that one might have.
Vu déclaration yo, mais plus m'a pli forme arrestation, moi que c'est pas une conversation normale qu'on moun da gen.
So although that's why I'm giving the standard instead of elevating.
Et c'est pour ça m'a bon caution standard là au lieu de caution qui élevé.
Okay? I'm gonna give it a
Okay.
$5,000 standard bond.
Caution standard là, $5,000.
Yes, Your Honor.
There are two stay away orders.
I'm sorry, Judge.
There are two stay away orders that I will be reading now.
Et gen de l'autre campé loin m'bral di yo pour.
The defendant is prohibited from having any contact with the following named persons:
Accusé a, yo défend accusé a pour gen aucun contact avec moun sa yo que nous pral bon nou yo.
hereinafter the victims Andres Santamaya,
Victime yo, yon a de c'est Andrés Santamaya
and Luis Aguilar,
et Luis Aguilar.
directly or indirectly, in person, in writing, by telephone,
Directement, indirectement, en personne. Voyez message en téléphone,
pager, fax, or through third person.
par beeper, fax ou bien voyez commission par un l'autre monde.
Defendant must stay at least 500 feet away from the victim.
Accusé a gen pou rete au moins 500 pieds de victime nan.
The victim's home, place of employment, and or school at all times.
Kote l rete, kote l travail, et ki la l'école tout temps.
Also, electronic contact, such as emailing, texting,
Et ou pa gen do gen aucun contact électronique avec moun non, pa ka voye email pou li, ou pa ka voye texte pou li.
Facebook messages, or by Twitter is prohibited.
Message Facebook ou bien par Twitter, ou pa gen do faire non plus tout, yo oubli, ou pa gen do.
Thank you very much.
Merci en pile.
Thank you, Judge.
Your Honor, this is the only Creole case.
Corrections? Anybody else need a Creole interpreter?
No, Judge.
All right. Thank you, Ms. Wilson.
Can we go to
Thank
Mr.
you, Judge.
Max Anvergil that we passed?
Yes, we can. This is Mr. Angerville.
This is Mr. Amberville.
Okay, Mr. Angerville, you are here on multiple counts. 2 felony, third-degree felonies, battery on a police officer, and resisting officer with violence to his person. And 2 misdemeanors, first-degree misdemeanor, resisting officer without violence to his person, and a second-degree misdemeanor for disorderly intoxication. You're also out on bond with TAP in a felony case F25 14436. Any probable cause arguments?
Judge, no, I do not have one. We would ask on the Bat Leo that the court set a bond of 2,500 and standard bond on the other count.
They,
Okay, so I'm just gonna go, if you're on, so with the resisting an officer without violence.
there are two resisting officers, one of them with violence, one of them without violence.
Right, so for the resisting officer without violence, the standard bond amount is $150. The defendant was convicted on January 1st, 2024 for resisting officer without violence. He was convicted on June 15th of this year for resisting an officer without violence. He was again convicted on May 28th of this year for resisting an officer without violence. And he was convicted on January 2nd, 2022, or excuse me, a withhold for resisting an officer without violence. He would be asking for a heightened bond amount on the resisting an officer without violence of $500. And the resisting officer with violence.
Without violence, I have here that $500 is the standard bond.
I had it for 100. I had it set. Oh, excuse me. Excuse me. I'm looking at the disorderly intox. So thank you, Your Honor. So without violence, we would be asking for a $1,500 bond. For the resisting officer with violence, as the defendant is now adding violence to his history of resisting officers, we would ask for a heightened bond of $5,000. And for the Bat Leo, which is again a heightened, the defendant is now increasing his behavior and violence towards officers, we would be asking for a $5,000 bond. And for the disorderly intox, standard.
Okay. All right. For the disorderly intox, standard bond, resisting officer without violence, standard bond, resisting officer with violence, standard bond. And the Bat Leo, I'm going to give, instead of $2,500, I'm going to give the $5,000.
Understood, Judge.
Okay. You. Back on page 10, where are we? Daniel Concepcion?
This is Mr. Martinez, I think 31.
Javier Valdez Martinez.
Just
can I get a quick update from corrections on where Mr. Epps is? Where's Mr. Concepcion? Am I missing anybody else?
We have Mr. Epps, Judge, and Mr. Concepcion is a bond out.
Okay, thank you. You have Mr. Epps. All right, I'll call him after this. If he's there, I'll call him after this case. All right. Javier Martinez, you were charged with a third-degree felony for possession of crack cocaine.
He does need the assistance of the interpreter.
Madam Interpreter.
Javier Martinez.
You are charged with the third-degree felony for possession of crack cocaine.
Delito penal en el tercer grado es el que tiene en su contra es tenencia de crack de cocaína.
Judge, I don't have a PC argument. From what I can see, it appears that this is his only local prior. We would ask if the court would be inclined to give him pretrial services.
Parece que este es su único antecedente. Solicitamos que le otorgue fianza gratuita pre-trial.
State,
No objection, Your Honor.
Y ninguna objeción por parte de la Fiscalía.
all right, pretrial services with alternate bond.
2,500.
I was like, whoa, $250. Thank you.
Va a salir gratis con el programa pre-trial, monto alterno de fianza, 2,500.
So that.
Gracias.
Okay, is Mr. Epps here now? Or there? Was Mr. Epps here yesterday? No?
Judge, from my understanding, it fell off the calendar.
Okay. Thank you. All right, Mr. Epps, you're charged with two charges. First degree felony, battery, aggravated battery on a person 65 or older, and a first degree misdemeanor of battery. Any probable cause argument?
Judge, I do not.
Yes.
All right, probable cause found. Just in case, I will always said probable cause found. Anyway, anything on release conditions?
Which review, remember, this is an add-on, so I don't have a file here.
Only prior. We'd be
Okay.
asking for pretrial services.
File. The defendant is,
He was a tourist here?
it's the A form lists him as a resident of Illinois.
Sorry, Judge, about the pretrial services. Standard bond, sorry.
Okay. State standard bond?
No objection, Your Honor.
All right, and standard for first degree felony is what? 10,000? I think that was the option you gave me earlier. Madam Clerk? Sorry, we are on Mr. Epps. Tolovius Jermaine, not Jerome. Sorry. First degree aggravated battery on an older person, 65 or older.
What degree is it?
First degree.
Isn't it 7,500? 1,500.
Most times will state the pre-trial detention on, it's up to you, Your Honor.
There's no pre-trial detention on this? I guess, no argument for that? No motion for that? Understood, so I don't have paperwork. All right,
When he said it, can get it for tomorrow?
And Your Honor, I think that was.
yeah, look, given it's a first degree, and the state doesn't have information. I don't want to set an enormous bond or something like that, so I'll let the division judge handle it tomorrow.
So you're resetting him for.
What's here? Sorry, not division judge. Okay, tomorrow's bond hearing, reset for bond hearing tomorrow.
Judge, is it a PCH?
No, not probable cause determination, it's the pretrial detention issue. It's a first degree felony that usually they seek pretrial detention. And they don't have the information. All right, Manuel Garcia. Is this Manuel Garcia? Fabian Rufin?
He refused, reset for tomorrow.
Okay, Manuel Garcia, I will reset for tomorrow.
Is Fabian Rubin?
No, Fabian Ruffin's there, I think.
Garcia reset.
Mm-hmm. All right, Fabian Ruffin, you are charged with a first-degree felony for trafficking in MDMA and a first-degree felony for I guess selling or having crack cocaine within 1,000 feet of a church or convenience store. Any probable cause arguments?
Judge, I do not.
All right, any argument for release conditions?
Judge, we would just ask if the court could set the bond for, or his total bond for 5,000 and 5,000 each, which is what he can afford. Anything else would be tantamount to no bond for him.
Total of $10,000 state.
Your Honor, the state would be moving for pretrial detention pursuant to 907.041 by the filling out the motion right now.
Because trafficking,
Yeah.
that's the issue. Okay, what is the standard bonds for these anyway? No bond?
Count one, count two, to the 5,000, I mean 15. 15,000.
All right, this would be before which judge? Within 5 days?
Alright.
Okay, this would be before Judge Alfield within the next 5 days. Count one, no bond. Count one, no bond. Count two, $15,000 bond. Okay, and Judge Alfield will address the motion for pretrial detention within 5 days. All right, thank you. So, Mr. Malloy?
Yes, it is, Judge, Mr. Malloy.
You have to stay away from this one?
No, I'm just saying the back of the order.
Oh.
I didn't make it. Crazy.
Sign it.
Yes, Judge, please.
Let's not do double-sided scanning. All right, getting back to this. Tony Malloy, you are charged with a second-degree felony for aggravated battery of a pregnant victim. Any probable cause argument?
Judge, I do not. I don't see that he has any priors listed on this. I don't know if the court would be inclined to either give him pretrial services, if not house arrest level 2, so he can work.
State. We're gonna allow the state's gonna take a moment to review, but in the meantime, I just want to point out this is a I know it's a second-degree battery, but it is concerning that especially it's an 8-month pregnant victim.
The state would be asking for standard bond.
Is there any reason that level 2 is inappropriate to allow him to work and with curfew? I was asking for arguments. Why, if the state has any argument against it? Well, this is a DV, correct?
The A form does not specifically say that they live together, that's what I was inquiring about, if they did live together, obviously the house arrest would be an objection because he'd be said to live in the same house as the victim, would we be objecting to?
No, the house arrest, we won't be allowed to live.
Where would he be staying then?
But he won't be.
Yeah,
He would be staying at his sister's house, not at the residence with the alleged victim.
We would have no objection to him staying on house arrest with his sister then.
okay, level two is allows work groceries with curfew. That work?
Okay.
Okay, so level 2 house arrest. I am going to order a stay away. I'm hesitant to not give a DV stay away here. I mean, this is the allegations in the A form is that it's his baby. He lifted the mattress she was lying on.
And the A form also states that this is a repeat offense, that they had been involved in a physical altercation before, but she was just fearful to contact law enforcement.
Okay, so this is an allegation of his repeat. Okay, so give me a second.
And it was also alleged that the older child witnessed the incident of the defendant striking the mother of his children. The defendant's children, that is.
Where does it say that?
And it does say, I'm sorry, I hadn't read the full A form. It does say that the children all reside in the home with both parents. So
yes, let's just do an DV stay away order.
Him witnessing it is the 5th paragraph from the bottom of the A form during the investigation.
How old is Xavier Malloy? I'm gonna
Probably 6 years old.
okay, I'm moving back on my prior determination that I was going to give house arrest. This is a domestic violence incident on surface. And there's 2 children witnessing the behavior, correct? Is that 2?
Yes.
2 young children witnessing the behavior. 2023, Amaya Malloy, I guess she's very young, but and a Josiah Malloy, who's older, and so 3 children were in the home with both parents. All right. I'm going to issue a stay away order, and I want to order a GPS bracelet. No, am I doing total lockdown? I'm not gonna do house arrest anymore. I'm gonna do bond and a stay away order. She's, okay, how would that work? I'm not,
You do a plus bond, it's called a plus bond, we can do house arrest plus 10,000, 15,000.
Right.
public defender?
I'm trying to sort out what the court is ruling on that. I got stay away order and then
I'm getting options from my staff, not from
Okay.
not from the state. The state's not giving me any input. So I'm just trying to figure out for my staff what I can do. I'm a civil division judge who's now in handling bond hearings. They're familiar with this, so they're trying to explain to me my options of what I can do, given my concerns about the severity of the situation, given the fact that 3 children observed this or in the home together. Those are factors that are associated with lethality.
and I understand what the court is working through. Thank you for explaining. But that's why I was saying if it was going to be house arrest and he would not be living at that place, but he would still be able to have level 2 be able to work so that he can still then support himself and have money to be able to support his children, even if you know, there is a domestic
My,
work stay away.
right, I'm also concerned about the, you know, I don't want them being together. So I'm concerned about that. Okay, so house arrest, level 2.
Have house arrest level 2, which would allow him to work. And he would still have to make a schedule with house arrest. The court can still impose a stay away order to make sure that he's not.
And a GPS bracelet?
If that's what the court.
I can do that all that. Okay, I'm sorry. I'm trying to make sure I protect
No.
I'm trying to protect the defendant or the victim, excuse me. All right, so, all right, so the, house arrest level 2, plus the, stay away order and the GPS bracelet. And that's all. All right, level 2, stay away order, GPS bracelet.
Is that plus bond or alternate bond?
I would ask for alternate bond.
That's plus bond.
Plus how much, Judge?
$7,500 bond. This is one count, right? Yes. So right here, home arrest, house arrest. Level 2. Stay away order. Oh, sorry. Plus $7,500, correct?
Yes.
All right. Stay away. GPS bracelet. All right. The stay away order. Again, and with the GPS bracelet. Mr. Malloy, again, I hope you understand that through all of this, this reflects very serious conduct. I have serious concerns about harm to your family. Do not engage in any criminal activity. Do not use or possess any illegal drugs. Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition. You must immediately surrender any firearms, ammunition, and any concealed weapons permits to the nearest police department and file a receipt with the court. The defendant is prohibited from having any direct or indirect contact with the following person, hereinafter the victim, Brandy Brown, including contact in person, in writing, by telephone, through social media, or any other electronic means, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and or at school at all times. I understand that you live together and you have common children. You may return to the victim's residence one time only within 48 hours of the entry of this order, accompanied by a police officer to retrieve his personal clothing, personal health items, medication, personal and business related paperwork, and work tools. Going to the home or remaining at the home without the police will subject the defendant to arrest. The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim. This order will remain in effect until modified by the court. Thank you. Jeremy Brown,
This is him, Judge.
you're charged with a third-degree felony for possession of cocaine. Any probable cause argument?
Sorry, Judge, I'm stepping on people's feet. No, Judge, I do not have a probable cause argument. He does have considerable priors, but we'd be asking the court, or he's had contact, I should say, not priors. We'd be
For
asking
what?
he's had contact, considerable contact, not necessarily priors. We'd be asking the court for pretrial service.
Okay, hold on. Anybody understood what part of that was? We're still having trouble with the middle part of that sentence.
Sorry, Judge.
The whole courtroom.
Let me try it again. I said, I do not have a probable cause argument. He does have considerable contact with the system. I'm asking for pretrial services. though.
Contact with the system, contact with the system. Okay, state.
Your Honor, we'd be asking for an elevated bond for the defendant as 1, 2, 3, 4, 5, 6, 7 convictions of controlled substances as recently as most recent one is from 2021. This is so the standard bond here is 2,500. You'd be asking for a $5,000 bond here due to the considerable priors and the consistency in these priors as the defendant continues to repeat the same offense.
Okay, I'm gonna order a standard bond of $2,500.
I'm sorry, I didn't hear you.
Standard bond of $2,500. I think both of you are correct with your arguments, but that's why I'm not going to depart the standard. Brian Olivero has 2 cases today. Does he need an interpreter?
No, he does not, sorry.
Thank you, Your Honor.
Okay, this is the defendant who was with Miss Cherry, the co-defendant.
Yes, it is.
Mr. Cherry? I don't remember.
Miss Cherry.
Okay, and the second case is a 3rd-degree grand theft. Any
Judge, I do
probable
not-
cause arguments?
I do not. Hold on one second. Judge, no, I do not. I would, sorry, asking if the court would consider pretrial services.
How long has this gentleman been in Miami?
His whole life, Judge?
So he's from 71 to present, he's been in Miami, Florida, or Hallandale, Florida?
Yes, Judge. And my understanding is that the address on the A form is correct.
Okay, so address in the A form is correct. Does he have any priors to state?
Looking at your low, it's here for grand theft of the vehicle and cocaine conviction. Starting with grand theft on convictions, 1, 2, felony grand theft. So 1, 2, 3, 4.
All felony grand
5,
theft.
5 felony grand theft. Then 6 felony grand theft. And then on burglary alone, Your Honor, we've got 1, 2 more burglaries, and then on cocaine possession, Your Honor, we've got 1, 2, 3. 3 more felony cocaine possession, Your Honor. And that's complementing a long list of priors here. The state would be asking for an elevated bond on both.
Elevated bond of what?
5,000 on each.
All right. He's not a flight risk though?
Your Honor, give me a moment, I can look it up, and try and Are the height risk here on it? Have to look further, I don't see anything in regards to failures to appear on traffic, that's that's the only thing I have access to. Due to the severe nature of how often this defendant repeats these offenses, there's a legal basis for the 11.
All right, I'm not gonna elevate, but I'm gonna issue standard bonds in both.
Understood, Judge.
What are the standards in both? $2,500 bond for both cases, for both, sorry. Two separate forms, right, to fill out?
You mean 5,000 on the 6529 and 5,000 on the 1652?
No, for both cases, you're saying, Judge, the ends 28 and 29 each is 2,500, correct?
Yes. Yes. $2,500 each. All right, George Gonzalez.
Yes, Judge.
All right. Mr. Gonzalez, you're charged with of life felony or a felony punishable by life, burglary with assault or battery armed. Second degree felony, aggravated battery with deadly weapon. Third degree felony, assault or aggravated assault with a firearm, and misdemeanor domestic violence violation of injunction. The first count is a no bond count.
I don't have any PC arguments.
Okay, no PC arguments. And there's a motion for pretrial detention that the.
Yes, no, I apologize in advance for the confusing nature of these motions.
All right, these.
Or the having it PRA is.
Obviously, no bond on count one.
That's right, Your Honor. The state would be moving for no bond on count one, and the state is still reviewing on the long count.
Excuse me? Oh, count two is also a no bond. Okay. All right, so we have two life felonies. And particularly bad alleged conduct, just put it lightly. All right, so I'll hear argument, but go ahead, public defender.
Judge, we just request standard bonds on the other ones. I didn't understand the state. Are they filing the pretrial detention motion or they are not?
They are filing the pretrial detention motion. So again, I'm gonna hold for the two counts of life felonies, because we have two counts of life felony, sorry, and then the second degree battery and the third degree felony. Yeah, so count three. So counts 1 and 2 will be no bonds. Count 3 is $7,500. Count 4, $5,000. All right, first degree misdemeanor, domestic violence, violence of injunction. What's the standard first degree misdemeanor? 500. Okay, and this is domestic violence violation of an injunction. Public defender.
Judge, I don't know if it's I think it's 500, but I don't know.
Mm-hmm. Are you arguing for 500?
I am.
State, all right, $500 for the misdemeanor as well. All right, now we got stay away orders, even though there's again currently felony holds, or excuse me, life holds. I don't know if I'm using the right lingo, but you're will be held until the division judge hears the motion for pretrial detention. Who's the division judge? So Judge Altfield will hear the division, the motion for pretrial detention. All right. Stay away order. There you go. I have 2 stay away orders. I'm going to read them once to avoid repetition, but the defendant is prohibited.
Hold on 1 second, Judge.
I can, if he's gone, okay, he's back. All right, 2 stay away orders. The defendant is prohibited from having any contact with the following named persons hereinafter the victims: Jorge Vasquez and initials KJ, who I assume is a minor. Is that correct?
It might not be a minor, they probably just select Marcy, so I'm not sure.
Okay, so yeah, all right, KJ. Directly or indirectly, in person, in writing, by telephone, pager, fax, or through third persons. Defendant must stay at least 500 feet away from the victim's home, place of employment, and/or school at all times. Also, electronic contacts such as emailing, texting, Facebook Messenger, by Twitter is prohibited. This order will last until the judge alters it. Thank you. This is Jefferson Jackson?
It is.
All right, Mr. Jackson, I think yesterday you refused. This will reset for today. So here we are today, and you are facing 3 counts. A 3rd-degree felony for resisting officer with violence to his person, 3rd-degree felony for battery on a police officer, and a 1st-degree misdemeanor for resisting officer without violence to his person. Any probable cause argument?
No, Judge.
Okay. PC. Found. All right. Any argument on the release conditions?
Oh, sorry, Judge. Judge, the court would be inclined to give him TAP. He is homeless. He does have prior contact, but it's minimal, at least as far as I can see on my sheet.
Sorry. Oh, sorry. I apologize. I'm looking for something else. I would have been inclined to do that, but sorry. I would have been inclined to do that, given his status as a homeless person, but the arrest form mentions that he was brawling with the police officer. He attempted to grab the deputy's handgun. So I'm not sure. He no longer poses a threat to the community. So I won't order TAP, but I'll hear argument on any additional discussion on release conditions.
Judge, I don't know if the court, he's homeless, so I know that he cannot do pretrial services. We would ask that you lower his bond for count 1 to 500, count 2, 2,500, and then leave count 3 to the 500.
State.
The state would object and just ask for the standard bond amount here.
You're asking for 1 to be reduced?
I am.
All right. I reduce one to $1,500. Count two, I can set it, what's the, it's Bat Leo, correct? What is that? Right, well, we can lower it to $2,500. And again, this is because of affordability. I don't know if he'll afford it at this point either, but, he is homeless. Count three is $500. So I'll give it $1.
Thank you, Judge.
Thank you. Did I read Troy Malloy? Didn't know if I read Troy Malloy. Yeah. Or was that the one that, no, that was the 20 Malloy. That's the one I made it a domestic violence.
Yeah, Brew Amigos.
Thank you. All right, is this Angel Ortega Orihuela?
No, this is number 48, Drake Davis.
Well, everybody else in between, anything, what's going on with them?
I do not know.
All right. Drake Davis. Okay, you are charged with 3 different charges. I believe I see you. You were reset for tomorrow, this morning on the misdemeanors. So I'm here for the 3rd-degree felony cocaine possession.
He wasn't on your calendar this morning.
Oh, he wasn't? Why don't I have him reset for A4?
I think it's to address a misdemeanor tomorrow. I think it's the
NBC says reset 8/4/2025. My initials and says NBC. So I'm assuming maybe, I don't know.
Alexander Davis?
This is Drake Davis? Drake Alexander Davis?
It is.
Okay. Any probable cause argument?
I do not. We'd have to respond.
Were these conditions? Standard?
Yes, Judge.
All right, what are the standards for 3rd-degree felony?
500 and 500.
State?
Yes, Your Honor.
You got a stay away order? Are you objecting to the standards?
Your Honor.
We're asking to elevate, not objecting?
The defense is just asking for standard bond amounts? No objection.
Okay, standard bond amounts. 2,500, 500 and 500?
Yeah.
My memory's not as good as it used to be. That was 5 seconds ago. All right, and a stay away order. The defendant is ordered to stay away from the following address: 8116 Biscayne Boulevard, Miami, Florida. That is a McDonald's, and this will last until the case is closed or modified by the court.
Ashley, can you call corrections?
One's being asked to call corrections. Well, what do you need? Sorry.
40, we did Jefferson Jack, which was count 150 or 1,500?
1,500, I think I lowered it from 2,500 by 1,000.
Yeah. Ashley, can you check please in the system? You put 150.
Fixed?
Go ahead, Your Honor.
All right, good. I don't know. I don't know what I'm allowed to do. All right, let's go. Next person. Is this? I don't know who this is. Because we called somebody else, Mr.
They're
Davis.
asking to take Mr. number 49, Mr. Moreland, Edwin Moreland.
He's the last one.
No, he's not the last one, Judge, but
I have a few that are.
he's number 49, Edwin Moreland.
Okay, he was ROR'd on a felony. That's what I have here, felony 25, 12813. All right, and so he's committed a crime while on ROR. So
I
he's now
have
been,
felony bond F 25 12813.
say it again, sorry.
He's out on felony bond F 25 12813.
So it's a felony bond, not an ROR.
Yeah, he's out on his own, he was out on his own comments, and then we picked up a new case.
Okay. Right, so
Judge, I don't have a PC argument. We'd ask that, I don't know if the court is holding him on the 12813, we would ask for a dollar bond on this case.
yeah, felony hold, state.
Here, after the standard money.
All right, $7,500 bond. And that's obviously because he's been picked up on a charge.
Oh, and Your Honor, we also have a statement.
Stay away order as well. The felony hold, $7,500 bond on the count one, or the only count. Probable cause found, no argument on it. The defendant is ordered to stay away from the following address area: Circle K, 970 West Palm Drive, Florida City, 33034. That order will remain in effect until case is closed or modified by the court. Right. Thank you. I assume it's Angel Ortiorgua or Orihuela. Do we need a interpreter?
We do. Yes,
Okay.
Judge.
Interpreter present.
Okay, so Angel Ortega Orihuela.
Ángel Ortega Orihuela, yo le voy a servir de intérprete, caballero.
You are charged with a second-degree felony, aggravated battery with a deadly weapon.
Tiene un delito penal en el segundo grado, agresión corporal con agravantes con uso de arma mortífera.
Any probable cause argument?
¿Alguien desea argumentar respecto a la base legal?
No, hold on, that's me.
Le están preguntando a los abogados, caballero.
Judge, no, I do not. I do not see that he has any priors. We would be asking for pretrial release.
La defensa indica que en base a que no tiene antecedentes penales, solicita la fianza gratuita, pretrial.
Doesn't qualify, given the nature of the crime, I believe. That is why. Okay.
Califica por más que la acusación es de esta índole.
Angel. Number 42.
And along with 7,500.
State.
Yes.
Are you ready?
I'm ready. I'm almost ready, Your Honor. One from here. Yeah, the state would be asking just for the standard bond here, and we have a stay away order.
La fiscalía solicita únicamente monto estándar de fianza y orden de alejamiento.
Is this a DV? Stay away? Okay.
Originally wasn't.
Parece que el caso es de violencia intrafamiliar. It is, Your Honor, or it's not?
This is a DV stay away. Yes.
La orden judicial es de carácter violencia intrafamiliar en su calidad de orden de alejamiento.
All right, so public defender, the arrest form has allegations that he put a knife against the victim's stomach and then threatened to grab a bigger knife to kill her.
Las alegaciones del informe de arresto indican que agarró un cuchillo y lo puso contra el estómago de la víctima, amenazando con traer un cuchillo aún más grande y matarle.
Is there any other? Does he live
Ajá.
anywhere else? Does he have a place to go?
¿Tiene algún sitio donde ir? ¿Tiene un lugar aparte para vivir, señor?
He
Tiene-
says, yeah.
He's nodding, pero tiene que hablar, señor.
Sí, claro, tengo a dónde vivir.
Yes, of course, I've got a place to live.
No, no.
Con mi hermana.
With my sister.
Okay, so again, the allegations are very, very serious. State, what are you seeking here? Just standard, or what are you seeking?
Nuevamente
Stay away order.
son bastante graves. ¿Qué es lo que me solicita la fiscalía? I'm sorry, State, could you repeat for the interpreter, please?
For Angel, Your Honor, we are asking for certainly the stay away order.
Please into the microphone.
Thank you, Your Honor. And due to the nature of the crime and the facts within the four corners of this complaint here of this A form, Your Honor, we would be asking for an elevated bond here. An elevated bond of $10,000 here.
Su señoría, obviamente solicitamos la orden judicial de alejamiento, dada la índole de estas acusaciones, y según los parámetros del informe de arresto, queremos solicitar monto elevado de fianza en la cantidad de $10,000.
Public defender.
¿La defensoría?
Judge, I have nothing further to add.
Nada que agregar por parte de la defensa.
All right. I'm not gonna raise the bond, but I will order house arrest, stay away order, house arrest plus bond, house arrest level 2, plus bond of the standard bond, which is I think $2,500. Is that right?
No, Judge, it's 7,000.
$7,500 standard bond, and then I will also order GPS bracelet.
Bien, señor, el señor juez le impone la orden judicial de alejamiento, monto de fianza $7,500, arresto domiciliario, nivel 2, monto de fianza y monitor satelital GPS en el tobillo.
That plus or off again?
Plus. And GPS bracelet.
Además, el monitor satelital GPS.
All right. The stay away order. Again, these are just allegations, but they're very serious.
En cuanto a la orden de alejamiento, señor, yo sé que se trata solo de alegaciones, pero realmente son de carácter grave.
Do not engage in any criminal activity.
Puede participar de actividades ilícitas.
Do not use or possess any illegal drugs.
No puede consumir ni estar en tenencia de sustancias ilícitas.
Do not use, purchase, possess, or carry a firearm, gun, weapon, or ammunition.
Puede utilizar, comprar, ni portar arma blanca, arma de fuego, ni municiones.
You must immediately surrender any firearms, ammunition, and any concealed weapons permits
Cualquier arma de fuego, municiones o permiso para portar arma oculta que tenga usted,
to the nearest police department
tiene que entregar al departamento de policía más cercano,
and file a receipt with the court.
presentando recibo y sometiéndolo aquí al tribunal.
The defendant is prohibited from having any direct or indirect contact with the victim.
Le queda prohibido al acusado tener contacto con la víctima de manera directa ni indirecta.
Which appears to be Estela Jarquin,
Parece que su nombre es Estela Jarquín,
including contact in person, in writing, by telephone, through social media, or any other electronic means.
Esto incluye el contacto en persona, por escrito, por teléfono, en las redes sociales y tampoco con el uso de ningún dispositivo electrónico,
or through third persons.
ni tampoco a través de terceros.
The defendant must stay at least 500 feet away from the victim's home, place of employment, and or school at all times.
El acusado tiene que conservar la distancia mínima de 500 pies de la persona de la víctima, su hogar, su lugar de estudio y o empleo en todo momento.
I understand that the victim and defendant live together.
Entiendo que la víctima y el acusado viven en conjunto. ¿Conviven, señor?
Sí, sí, convivimos.
Yes, we live together.
The defendant may return to the victim's residence one time only within 48 hours of the entry of this order.
El acusado puede regresar en una sola ocasión a la vivienda en común dentro del plazo de 48 horas de la emisión de esta orden.
Accompanied by a police officer
Debe contar con escolta policial
to retrieve his personal clothing, personal health items, medication,
Esto es únicamente con fines de obtener su ropa personal, sus artículos de cuidado para la salud, medicamentos,
personal and business related paperwork, and work tools.
documentación personal laboral, incluyendo herramientas laborales.
Going to the home or remaining at the home without the police will subject the defendant to arrest.
Si acude al hogar o permanece al hogar sin la presencia de la policía, le deja sujeto al acusado a nuevo arresto.
The police officer shall request all keys and garage door openers to the home from the defendant and turn them over to the victim.
El agente policial va a solicitar toda llave o artículo para ingresar a la vivienda a que se lo entregue a la policía para la policía entregarle a la víctima.
This order will remain in effect until modified or terminated by the court.
Esta orden judicial sigue en vigor y efecto, sino hasta que se modifique o la corte la anule.
And a violation of this order may be a first-degree misdemeanor, which carries a maximum punishment upon conviction.
Quebrantamiento de esta orden judicial representa un delito menor en el primer grado y en caso que lo condenaran,
Of 1 year in jail and a fine of $1,000.
tendría que cumplir con 1 año de cárcel y $1,000 de multa.
Or may subject the defendant to criminal contempt of court charges and or result in revocation of bond or pretrial release.
Puede resultar también en encarar un proceso donde le declaren en desacato ante el tribunal, también a que se le revoque la fianza o, Your Honor, the interpreter missed the third one, I'm sorry. Something with the bond and...
Revocation of bond or pretrial release.
Oh, thank you, Your Honor. Puede que se le revoque la fianza o que se anulen los términos de su liberación.
Thank you.
Gracias.
It's Mr. Montoya Guzman, and he's also going to need the services of the interpreter.
Señor Montoya Guzmán, yo le voy a servir de intérprete.
Montano Guzmán.
Pablo Guzmán.
Montano Guzmán, sí.
Sorry, my fault.
Lo siento.
Bien, disculpe.
All right, Mr. Montano Guzman, you are being charged with a third-degree felony for possession of crack.
Señor Montano Guzmán tiene una acusación penal en el 3er grado. La acusación es estar en tenencia de crack.
2 first-degree misdemeanors, 1 for possession of drug paraphernalia with intent to use.
Tiene 2 delitos menores en el 1er grado, uno de ellos cargo de estar en tenencia de instrumentos para el consumo de drogas.
And resisting officer without violence to his person.
Y resistirse al agente policial sin actos violentos.
Any PC argument?
Argumentos respecto a la base legal, escuchemos.
I don't have any
Yeah,
PCR.
immigration hold. I'm sorry.
Orden de detención por parte de la entidad migratoria, nos avisa el personal de la cárcel. La abogada de la Defensoría Pública no tiene argumento respecto al fundamento legal.
Judge, I did not have any
Perdón, como dijo, ¿me podría repetir que?
Please repeat. May the interpreter repeat, Your Honor.
Tengo detención de migración.
I'm detained by immigration.
You have an immigration hold.
Hay orden de detención por parte de la entidad migratoria.
Ah, entonces me van a deportar a mi país, ¿sí?
So they're going to deport me to my country, right?
Ah, okay, no problem. Yeah.
Judge, I do not have a PC argument. If the court wants to give standard bond.
No hay ningún argumento de la Defensoría Pública en cuanto a la base legal. Sugiere el monto estándar de fianza.
All right, what are standard bonds? State any argument about standards, immigration hold?
No, but.
¿Algún argumento, algo a comentar respecto a la orden de detención migratoria o los montos de fianza?
Standards is 25, 500, and 500.
Los montos estándar serían 2.500, 500 más 500.
All right, standard bonds for all three, so $2,500, $500, and $500.
Bien, monto estándar de fianza en cada uno de los tres cargos, 2.500, 500 más 500.
Thank you.
Gracias.
Is this Walter Leva Rojas or Howard Foreman?
Howard Foreman.
Rojas put the bond out.
Rojas is a bond out, okay. Mr. Foreman, you've been charged with third-degree felony of possession of cocaine around 3 grams or more than 3 grams.
I can, Lord, mañana.
He just told you that you were charged with possession.
Yes.
And first-degree misdemeanor for possession of cannabis. Any probable cause argument?
No, Judge, but I do not have one. I'm looking at his priors. I see one prior contact, which was no plus. We'd be acting for pretrial services. He's indicated to me that his address on the A form is correct.
Date?
No objection, Your Honor, just asking for an alternate bond, this is heading out on both charges.
Okay, so what is it, pretrial services you asked for? Sorry?
Yes, Judge, and the alternate bond can be the standard bond.
All right, pretrial services and the alternate bond.
I believe it's 2,500.
500.
Yes, okay, so $2,500 as the alternate for count 1, $500 as the alternate for count 2. Thank you.
I'm curious. I just want to find that.
All right, Jorge Bergoya is next.
He refused, reset for tomorrow.
Which one was that?
Jose Bergoya. All right. All right, final person, Jean Marseille Perez Garcia.
Which number is that one, Judge?
This is page 15.
Bond out.
Bond out. Okay, I don't have any further documents in front of me, so is there anybody else missing, or are we done for felony bond hearings?
I believe we're done.
Thank you.
You have Michael who? Michael Miller. Do we have Michael Miller anywhere?
Michael Miller is, we did him already, Judge. He was at Metro West. That was one of the first ones that we called out of turn. It was NBC, but I think they set the bond.
Okay. Thank you very much. That concludes the felony bond hearings. Everyone have a good night, and I apologize for the amount of time it took. Hopefully everybody gets home safe. Thank you.
Nice to meet you, Your Honor.
Nice to meet you as well. Thank you.
Thank you very much for your patience.
Thank you. Thank you.
Recording stopped.